Dzień dobry Państwu. Chciałbym wszystkich serdecznie
Ladies and gentlemen, it is my pleasure to welcome you on the second day of this international conference devoted to the theme of worker and employer. Before we move on to the first plenary panel, I would like first to thank and congratulate the organizers for this very professional preparation of this conference. And I praise its excellent, very high technical level. We're here in Rzeszow on the spot, and you can trust my word. Those who are online with us, this conference has been perfectly prepared, and we thank you so much for the yesterday's gala dinner and gala evening summarizing the first day of the conference. It is my pleasure to welcome the speakers of the first panel. The plenary panel will be devoted to the the concept of employee and employer under international and European labor law. I would like to thank the organizers for making me the moderator of this panel. So the concept of employee and employer under international and European labor law is very important. That is the foundation and the key for today's conference and for its second day. Well, the concepts clearly show that the definitions of an employee and employer are not identical. We have different definitions under international and European law, and I think the broadest interpretation is offered under the UN law that applies to the labor law, and we should consider the implication of these laws for national legal orders, and that is our task for today. We have 6 speakers in this panel, and each speaker has been given a time slot of 15 minutes, and we strongly request that you adhere to your time frame. Then we have online participants, online audience. So without further ado, it is my pleasure to invite our first speaker. So the keynote speech will be given by Professor Emanuele Menegatti from the University of Bologna, Italy. Professor, the floor is yours.
So, thank you very much, Professor Giurai, for your introduction, for giving me the floor. And let me join in congratulations to the organizer of the conference, because it was really amazing. I connected also yesterday, and I was impressed by the organization and all the level of the presentation. In the meantime, I'm trying to share the screen, but it says that the organizer has disabled the sharing of my screen. I don't know if it can be empowered. Okay, now it seems working. Okay, I try to open my presentation. Okay, I hope you can see it because I've lost the, sorry. Okay, so if you can see the presentation, I can, okay, now probably. Okay, found it. Thank you. Sorry for, it's always tricky, these technical details. So let's jump into the presentation. As a keynote speech, and it's a really honor for me, of course, to be entrusted of the keynote speech. I'll try to give, provide a general framework pointing out the evolution of the concept of worker in EU law in order to demonstrate how the European Court of Justice and also EU legislations has managed to take some employment protection and social security beyond the employment contract in order to include those self-employed that can be considered vulnerable workers from several points of view. And in presenting the evolution of the of EU law on the concept of workers, so on the definition of the scope of application of many EU employment protection, we need to start with the initial, let me say, minimalist approach of the European Court of Justice, which differentiated between the concept of workers for the purpose of free circulation within the internal single market and the concept of worker for the purpose of labor law directives. As for free movement of workers, since the beginning, the European Court of Justice put forward a single concept, single EU concept, a community with a community meaning. Otherwise, member states could have narrowed the definition of worker in order to prevent the free circulation of workers from other countries. And the concept of worker for free circulation purposes was based on the leading Lori Bloom case. I'm going on it in a while. On the other side, for labor law directives, we had the so-called Denmos approach, so dating back to the Denmos case, in which the European Court of Justice said, well, the transfer of undertaking directives, that was the directive at stake, is referring the scope of application to those that are considered employees under national laws. Therefore, we should seek only for a partial harmonization. So the substantial rules are the same, but the scope of application of these rules depends on the national definition of employees. Underlying this distinction, there was a clear, let me say, rationale. The European Court of Justice was concerned with supporting the creation of the single market. And so free movement was really important to that purpose. Social policies, the European social policy at that time was just in the background. So it doesn't matter if labor law directives had only this kind of partial harmonization. As for the concept of worker, well, Lori Bloom and let's say the following jurisprudence of the European Court of Justice pointed out three characteristics. A worker is a person who works under the direction in return of which he receives a remuneration and who is engaged in an effective and genuine activity. I'm not going into much detail, but the point is direction, which is, as we know, the main distinctive features between an employee and a self-employed in national law, was never really considered by the Court of Justice for free movement of workers' purpose. Because, self-employed can circulate as well as employees, taking advantage of the freedom to provide services or the right of establishment. So it was not really important to distinguish between an employee and self-employed. What was important was the distinction between active citizens and non-active citizens for free movement purpose. And the engagement in effective and genuine activities was the relevant point. And the court has been very generous on this point, excluding from effective and genuine activities only situations where work was just marginal to the overall situation, like, for example, in betray, people engage in rehab programs. Then, starting from this, the Laurie Bloom approach, the European Court of Justice, especially in the new millennium, made the field of application of the EU concept of worker broader and broader, and also the court expanded the concept of worker by, let's say, a redefinition of it on a case-by-case basis. So if we quickly look at the evolution of case law on the concept of worker and the field of application of this concept, starting from free movement, the Court of Justice then moved to pay equality between men and women. And interestingly, in Alumni, on-call lecturers were considered as worker for the purpose of the right to pay equality. Even though direction was not really clear, there was just a kind of organization by the client of the work of on-call lecturers. So they just set like an organizational framework, like the time and the place of work. And also the on-call casual nature of the work was given no relevance for the purpose of the inclusion in the concept of workers. So they were workers despite the casual nature of the employment relationship. In Danosa, for example, this is very interestingly, the case dealt with the sole member of a capital company's board of directors, which is, let me say, a worker that in most EU legislation, national legislation, is not considered as an employee, is definitely a self-employed. However, here the Court of Justice, for the purpose of the application, the recognition of the maternity leave, said that she could be considered as a worker because, again, there was some kind of coordination between the capital company's sole member, CEO in this case, and the company. And so coordination was enough to say that she was a worker for EU law purposes. Let me move to Directive on Collective Redundancy. Again, the member of the board of directors of a capital company in Balkaya was considered a worker. Coordination was enough. And then the famous FMV constant for the purpose of application of recognition of collective bargaining as an exception to antitrust law. Here, self-employed musicians could be recognized as worker if they can be considered as full self-employed. And full self-employed, according to the definition, were there with a kind of functional integration in someone else's business and an operational dependence from this business. So we have got this expansion of the concept, and at the end of the day, we can say that the EU concept of worker is much broader than the traditional concept of employee in member states, because direction is replaced by coordination, and so it's easier to be met by workers when they should be classified. And also the casual on-demand nature of the work bears no relevance for EU law. Yodel was said something different, actually, a very controversial case. Let me mention it quickly. briefly. In Yodel, we had a parcel delivery courier engaged in a typical gig economy arrangement. And in that case, the Court of Justice excluded it from the concept of worker because of the possibility he had to refuse assignments. That was considered too much independence to be included in the concept of worker. So basically, is a kind of setback from the jurisprudence recognizing workers no matter if they were casually or on demand engaged. However, I think this was just a bump in the road for the Court of Justice. And so basically, I mean, the assumption, the concept I provided, I think it still remains the main concept endorsed by the European Court of Justice. So let me say, at the end of the day, we can say that a worker for EU law purposes, not all EU law purposes, but for some employment directives, I will go on this later, is someone engaged in effective and genuine activities who is functionally integrated in the business cycle of the client, and he is operationally dependent from this business cycle, even if he is or she is casually engaged. So basically, we can say that all self-employed in national laws who can be considered as dependent contractors or even economically dependent contractors, they are included in the concept of workers put forward by the European Court of Justice. Another important step in the evolution of the jurisprudence of the Court of Justice is Begrensbrat der Ruhrlandklinik, a German case dealing with temporary agency work directive. This is interesting because so far the Court of Justice endorsed the single EU concept of worker for labor law directives or labor rights, not referring to the national concept of employees. So it was easier for the Court of Justice to say, well, in this case, we need to apply a common EU concept of work. In the case of temporary agency work, the directive includes a clear referral to the national concept of worker. So the directive applies to those that are workers under national employment law. However, the Court of Justice said something really interesting. The Court of Justice said that by referring to the national concept of worker, basically, it doesn't mean that EU law has given up completely to the power of establishing the scope of application of its directives. Otherwise, narrow definitions put forward by member states could jeopardize the effectiveness, the so-called effet utile of the directive. So again, this means that a EU concept of worker can be considered also for those directives that are referring to member states, the definition of employment. This is potentially true for all labor law directives. Again, we have recently a kind of setback in the case Correira Moreira, where the Court of Justice, for the referring to the transfer of undertaking directive, said, well, it's for member states to provide a definition of employee. But then the court, again, in the same case, went on saying that in the case at stake, even though the Court of Justice cannot interpret national law, the court said, well, in this case, the relationship at stake is clearly an employment relationship. The case was referring to a contract for a position of trust as head of human resources unit, so it was a kind of manager. And the court just said, well, in my opinion, this is an employee. So again, in matter of fact, a EU concept of worker prevailed over a national concept of worker. Let's move to labor legislation, and then I jump to conclusion. Labor legislation, recent labor legislation, interestingly decided I'm referring to the directive on transparent and predictable working conditions and that on work-life balance. These two directives were approved in the very same day. And as for the scope of application of this directive, the Commission original proposal was based on the concept of workers developed by the European Court of Justice. So we have this continuity between the jurisprudence of the Court of Justice and the new legislation. So the Commission said we should base the scope on the concept of worker provided by the Court of Justice. But then the Council said, no, you're joking. We are moving back to a traditional referral to the national concept of employee. Then the Parliament stepped in and it found a compromise and said, okay, we are using, let's say, a mixed formula. So the directives apply to those that have an employment contract or employment relationship as defined by national law. So we get the referral to national definition, but with consideration to the case law of the Court of Justice. So that was the compromise. And the outcome was a very ambiguous formula. However, I guess that the interpretation of the Court of Justice would basically push the notion of worker towards its own jurisprudence, so towards a broader concept of worker than the national concept of employees, also for these two directives. To conclude, we have still some labor law directives which refers to the national concept of employees, so they have a narrower concept compared to they endorse a narrower concept compared to the EU concept of worker. However, as I highlighted, there is probably an ongoing trend of the European Court of Justice toward the extension of the scope of these directives towards the single concept of worker put forward by the Court of Justice. Then we have other labor rights and labor law directives that are addressed, they are based on the EU concept of workers. So as I said, they can be extended also to those self-employed that are considered like dependent contractors because they have this kind of functional and operational dependence from the client. And we have in the middle these compromise solutions put forward by the directives on transparent, predictable working condition and work-life balance. Interestingly, also the new proposal for adequate wages in the EU is endorsing the same formula. So in this case, we need to wait for the interpretation of the Court of Justice, but I am quite confident that they will move towards the EU single concept of worker as well. So at the end of the day, let me say, and to conclude, the Court of Justice and EU law in general has been able to eventually move past the outmoded traditional dichotomy between employee and self-employed in order to extend some important and also we can say universal rights beyond the employment contract to those that who needs this right, like dependent contractors and vulnerable self-employed in general. So thank you very much for your attentions, and I look forward for the other presentation and the comments, of course.
Dziękujemy bardzo panu profesorowi Menegatti za interesujące wystąpienie i poprosimy kolejnego prelegenta, jak rozumiem w tym samym obszarze tematycznym, pani profesor Maria Salas-Porras z Uniwersytetu w Maladze w Hiszpanii zaprezentuje nam referat dotyczący pojęcia pracownika według kryteriów określonych przez Trybunał Sprawiedliwości Unii Europejskiej. Bardzo prosimy pani profesor.
Thank you, Professor. The floor is yours.
Thank you very much. Yes, let me know, please, first of all, if you can see the PowerPoint presentation. Yeah?
Yes, of course.
Thank you. Thank you very much. So good morning. the first words of this presentation must be addressed obviously to the organization of the international conference. Congratulations, because from this side of the screen, it has been marvelous, well organized, and very nice to follow. And specifically, I would like to thank Professor Agata Rudera-Roosevelt for his kindly invitation to participate in such an interesting conference. It's an honor to have the opportunity of sharing views with expertises in law from all around the world. And having in account that Professor Menegatti has been introducing a lot of concepts, and in order not to rest time to the other speakers who have to use the floor, I would like to go directly to the content of the presentation, which is, let's say, in a simple way, no more and no less than to present an updated version of the new criteria given by the Court of Justice. So it is important to highlight from the very first moments that the role played by the court is an important role, because as Professor Menegatti has been saying, the directive of transparent and predictable working condition has highlighted this role. So as all we know, the political reality, which is the European Union, uses different tools, which is not very normal in, let's say, national systems. So they need the support of the Court of Justice just to keep on moving in the construction of Europe, having in account that Europe, as Monet says in his memoir, is an unfinished integrative will. So what is so important, the role of the court in the construction of the European Union, because it is the European Union helps to build up the different terms that legally are not being constructed, because there is a lack of competency, and it happens in the employment relationship, and it happens in citizens, and it happens in social protection. So Extra and Larry Bloom has been commented, so I'm not going to stop in them, and Yodel and Correia Moreira, although they have been referred also. I would like to highlight that from a point of view, there is an important stress on the element of subordination. And in this way, as Professor Menegatti has been saying, the court has been following the national concept, traditional concept of employee. However, the concept of worker is different one, more wider, more broad one. So the problem in here with Yodel and Correia Moreira is the different elements that from the point of view of the court compound now the element of subordination, which is related with the possibility of perform the service, of to refuse it, the possibility to accept or not different tasks, the possibility to have to provide services with other parties, which is, let's say, not only the one which is the activities has been undertaken. And also in Correia Moreira, the element of subordination has been, let's say, dislocated, such point, which is very difficult to understand if we are facing subordinate employee or not, because in this case, Correia Moreira, she, the worker, has had contract of trust. That means that it is considered by the company something similar as superior body. So it's very debatable, the element of subordination. However, the Court of Justice has been highlighted the importance to maintain or to keep an eye on this element. From the point of view of social protection, as it has been written in the paper, and also I want to present to all of you, is that there is a sort of dislocation also of what we call this principle of contribution. That means that the citizens, if want to have access to the national social protection system, must to contribute by the productive activities to the protection, social protection systems. Why this happened? That this is a new expansion of the idea of worker in relation with this principle of contribution. But because in Technivis Iute, Interola, in the very recent case named Key, which is the last one that you have in the slide, what we face in here is an extraordinary alteration of this principle of contribution, because worker is not only those who are in the market, but workers are also people who are near to the market and that involuntarily have stopped being engaged or being facilitating these productive activities. So Technivis Iute, Tarola and Key are interesting cases. The first one, because it's self-employed women who have to cease in their activity, in their productive activity, but because of the physical obstacles that are produced by the childbirth. So Technivis Iute is considered to be an employer, although he is not actively working. He is temporarily out of the market. Tarola, however, was not temporarily out of the market. The, let's say, punctuality of his activities was the extraordinary point in order to change the meaning of worker, because Tarola was working only 2 weeks in a period of 3 years. So even in this case, which the temporality of the absence of the markets is very debatable, Tarola was considered also a worker. And finally, Key is an extraordinary extension of the concept of worker, because in this case is considered a worker and a very similar situation to a worker, the one in which Key is found, which is a person who never have been a job seeker, never have been in the market. He perceives a sickness leave. And also in these circumstances, it's allowed, because of the interpretation of the court, to have access to the national social protection system. So the last one, which is purely and strictly speaking about this freedom of movement and right to establishment, in this case, GMA, which is the preliminary ruling was related with Article 45, but also with this directive of the right of unions to the rights of circulation of citizens and their families. The important point in this case was that Belgium denies the possibility and the right of residence, because GMA, which is a Greek citizen, is not a job seeker. Even before being a job seeker, the court rules that is a worker, because, and I just only for this possibility of exercising the freedom of movement, right to establishment. So not only and not yet job seeker, not only people who are temporarily out of the markets, and not only people who has a strict employment contract are considered workers from the point of view of the European Court of Justice. So which are the main conclusions from our point of view? We have to think a bit about the very beginning, the starting point of the European Union. Is a politics reality, very old, which has nothing to do with federations and confederations. The European Union depends upon the willingness of the member states to keep on building up, to keep up construction. And the unique tools are the recognized competencies and the rule that is playing the European Court of Justice. The European Court of Justice, the case law, the jurisprudence, it's one of the main pillars of the European Union construction. So what we are facing with this concept of workers at the European Union level is a step forward to the difficult task of keep on construction the European Union. However, we cannot forget that the European Union is an integrative rule. It means the European Union needs what we call materia prima, that means fuel, in order to keep on moving. Citizenship, employment relationships, social protection system are the new fuel for the future of the European Union. What is happening now, it depends on the willingness of member states, but specifically the interpretation of this and the application of these cases that the European Court of Justice has been given us. Just for finalizing, I think that we are facing an Europeization, not only of social protection system, but also of the concept of worker, which is going to be characterized by guaranteeing at least a minimum threshold of protection, not only for the fact of participating in markets, but also for the fact of just being a human being. So that's all. Thank you very much.
Pani profesor Poras za bardzo inspirujące wystąpienie
Very much,
i jednocześnie
Professor
za
Poras, for a
zachowanie
highly
dyscypliny
interesting
czasowej.
presentation. You are very
I
disciplined and you
poprosimy
stick to time limits, so
kolejnego
many thanks for
prelegenta,
that as well.
panią
And the
doktor
next
Katarzynę
speaker
Bombę
is Dr.
z
Katarzyna
Uniwersytetu
Bomba from the
Warmińsko-Mazurskiego w
University of
Olsztynie
Warmia and
o
Mazury in
przedstawienie
Olsztyn,
swojego
and she's
wystąpienia.
going to give us a
Tematem będzie
presentation
zakres
on the
podmiotowy
personal
prawa do
scope of
minimalnego
the right to
wynagrodzenia za
minimum
pracę w
wage in the
świetle
light of
regulacji
international and
międzynarodowych i
European
europejskich.
regulations.
Bardzo proszę,
The
pani
floor
doktor.
is yours.
Good morning, ladies and gentlemen. Let me start by thanking the organizers for inviting me to the panel at this very interesting conference. And I wanted to make sure that you can see the presentation and you can hear me well. So the scope of my presentation is devoted to the personal scope of the right to the minimum wage in the light of international and European regulations. And I'll focus on different forms of earning. So first I will present the UN instruments, then I will move on to the legal regulations in labor law organization, and then I'll refer to the regulations of the Council of Europe and the EU, and I'll focus on the admissibility of applying that subjective scope, and then I'll talk about the minimum wage directive, and I also want to emphasize that this paper is based on my research financed by the National Center of Science. So this subjective scope is based on the minimum remuneration in the light of the UN regulations, and I will refer to the provisions of the Council of Europe on just and decent regulation. First, may you please look at the Article 23, Paragraph 3 of the Universal Declaration of Human Rights. Everyone who works has the right to just and favorable remuneration, ensuring for himself and his family an existing worthy of human dignity and supplemented, if necessary, by other means of protection. So here, the right to decent and fair work conditions is for everyone, but the right to just to favorable remuneration applies just to the employees, where we have the reference to the concept of worker and not to the concept of employee. The International Covenant on the Economic, Social and Cultural Rights analyzes that right to a just and fair concept. And here the term worker should be understood broadly, so that is a person who works for a fee to an entity irrespective of the type of work. However, that term does not apply to independent workers, independent work providers. And here we have a combination of the minimum wage with the wage that allows for living. And the Philadelphia Declaration provides that the minimum wage is that all employed and all in need of such protection have the right to the minimum living wage. Note that the concept of the minimum wage that guarantees the basics of living is still considered. The International Labor Organization considered that as one of the instruments ensuring decent labor, which has been expressed in its declaration of the International Labor Organization for the future of work. And here all workers should enjoy adequate protection in accordance with the agenda for fair work, decent work, that includes adequate minimum wage. Article 1, paragraph 1 of the Covenant of the International Labor Organization apply to the remuneration for work, and that is the Convention 26 and 29 and 131 dated 1970. And the subjective scope of the minimum wage under ILO is gradually extended. Convention 26 applied to all such industries where employees were not adequately represented. Convention 99 applied to the farming sector only, and in the afterwar period in different states, regulations related to the minimum wage, in particular cases could be broader than provided for in the labor regulations, and that corresponded to the international human rights declarations and solutions at the international level. And here ILO started working on the Convention 131, adopted eventually in 1970. According to that Convention 131, all groups of employees that should be covered by should be protected. And here in that regulation 131 there is this term wage earner used, and the ILO identifies this term with the term worker. As a result, the subjective scope of that convention applies to all working for a fee, for a wage, irrespective of the scope of work. And here note again that the Convention 131 is supplemented with the recommendation of 135 that I will quote more extensively. And again, the Convention 131 continues to apply. That is the piece of legislation which refers to the minimum wages introduced by the all International Labor Organization, and there is a reference in the preamble to that in the directive on minimum wages. Moving on to the European law, note the Article 4, paragraph 1 of the European Charter of Workers' Rights, and here we have employees' right to such wage that would guarantee them a decent level of living. And here we have again a reference to the minimum remuneration, to the minimum wage, and it is considered that the right to decent and fair fee or wage applies to all employees, and according to the Commission, such regulation applies to EU functionaries, etc.
Zawodowe. W prawie unijnym chciałabym zwrócić uwagę na projekt dyrektywy w sprawie adekwatnych wynagrodzeń.
On adequate wages, here the directive refers to workers who are in employment or the speaker is speaking too fast and the translator cannot cope with the speed of the speaker. This person should, however, meet some criteria, and these criteria were covered by previous speakers. However, note that the broad scope of the subjective scope of the directive corresponds to the Charter of Fundamental Rights. In here, human rights and decent and fair nature of work should be considered. And then when interpreting the Charter further on, I would like to move on to the differentiation of the subjective rights to the minimum wage. The European law allows for differentiation of that wage. When it's so permitted by regulations, there is this accommodation 135 that adds to that convention 131 because of the geographic criterion as when justified by differences in the level of living. And then there is this draft of the EU. According to the Article 6 of the directive, member states may allow for differentiating the minimum wage for specific groups of employees, but such differentiation should be reduced to the minimum, and it should be non-discriminatory, proportional and objective, spread over time and reasonable. And then, according to the same director, minimum wage is admissible when conditions specified in Article 6 are met. However, then we have only the differentiation of the statutory minimum wage. Then, let me move on to the criteria for differentiating the minimum wage. As I mentioned, the geographic criteria is the only one that arises directly from the regulations of the international labor law, and it is connected to the administrative division of states, and it exists in autonomous regions. According to ILO experts, a reference is often made in three criteria: the criterion of age, the criterion of acquiring qualifications, and the criteria of the operational sector. As for age, note that that cannot be an independent premise for reducing the wage. Application of the age criterion should be justified and proportional, but the reduction of the minimum wage for all persons at a certain age without using an additional criterion like the professional qualifications is not allowed and does not meet these conditions. That we have the next criteria, which is the criterion of acquiring qualifications, and often exists in connection with this age premise, in particular when for underage or minor employees, and that should again be proportional to the full amount of the minimum wage. When an acquisition of qualifications should requires an increase of wage in time, And then we have the next criterion, the operational sector, when it serves the differences in the productivity sector.
Można znaleźć przypadki, kiedy to ustawodawca decyduje o tym.
There are some cases when the legislator decides on using that criterion of on differentiating the wage by sector. To sum up my comments, note that the subjective right to the minimum wage in the international and European law is common, applies to a worker, applies to workers. So I'm referring to both concepts as well to the concept of a job seeker. Therefore, let me add a few words about the subjective scope of the right to minimum wage in Polish law. We have this legislation on minimum wage dated 2002. Initially, that referred to an employee under Article 2, a monthly salary starting from January 1st, 2017. The legislator expanded the subjective scope of the minimum wage to those accepting instructions, contracts, and delivering servicing by introducing the minimum wage. That change that corresponds with trends that we see in other countries. So that is about moving beyond the work relation. And that requires several comments. First, note that there are some exceptions in Article 80 of the Act on Minimum Wage, and according to that regulation, the minimum wage cannot be applied when it is the service provider who decides on the time and place of providing the service, and he is entitled to an agency fee. The minimum hourly wage is based on a temporary method of pay. However, application of non-time-based methods of payment of giving of salary should not be related to transferring risks onto service and contract providers.
Dla osób wykonujących pracę. Także z tej perspektywy
This perspective referral to that negative premise about the minimum wage in Article 8 may arise some doubts. Also, in case of an employee, we deal with a monthly minimum salary when the number of hours of that person in a month is not does not correspond to the number of hours monthly. There should be an additional fee or additional pay that would make that his pay sufficient for decent living. And here we're dealing with the hourly wage with the minimum hourly rate that the person is supposed to work.
w niektórych przypadkach może prowadzić do sytuacji, w której te osoby środki uzyskane z wynagrodzenia
So funds when funds from remuneration are insufficient to meet employees' needs. May you please conclude, because we're running out of time.
Slajd, to już jest ostatni slajd. I to już jest ostatnia kwestia, mianowicie...
Last slide and my last issue, so that is on the differentiation of the subjective scope. So noting since 2017, the legislator also provides for a lower minimum wage for employees in their first year of work. That regulation was abolished from January 1st, 2017, and that was a positive change, and that fits into the trend noticed in other countries. So this regulation should be considered positive. Thank you very much for your attention.
Dokładne. I poprosimy kolejnego prelegenta, panią doktor.
Very much for the presentation. Now it's time for Dr. Eliza Maniewska from the University of Warsaw. Her paper will be entitled The Concepts of Employee and Employer in the Science of Employment Law and Analytical Philosophy. The floor is yours.
Proszę Państwa, bardzo dziękuję za możliwość
Ladies and gentlemen, thank you for giving me an opportunity to deliver a paper during this great conference. Those who are our online participants have to believe me that the atmosphere here on site is even better than you may imagine. So I fully appreciated the organization of the conference. Many thanks to the organizers in terms of the subject matter, of quality, of organization. Everything is perfect. And the subject matter was very well selected, and I'm sure there will be, it will be a great contribution to the science, to the analysis of the labor law and employment law. So many thanks to the organizers once again. If I may, I would like to sit down. I guess it will be easier for me to control my presentation. The topic I've chosen is attempting to bring some order into all these concepts, and in this panel all the speakers to some extent talk about the same issue. Some of them broaden their considerations, adding international context, but both the keynote speaker and keynote lecture and the next lectures focused on EU law. So I'm not going to repeat all the conclusions that have already been presented in previous papers, but my presentation is supposed to bring some order into all these notions, and I want to talk about a certain methodology which is typical for analytical philosophy. Philosophy, the queen of sciences, may be used for such a purpose, to bring some order into other sciences, including the labor law or the science of employment law. The most important thing in every science, and in this context it is even emphasized by analytical philosophy, is to be precise when we talk about all the concepts. Without precise concepts, there is no scientific discourse. So certain obvious things. First, employment law versus diversity of models of performing work, to bring more order. I know it is obvious, but employment law is a category which is broader than labor law. And I should emphasize that, because there are some linguistic entanglements, and I'm going to discuss them later on. So, employment law, as a category broader than labor law, regulates not only relations in the labor law, but also other social relations connected with personal performance of work for remuneration. It is also very obvious that in this broader concept, there are also administrative and legal relations under which paid work is performed, self-employment or civil law contracts, focusing on personal performing of work. And there are also in the Polish law managerial contracts. So it is also part of that category. And the goal of employment law, and basically I guess that's the idea, that's the concept of this conference, and all our considerations and lectures revolve around this topic, is a reflection upon diversity of models of providing work can be translated into defining a scope on indispensable protection of a person performing work. Because again, to bring more order, a person performing work is a broader notion than an employee. So yes, linguistic ambiguities, linguistic entanglements will be mentioned later, and problems with translation, basically, because we have 25 member states. I guess it is more now in the European Union, so more than 25, and how it influences the level of the discourse, because we need to have communication between members of various member states using different languages, so how we can derive from broader context than just our national context. It is also no secret, and it is also a matter, again, bringing some order into our discussions, that one of the determinants of the scope of protection of a worker or person performing work are standards of the European Union law. And now, let me move on to the second item on my agenda, namely analytical philosophy. What does it have to do with labor law? What does it have to do with the concepts of worker, employer, employer? So in our debates, we can see many things touching upon that, but in my paper, I want to emphasize a certain formal aspect of our discussions. So linguistic ambiguities or linguistic entanglements, we could see that also in previous papers, that linguistic entanglements connected with the notions of worker, employee, employer, and employment versus efficiency of translation of standards of supranational law, in this context EU law, and translation of these standards into domestic national legal orders. And what kind of context is set by analytical philosophy here? The key concept is conceptualization of notions. So defining concepts or attributing a meaning to a given concept. That's the pillar of analytical philosophy. Analytical philosophy, for those of you who may not be interested in that very much, is the newest trend in philosophy, the newest part of philosophy created towards the end of the 19th century or at the turn of the 20th century. Now it is a dominant part of philosophy in general, and it is based on 4 pillars. We have analysis of a language, that's the most important thing, that is logic, analysis of real phenomena, which is realism and intersubjectivity. The canon of analytical philosophy is as follows, that we have access to concepts only through a language. So sometimes it happens that language traps, linguistic difficulties, and I will exemplify it in a moment, referring to the topic of our conference, determine the network of concepts, and then they are determining various misunderstandings that may arise. So, in a nutshell, analytical philosophy, of course, I can't describe it within a 15-minute time slot, but analytical philosophy can be boiled down to the following: traditional problems and philosophical disputes which took place in traditional philosophy disappear when we establish precise linguistic rules in which they are described. Because precision in terms of concepts and linguistic precision is the foundation of every science, because it is about adequate description of described phenomena and formulating statements about them. So, the first examples of linguistic entanglements which are relevant from the perspective of legal framework set by the EU law. And now I'm talking about protection of a worker, because we have employment law, as I've said, and it focuses on establishing the scope of protection of a job seeker, of performer of work, of worker, and a worker is a notion broader than employee. So there is a worker, a person performing work, it is from employment law. It is only about work for a fee. It is not about volunteers. It is not about voluntary work. And then employee is limited to the labor law. So in a nutshell, that's also clear and obvious, but every employee is a worker, but not every worker is an employee. And now the problem of translation. Naturally, I'm referring to translations which we have in our Polish legal system. What was mentioned here was differentiation between employee and worker. So our translations into Polish do not reflect this subtlety, this worker versus employee difference. So a person who doesn't know the conceptualization of worker in a case law of the Court of Justice of the European Union will never guess what is the subjective scope of a given directive. Because even if they read the definition of a worker in the Polish translation, this person will never think that it may be a broader notion that every worker simply, in the Polish language, there is no differentiation between worker and employee. So I'm not going to repeat what was said by previous speakers, because they've touched upon some of these issues as well. I just wanted to show these elements that you can see in bold, so translation into Polish. And again, we have Directive 92/85. And there we have a different translation of a notion of a worker. In Polish there is just one word. It is pracownik. It is closer to employee than worker. But it was also emphasized by Madam Professor that in this particular directive, because the previous directive, which was shown in the previous slide, included its own definition, a legal definition of a worker, but if we talk about Directive 92/85, which is about protection of women who are pregnant, who gave birth and are breastfeeding, what is missing is a definition. What is missing is a legal definition. So it was also conceptualization of the concept in the case law by the Court of Justice of the EU. And now let me move back to Polish regulations. And if someone doesn't know Danos decision, will never know that the rights connected with a maternity leave also belong to a person who is not covered by an employment contract. And it is a fundamental issue, because things that have already been decided, and they are binding, they are simply binding, because decisions of the Court of Justice are absolutely binding, and they must be translated into like a hard reflection pertaining to our regulations as to the scope of indispensable protection of workers, people performing work. And then another thing, it is the latest decision by the Court of Justice, July 2021, Grand Chamber, and it was about certain aspects of time of work. And here, in the title of the directive, we do not have the key concepts, and the subjective scope of the directive is, well, I would say, unknown/unknown, because Article 1, paragraph 3 says it applies to all the sectors of activity, both of the public and the private. I read the thesis of the judgment, and for a Polish recipient, for a Polish lawyer, including into the subjective scope, including a soldier here, is highly disputable. Only if we track the whole case law, if you read it as it is issued, as it is announced, if you follow it very closely, you may understand the legal framework. Otherwise, it is not clear at all. I was talking about translation and about linguistic ambiguities, but another kind of linguistic ambiguity I wanted to point out is a definition between it is a difference between a real definition and a nominal definition as perceived by Kazimierz Ajdukiewicz. From my perspective, it is one of the most eminent representatives of Polish analytical philosophy, Kazimierz Ajdukiewicz. In Poland, we've had many great traditions in terms of analytical philosophy, like we had the Lviv mathematicians. We also have philosophers. I would say it is one of the greatest contributions of Polish science to the global science, so we can be proud of it. So why do I mention it? Because it is of greatest importance to understand the difference. A real definition. Formulating a real definition, we want to point at the joint features, joint qualities of objects symbolized by a given word, which differentiate them from other objects. Obviously, it is a very brief explanation. It is just the essence. So when we formulate a real definition, it is a sentence in a logical sense, and if it is so, it can be assessed from the perspective of truth or false, true or false. A nominal definition, it is a totally different approach. We use it because someone may not understand a defined word, and we want this person to understand this word. So we can have like terminological agreement, terminological consent. We say, This means that, and we express the significance by means of words which a given recipient understands. So a nominal definition is not a judgment, it is like a volitional act of will. So it is not subject to assessment from the point of view of true or false. So this linguistic entanglement, linguistic ambiguity, which arises here, what is that? We tend to forget that legal language definitions are mostly real definitions. And that's what we require, that's what we need, whereas normative definitions are nominal definitions. And if we mix these orders, if we can't see this difference, well, it may lead us to serious mistakes. And the postulate now, recognizing the need a postulate, we need to recognize the need to introduce to the normative language of the law of EU a definition, nominal definition of worker and employee using interpretation applied by the Court of Justice of the European Union. So based on conceptualization of these concepts in case law by Court of Justice of the EU, because we know on the basis of the case law how on the basis of the real situation what was decided by the Court of Justice, what situation was recognized as the situation to be protected. For example, a worker understood or interpreted in this direction is a general conceptualization of the concept of worker, but later on we need to say what specifically results from individual decisions of the Court of Justice, because then it becomes a standard, it becomes a norm. Or worker as understood by a single provision of the directive means this and that, because as we have provisions about organization of working time, not all the provisions have to apply to the same factual situations. And as previous speakers have said, eminent speakers before me, the Directive 2019/1152 goes in this direction, but in the original definition it was to be, it was a nominal definition, a hard definition as I call it, but due to political reasons, I guess, it was blurred, and they focused on consideration of the case law of the Court of Justice. If you read the directive and you don't know the case law of the Court of Justice, you will never guess what these special cases refer to, what significance it has for protection and for efficiency of the EU law, especially in a horizontal approach. And I guess I don't need to give you any further explanation. That's all from me. I know I was talking for a bit too long. I do apologize for that. Many thanks for your attention. Thank you very much. It is a highly analytical presentation, Dr. Maniewska. Now let me move on to the next presentation. Now it will be a presentation by Agnieszka Olszewska. She is the representative of the government plenipotentiary for human rights, and she's going to talk about whistleblowing, employer or employee protection. So the floor is yours.
Dziękuję bardzo.
Well, good morning, ladies and gentlemen. My name is Agnieszka Olszewska. I'm a legal counsel. I've been specializing for years in labor law and social insurance. Today, I represent Minister Marcin Warchoł, the plenipotentiary of the government for human rights and the undersecretary at the Ministry of and on his behalf and on my name, in my name, I want to thank you for inviting me here. It's a great honor. I'll be speaking about the relationship between the employer and employee in the context of introducing whistleblowing procedure into Polish law. So this topic is up to date and so much that yesterday it has been registered in the it has been shortlisted for the next parliamentary session. We need to implement the relevant EU directive in December, so the topic is up to date. So we need the theme of the conference is both a worker and an employer. The relationship between them in the labor relation have the nature of equivalent benefits and rights and obligations. So employer have obligation to treat employees in an equal and undiscriminatory nature and way. An employee is obliged to work properly for the employer. So what happens when things go wrong with an employer?
W swoim środowisku pracy z problemami, z prześladowanym.
When employees meet with malpractices, with harassment, with violation of employees' rights at the employer, and when things go even more difficult, when employees notify the mass media, the general public, and the law enforcement agencies, then, according to international law, such person, a whistleblower at work, should enjoy protection against revenge of the employer for disclosing irregularities in the operation of the workplace. Let me just mention several pieces of legislation that guarantee such protection. That is the Covenant of Convention, UN Convention, and then the Convention on Combating Corruption that provides protection of whistleblowers. And then, according to the convention, parties to the convention should introduce necessary measures to secure against potential retaliation against whistleblowers who report on the perpetrator. Then we have ECDE, committing to effective whistleblower protection, where member states are obligated to protect informers. So with that, there is this obligation to protect the whistleblower against disciplinary actions. So that is to protect employees who disclose to competent authorities crime and offenses at workplace. Then other conventions and recommendations from the ILO and documents from the Council of Europe, including the most important European Convention on Human Rights and Basic Freedoms, with this freedom of speech, and the Convention of the Council of Europe on about corruption, 2009. Here, member states signatories are obligated to offer protection against any unauthorized or unjustified actions on the part of employees, and proper protection should involve an obligation to pay compensation to whistleblower for redundancy. There is also resolution of the General Assembly of the UN, the so-called soft law document. In that document, it is noted that in a legal court dispute between an employer and a worker, so the worker is obliged to prove that the whistleblower was not there to notify about irregularities at the workplace, and the Council also awards the whistleblower the right to claim compensation in case of negative financial consequences of whistleblower's action, and such employee should be restored to that person's position until the case is handled fully. And then finally, the EU law on whistleblowers protection, that is specifically Article 11 of the Charter of the Fundamental Rights, and that guarantees freedoms to employees, freedom of expressing views, and the freedom of accepting and expressing views irrespective, without interference of the state bodies. And there are numerous EU directives which refer to the operation of the banking system. They were implemented in Poland with the regulations of the banking law and regulations of the Ministry of Finance. The key piece of legislation when it comes to protection of whistleblowers, that's the Directive 29 by 1937, dated the 23rd of October 2019, on protecting whistleblowers. And that specific date by which the directive should be implemented will elapse soon. The directive ensures the minimum protection of whistleblowers, and it offers the freedom in shaping certain solutions. And as for Polish legislation, well, we see the concept because the draft will be in public consultations very soon. Then the member states have the obligation to agree and introduce on commonly agreed solutions for protection of whistleblowers. There is also this obligation to protect personal data of participants of the proceedings. And there are 3 procedures for abuse. So the whistleblowers are obliged to notify employers through internally, and employers obliged to notify the employer, to give feedback to employer accordingly. In absence of information from employer, whistleblower may notify the relevant external unit about the case, and only when these 2 paths fail and do not work, he may notify the general public. And then such an employee can also refer to special protection he enjoys during the proceedings, and the means of protection include prohibition of laying off such employee, and also prohibition of taking some degrading measures such as lowered performance assessment. And then there is this reversed burden of proof, so that is on the employer to prove that disclosure of prove that the disclosure of evidence was not possible. And here an informer would be any person who obtains such information in the context connected to work. That could be the current or former employee, work candidate, or a person from a company taking part in the procurement proceedings, etc. Answering your question whether under the whistleblowing procedure an employee should be protected, irrespective of their employment type, or let us go back to whistleblowing. So whistleblowing is when the consequence of whistleblower's action leads to a disclosure of some significant irregularities. And there are 4 basic elements of whistleblowing. So, disclosure or significant irregularities in our organization by persons who are inside the organization or in the public zone, in the public sphere. And here the directive specifies that that is about inconsistency with legal regulations, but it's also about the breach of professional ethics or some managerial irregularities or a suspected crime or offense. When it comes to the entities that reported, these are persons who manage or direct an enterprise, or an undertaking, or bodies or institutions that control an entity. That could be also any other entity that could cause disclosure of the irregularities. Irregularities are reported by a person that is inside the organization. The directive defines the whistleblower as a person who is a whistleblower in the context of work, and that context of work, according to the directive, means current or future action related to working in the public or private sector. Well, irrespective of the nature of work, persons may have information on details related to work, and then any threats would be any impeding threat of an action or abandonment of an action at work that may cause unreasonable or unjustified damage to the reporting person, to the whistleblower. And finally, that irregularity must be reported in a public process. So whistleblowing is largely oriented towards protecting public interest, and that is about remaining on a long-term contract to protect the whistleblowers' interest and person. And the case law of according to the Supreme Court, whistleblowing is not the case of utmost care, because the employed and the employer are both obliged to care for the good and work for the benefit of an enterprise, and it cannot give rise to claims of anyone beyond the labor law, and the interest of the employers often related to the protection of public interest. So note that there is this content of the list of employees' obligations. One of them is that obligation, the duty to care about maintaining the rights and standards of the workplace. And the work relation, as it is assumed, should be based on the mutual trust between employee and employer. So the employee is convinced that he may rely on an employee because of they're reliable and good work and performance, and loss of such trust in an employee may be the cause for dissolution of employment relation.
Lojalność w stosunkach zatrudnienia.
Loyalty in professional relations secures deepens trust between employees and employers. So the employee has this obligation to report irregularities noticed in his organization. It may be as well that hasty whistleblowing may breach the loyalty obligation. So there is this instrumental protection of the whistleblower by introducing whistleblowing first within the structure of the employer, providing that the employer, in the sense of the employing undertaking, has some procedures introduced, and care should be taken to avoid excessive irregularities, such as attaching blame on the good name of the persons working for the plant. There is also a risk that whistleblowing could be used for terrorizing employers, so employees should also protect themselves against such charges. So the issue is to keep the right balance of these concepts, and not to cause an accusation about taking false steps. It is very important to have the precise path for escalating reports and notifications on any abuses committed. The whistleblower is not obliged to present evidence proving their case, and it is important to provide the legal framework for such solutions, and also avoid May you please move on to conclusions.
Powinna być jednak zachowana proporcjonalność.
However, proportionality of the sanctions should be maintained, not to scare off whistleblowers. Employers and whistleblowers have also the right to enjoy protection, and such right has been guaranteed in both international law and in Polish constitution. The employer's right to the freedom of speech is not of absolute nature, because it doesn't give the right to provide any information, even if blemishing the reputation of the employee. So employer may restrict the employee's freedom of speech as long as it doesn't contradict the provisions of the labor code. So the freedom of employee cannot be limited only to dissemination of views which are neutral for employer, but also includes such notions which are unfavorable for the employer. So there is this certain allowed criticism, and a particular example of such criticism is disclosure by the employee facts under the whistleblowing procedure, and in the case revised by the Supreme Court in 2013, the court recognized that an employee has the right to criticize the employer as long as that doesn't contradict and doesn't affect proper performance of the employee's obligations at work. So the employee can openly speak about the work arrangements at work. It is important that the criticism is justified and presented in a proper form. It cannot be undermining, it cannot involve only undermining the employer's good name, or slandering employers, and such standards for protecting whistleblowers are consistent. Because of lack of time, I will not be quoting all the case law decisions, so let me just confirm that the introduction of regulations confirming whistleblowing implies both protection of interest of employee and employers. Employees should be protected against retaliation from the employer, against the discrimination in access to professional development options, and the employer should also report doubts or report questions to avoid damages and to avoid having his reputation tarnished.
Thank you, and there is one more paper. Now it's time for Dr. Agata Ludera-Ruschel from the University of Rzeszów. She is a representative of organizers, or the main organizer of the conference, and she will talk about the EU concept of worker and its potential for the protection of workers. The floor is yours.
Czy ja mogę z tego miejsca? Tak, to super. Dziękuję bardzo, panie profesorze. Otóż, proszę państwa, żeby nie powielać też tego, co zostało do tej pory powiedziane, szczególnie.
Thank you very much. I don't want to repeat the messages which were delivered by previous speakers, like Professor Menegatti or Professor Salas Porras. So I'm just thinking about directions of case law of the Court of Justice, whether on the basis of these directions we can have some predictions about the possibility to have a definition of a worker at the level of the EU. A definition of worker on the grounds of the European Union can be considered in two dimensions, and they are interrelated. There is a social dimension, and we don't have any doubts as to this dimension. And if this definition is decisive for applying minimum standards of protection resulting from EU directives and contributes to implementation of social goals of the EU law in a uniform way in all member states and improves standard of protection in EU member states, there is also the other dimension, the economic ones, when it prevents disturbing competition between member states in the single market, and then when we leave the possibility of modification of this definition to member states in their state or national legislations, which allows to avoid the obligations resulting from minimum standards of protection, will be treated as a source of competitive advantage for a member state. This practice is called the social dumping or manifestation of social dumping, and is perceived as detrimental to the single market based on the principles of competition. And it is also a threat for efficiency of EU law in its social dimension, because it leads to lowering standards of protection. These arguments of economic nature were original justifications for creating a definition of worker by the Court of Justice of the European Union in the case Lowry-Brum. But, as I've mentioned, we cannot doubt as to the social dimension of the definition. What is the expression of that? Application of the definition of worker based on Lowry-Brum formula to be applied of socially focused EU directives without its own definitions of a worker, or do not refer to national definitions of member states. I mean directive on protection of maternity, on working hours, or group redundancies. But also, that's another step, limitation of freedoms of member states in shaping their own definitions of a worker, their national legislations for the need of implementation of the directives that refer to their subjective scope, refer us back to the legislation, collective agreements, or the practice of member states. I'm thinking about the directive of temporary work agencies, the directive on part-time jobs, or directive of fixed-time contracts. There is, for example, a decision in O'Brien case where the court referred to efficiency of EU law in implementation of social interest and non-discrimination principle. If we talk about a notion of worker on the grounds of the European Union, we can observe, and it's already been mentioned, we can observe a trend for unification of a definition of worker based on Lowry-Brum justification for the statement that it's possible to structure and to create an autonomous definition of worker is the need to provide a uniform application of the EU law, which is based on a joint interest, joint goal, namely providing comparable standards of protection, minimum working protection measures in member states. And initially there was a freedom of movement for workers and harmonization of domestic laws based on non-discrimination principle, and its integral parts may be a unified definition of worker, has clearly a social dimension. So there is this trend, and we can see it because there is a limitation of freedom of the national legislators to shape national definitions of worker for the needs of implementation of EU directives, which, when we talk about the subjective scope, refer us to legal orders or collective agreements or practices of member states, but also, as Professor Menegatti has mentioned, there is a necessity for the member states to take into account the case law of the Court of Justice about defining criteria of a worker and defining a worker for the needs of implementation of EU directives. And an example here is the directive on balance between private and professional life, directive on transparent and predictable conditions of work, but also recently a draft directive on the right to disconnect. On the other hand, from my perspective, the specifics of the EU legislation on workers' rights may undermine the idea that it will be possible to create a unified definition of a worker. So as I see it, there are some arguments for such doubts. The EU labor law, if we may call it like that, doesn't have a nature of a full field of the law. The subject matter of the regulations at the level of the EU are just some areas connected with workers' rights. Then tools for implementation of this law and execution of this law according to the principle of subsidiarity are the directives which are binding for the member state as to the goal, and the state has a freedom of attaining this goal, the method to attain this goal. Thirdly, there is this obligation sent to the member states of taking into account the case law of Court of Justice in preparing a definition of worker, but in the country legislation, national legislation, for the needs of implementation of EU law, there is a need to have efficiency of EU law, efficiency, not replacing national definitions. Fourthly, a definition of a worker for the needs of the freedom of movement and broadening this definition into other areas of the European labor law refers to theological arguments, namely the need of implementation of goals, which were initially treaty goals, like in the Levy and Laurie Broom, and then implementation of the non-discrimination principle on the basis of EU directives. Fifthly, there are limitations of freedom of member states in shaping their own national definitions for the benefit of implementation of EU directives, based on arguments which are theological. So, and number 6, I guess that's the last argument I may present here, to justify the statement that creating a definition of a worker adjusted to the goal of a given directive may contribute to a better protection of this category of employed who are now out of the scope of protection of the labor law in the other national orders of the law. As Professor Menegatti has mentioned, the Court of Justice is already doing that. So the Court of Justice, or the definition of worker, created in the case law of the Court of Justice of the European Union is inclusive, including various categories of workers who need protection, and it takes into account the goal of a given directive. So here I'd like to make a full stop. So that's my presentation, and I hope that perhaps there is some discussion afterwards, that there are some remarks or questions to the arguments I've just mentioned. Thank you very much for your attention. Thank you.
Dziękujemy pani doktor za takie porządkujące wystąpienie.
Very much. I guess it introduced more order into the concept of work in the context of EU regulations. So I guess it is a very good moment to open our Q&A session. We have like 15 minutes to the end of this session, so I would like to encourage on-site participants, but also online participants sitting in front of their computers to participate in our discussion. Maybe you have some questions. I can see that Professor Florek is raising his hand. Thank you very much. Perhaps, first of all, I would say that I share the opinion of Dr. Ludera Ruschel, because it is precisely this method. But we should also take into account a local aspect. What do I mean by that? Some of the decisions of the Court of Justice were actually connected with local conditions. In a given state, there are some doubts, like a Latvian woman and her benefits and allowances connected with maternity, and the court asks, all right, so member states, all right, sorry, there are some technical difficulties. All right, so let me just say that institutions of the European Union are not very active in the labor law sphere, because at the beginning of the EU law there were consecutive directives with various approaches to that, but starting from this directive on transfer, because that's where it started, we had an attempt to design an EU concept of worker. And this concept of worker would be very helpful, or the definition of worker would be very helpful also in submitting legal questions to the Court of Justice of the European Union, because the Court of Justice would develop EU law. And to some extent it is an individual matter, but sometimes, as for working time of doctors, there were several decisions on that, but sometimes it is of fundamental significance, because then it has great significance, great impact. And the second remark, when we want to bring more order, or when we want to broaden perhaps the concept of employer or worker, employee, employer, we should look at social needs. It is not about perfecting the concept. The concept may be perfect, but there are some social requirements. There is a social need, namely there are new forms of employment, and they should be reflected in EU regulations. To a small extent, well, we would like to bring some order, more order. Well, that's good, but yes, obviously it would be very convenient, because every time we have to present various decisions by the Court of Justice, and we would have a single definition. We don't have that now. There are various verdicts, various court decisions. They were issued in various circumstances, like in Lori Bloom. Sometimes these verdicts, yes, intend to bring more order into the situation, but some decisions are about freedom of movement. They are of different nature. Sometimes they pertain to issues which are more marginal, like how many hours you have to work to be considered an employee. So we don't have this issue here, but I just wanted to comment on that. It was my comment on the paper by Dr. Ruschel, but I'd like to say something about the intentions of Ministry of Justice on whistleblowers. The case of whistleblowers, the issue of whistleblowers, is actually defined in the international regulations. At the Faculty of Law, we had a conference on that, and there was a very cautious paper by Adam Bodnar before he became the ombudsman, but it was really classy, it was high quality, because this complicated issue was discussed in a very insightful way. What is concerning me to some extent are two issues, like labor law. Well, certain things are added to the labor law, like from the side. We had equal treatment, it was developed, our officials went to Brussels, it was discussed in Brussels in an in-depth way, and then it was included in the regulations, and then there was inspiration of the Ministry of Justice that read somewhere in Scandinavia that there is also mobbing. And now, if we juxtapose these two institutions, I would say that 70% of regulations overlap. So we have like double regulations on the same thing, but perhaps I could come to terms to it. All right, it is somewhere in the code, that's not a problem, but the accusation of mobbing, discrimination, sexual harassment, as judges say, is automatically added to cases, and these cases are prolonged. And the result is none, but it is absorbing to an employer, absorbing to the system of justice. So it is my concern that if we develop or broaden or excessively develop this institution of whistleblowing and add such a huge protection to that, and general justification is social interest, well, the notion of social interest is not easily defined. And everyone who would like to have a dispute with an employer will quote, well, social interest. Well, we didn't have any information whether it was consulted with employers, because if the platform to apply these regulations are to be places of work, I guess it needs to be consulted with employers, because it may lead to trials and tribulations in workplaces, which is not necessary, because I would say that the number of cases with a real social interest, I wouldn't say it is a big number. It will be like with non-equal treatment, discrimination cases, where sometimes they were fictitious accusations, because sometimes a person receives a lower salary and they say it is a discrimination. I know a big case like that. It was about a member of the board, and actually it was just petty grievance because I earn less. There were no premises to justify a discrimination case. So these are my concerns and remarks. Thank you very much. And the next participant who would like to participate in Q&A session is Bolesław Ćwierniak from the university in Sosnowiec, the University of Humanitas. We will have a connection with Professor because he's an online participant. Good morning, ladies and gentlemen. Can you hear me? Yes, we can hear you. We can see you, Professor. Thank you very much indeed. So a few remarks. I've been listening to the discussion and I want to say that I agree with Professor Ludwik Florek to a large extent, like too extensive development and adding too many legal tools to whistleblowers, but that's not the essence of my contribution. The majority of today's papers, apart from the paper by Dr. Eliza Maniewska, which I will discuss later as well, because it inspired me greatly. But the majority of papers in this session are about capacity for creating definitions by institutions of the European Union, like by the courts, which could create elements of definition or attempts of defining the concept of worker, understood in various ways. Worker or employee or worker, yes, as it was pointed out, that there are problems with translation between English and Polish. And I guess the same problem may appear in other official languages of the European Union. So the question is, what definitions or what elements of definition are created by the Court of Justice of the European Union while examining individual cases, because it is precedent law, it is case law. So, and here I guess we could have this debate in the context of legal interpretations. This aspect was not emphasized here, but the Court of Justice makes an interpretation of a directive or a regulation, and then there is an idea expressed in the decision by the Court of Justice, which is again the subject of interpretation, doctrinal interpretation, like in our labor law, and then in practical activities of, let's say, a Polish court. A Polish court may refer to that and may follow the principle included in the Court of Justice of the European Union decision. But let me go back to the main topic in my contribution. Or perhaps one more digression. So it is not at the end of the day, it is at the beginning of the day. Now I'm referring to Agnieszka Olszewska. The notion you wanted to discuss and make more specific in draft law, like goodwill, it is typical for general clauses, and its essence is precisely slightly ambiguous, slightly general, so there is still some room for maneuver, for some room for interpretation, for institutions which apply the law, especially courts. So here, this postulate, well, I wouldn't support that. And I don't share your postulate to make it more specific. And I was listening with great attention and a lot of concentration. I listened to Dr. Eliza Maniewska, not only because she praised my presentation yesterday. I was simply interested in the subject matter of her presentation. It is now autumn, but this presentation is like a sign of the spring. Maybe one sign doesn't mean it is beginning of the spring, but we also have a new monograph by Dr. Kowalczyk about collective bargaining and collective agreements with plenty of theoretical concepts. So in science of labor law, we have a shortage of that, namely a broader concept and locating our concepts on the grounds of theory or philosophy. So here, I agree with many theses of Dr. Maniewska, especially when you were talking about problems with more precise notions, more precise definitions, legal language, normative language, translation problems, translation ambiguities, linguistic ambiguities. As our current ministers say, you have to read with understanding. So first, if you want to translate into a different language, you have to understand the text. But obviously, I have a critical remark as well. Because you were right in saying that definitions in a legal language are nominal definitions. And it is designing something. It is designing something. So such definitions may be legal definitions in various legal texts. They are legal and they are also authentic because they are issued by an institution which set up a standard. But I have a doubt as to what you have mentioned, namely that in the language again, here we have different ambiguities in the Polish language, and now I'm quoting an expert. There is differentiation by a Polish expert from the 1920s, because you've mentioned that in one of the languages there are real definitions. So we want to describe features of objects, features of phenomena which appear in reality. But this situation is even more complex, I would say, because we could say the following, that lawyers using a definition in their own language, like a definition of an employee-employer, because that's the subject matter of our conference. So these lawyers think that they build real definitions. They establish some features, some characteristics of objects, phenomena. Very often we define typological notions. Typology, as we know, a type, a name of the type. So these are assumptions which are not precise. Not all the elements must appear to include an object into the definition. There might be various intensity of various attributes. So that is just a general notion that I wanted to touch upon. So very often a lawyer seems to think or believes that it is a real definition. And actually, it is his or her nominal decision. So it is based on a factitious state. Let me call it a natural situation. Unlike legal situation, we have various phrases like legal reality. So very often we talk about legal status. We don't talk about reality in this context perhaps too often, but people think they build a real definition because it is based on some elements of reality. It doesn't mean, however, it will be a real definition, that it will include a description of reality, and it will define features which are relevant to the defined object, phenomenon, and so on and so forth. And such mistakes were made by the greatest experts on the labor law. Let me just quote attempts of creating a definition of features of employment relationship by Tadeusz Zieliński into his textbook. It had several editions. At the beginning, it was a textbook at the University of Silesia, and then it was used throughout Poland. 3 volumes, every lawyer knows it. Professor, I'm afraid we have to wrap it up because we are finishing our session. All right, so my conclusions. In a juridical language, we often quote legal definitions. We often create definitions, and we think they are real definitions, whereas they are nominal definitions. So it was precisely my point, and I wanted to emphasize that. And that's my comment to Dr. Maniewska. Please consider whether this thesis about a real nature of definitions in a juridical language, perhaps it is slightly too far-fetched. That is my view. Thank you very much indeed. Thank you, Professor, for your contribution. It was a highly interesting intervention. Before I give the floor to the speakers, because as I understand, some of them would like to comment on that. I have a short question to Dr. Bomba in the context of the Polish law on protection of minimum wages. Could you tell us a bit more about protection guaranteed under the law in the context of non-employers or non-employees? Would you say this protection, perhaps it is too far-fetched, perhaps it is going too far? Could you give us a broader perspective also in the context of EU regulations? Because the Polish legislator actually has a very broad approach to protection of people who are employed outside of employment relationship in the context of minimum wages, does not apply any criterion of economic dependence, and it seems that the function of a salary or a wage is alimentation function. So it means that these people has to have the main source of income, the main source of living off this salary or living off these wages, or protecting them in terms of their basic living needs. So perhaps this protection in terms of minimum wages should be given to non-employment or atypical workers who are only economically dependent. So the legislator in Poland actually doesn't notice any differentiation here and guarantees this protection to all the workers. There is an additional criterion when work performers do not decide about the place of and time of performing work. I would say this criterion is not entirely pertinent. So if you could comment on that, but before you do that, I guess, first of all, Professor Meneghetti would like to comment on these questions and remarks which appeared in our Q&A session. So, Professor Meneghetti, over to you.
Thank you. Thank you very much. It was very interesting listening to all the comments, and I will try to make it very short since time is running out. First of all, I do agree that in drafting the scope of labor law by providing a suitable concept of worker or employee, we need to focus to social needs. And in my opinion, I just pointed out briefly in my presentation, but let me elaborate a bit more on this. In my opinion, a way for addressing social need is precisely moving past the old-fashioned distinction between employee and self-employed, because this distinction no longer makes sense for many work relations that are not able to fall under the domain of labor law. And this is exactly the point on which the European Court of Justice is working. Sharing, giving, providing universal and fundamental labor protections and social security protection to workers that are not employees under national law, but are considered worker under EU law. So by extending this protection, I mean, the European Union and the Court of Justice in particular is exactly trying to address the social needs of vulnerable workers that cannot benefit from labor law in their own countries. A second point I would like to touch upon is, well, it's true that the European Court of Justice is working on the concept of worker on a case-by-case analysis. That's exactly what case law is. But what I see that the sequence of the decisions of the European Court of Justice are all referring, at the end of the day, to the same concept of worker. I mean, they all start from the Laurie-Bloom doctrine. This is a fact. So they always mention in the first place the Laurie-Bloom case. But then they elaborate around the definition of worker provided in the Laurie-Bloom case in order to address the specific needs at stake. That's to say, the directive they are considering and the rights that are attached to this directive. But in elaborating around the Laurie-Bloom concept, basically, they are just providing kind of specification to this concept, and I don't see any leap of logic between the different decisions. So basically, they are all, at the end of the day, referring to, in defining the worker, referring to, again, functional integration of the worker into the client business. So the worker is someone that is basically part of the production cycle of a business, and operational dependence of this worker from this business. So not only employees, as they are defined in national law, can match this definition, but also dependent contractors, as I said. So self-employed that are depending from operationally and functionally from one business, and so eventually also economic from this business. So I see there is case law, there is a case-by-case adaptation, but at the end of the day, all the decisions are connected to each other. So we, in my opinion, we do have a single concept of worker in European Union law, which is applied to a share of labor law and social security provisions, as I highlighted in my presentation. Thank you very much.
Dziękujemy bardzo. I bardzo krótko w takich syntetycznych wypowiedziach
Very briefly, may I please request that speakers refer to the questions. Eliza Maniewska, please.
Bardzo dziękuję.
Thank you.
Bardzo syntetycznie.
Very briefly.
W odniesieniu do tego, co podniósł pan profesor Ćwiertniak.
So, responding to Professor Ćwiertniak, I'm more than aware of what Professor said. 15 minutes, it's not enough to present the entire concept of the distinguishing between the real and general concept. So I will tell you only about this definition from the collection theory and
wytknął to pewne uproszczenie, tak jak mówię, absolutnie na potrzeby
theory and acknowledgement, or theory and by Ajdukiewicz. And there is also this differentiation that was introduced by Professor Ajdukiewicz. So it's about distinguishing within nominal definitions and nominal definitions in the substantive sense and in the linguistic sense, or in the object and linguistic oriented sense. And both these definitions, nominal definitions, definitions in the subjective sense from the formal point of view, just to put it simply, when considering in the context of meta language, this is the reflection of a real definition when introducing that separation line, marking the difference between these two types of definitions. I'm fully aware of the simplification, which I committed for the sake of this presentation, but if that triggered your interest, I refer you to the text.
które są w nim zawarte, to myślę, że spowodowałoby to istotne niezrozumienie.
If I did otherwise, if I had done otherwise, that would have caused a misunderstanding, a considerable misunderstanding. And now about linguistic precision. Let us try and use terms such as labor law, such as employment law, and perhaps at that stage things will be easier. And at this more general level, we'll be dedicating our comments on our comprehension of our understanding of a notion of an employer. And here I'm a bit concerned to ask Agnieszka Olszewska, but I'm curious, what what is the ministry planning when it comes to the distribution to the burden on proof when it comes to proving the cases presented or brought or initiated by whistleblowers. Actually, we're past our assigned time, so perhaps Dr. Katarzyna Bomba could quickly add. Professor, thank you very much to this question. I think we should refer to the origin of that concept of a fee or wage. When we look at the positions of the committee that monitor observance of the directives of the European Charter of Fundamental Rights, so that is expressed in such a way that once we have regulations, legal regulations of a state that meet requirements arising from Article 4 or Article 7, I don't think there are any comprehensive definitions given that I could present here. But in fact, committees here, they refer to that origin, to that initial concept, and they say that the parties that do not fall under these regulations, we have include people who live on their earnings, on their investment, or those who provide interest in their own enterprises, or as within their own enterprises. And then moving on to questions, it seems to me that the criteria, that the definition contained in the minimum wage regulation is should be debated in terms of the minimum wage requirement. Note that the pressure is the emphasis is put on the subordination, on working under direction, on managing the time and location of work, and then we have that exclusion of the minimum hourly wage. But then we do not have the minimum number of hours that the person can work per month to fall under that regulation. So even in the case of operating and providing services of minor importance, if the negative premises of that regulation or law are not met, such person falls under the provisions of that regulation.
Czasową. Taka osoba może być wyłączona.
Otherwise, such person may not fall under that regulation, although given a work relation, and from that work relation comes as the source of income for that person.
Zależności dla zapewnienia środków utrzymania świadczącego usługi, czy też wykonującego zlecenie. Wydaje się, że to jest dyskusja.
So it seems that that specific
Dziękuję bardzo.
concept
Czas już
should
nam
be
się
changed.
skończył tak naprawdę,
Thank you so
ale
much.
jeszcze
I think
może
we
jedno
passed
zdanie,
our
żeby
time to
chciała
perhaps
zabrać głos pani Agnieszka Olszewska, która kilkukrotnie
I will give the floor to Agnieszka Olszewska. She was mentioned on several occasions during the
chciałaby
debate.
skorzystać z prawa odpowiedzi.
Would
czy
you like
ewentualnie-
to take up on your right to respond? I don't think she's with
Zapytam
us.
się jeszcze pani profesor Poras, tak? Czy
Profesor
chciałaby
Poras?
podsumować swoją wypowiedź w 2 zdaniach?
Perhaps, Professor Poras, would you like to summarize your
Jeżeli
contribution
nie, to
briefly?
wobec tego,
If you're
biorąc pod uwagę już
Not with
znaczne
us,
wydłużenie
if
czasu,
not,
chciałbym państwu
considering
bardzo
that we're
podziękować
past
za
our allotted time, I would like to thank you very
udział
much for your
pierwszym panelu
participation in that panel.
dzisiejszych obrad i jednocześnie chciałbym zaprosić państwa na przerwę. Biorąc pod uwagę przedłużenie tego panelu, myślę, że
Considering
będziemy
that this
mogli się
panel
spotkać około za 20 minut.
took
Zapraszam
longer than
państwa na
planned, I think
przerwę.
we should meet in about 20 minutes or so. Thank you.
Dzień dobry, witam po przerwie.
Come after the break, we are beginning our next session. My name is Krzysztof Walczak and I will moderate this session. So now some housekeeping issues, because there are 6 presentations planned for this panel and formally we have 2 hours or a bit less. So I will be a very strict moderator. So up to 15 minutes per speaker. So please stick to your time limits, because we would need some time towards the end for a Q&A session, because we can see that the discussion is usually prolonged. So we have to stick to our agenda. The topic of our panel is the concept of employee and employer national experiences, because we are going to discuss the same concepts but in different perspectives. So from a comparative perspective, it will be definitely of interest. The first speakers will be Professor Krzysztof Baran from Jagiellonian University and Dr. Izabela Florczak from the University of Łódź. And they are going to talk about a remote work, a necessary revolution, or a step towards undesirable direction. So the floor is yours. The first presentation. Many thanks. Good morning, ladies and gentlemen. I do apologize for my muffled voice because I have an infection, so I'm going to talk on behalf of 2 people, both me and Professor Baran, who conveys his best wishes, and I'm going to present the results of our joint work about the concept of a remote worker and all the developments in this respect, both in the legislation and in the real world, whether it is a necessary revolution or a step in the undesirable direction.
Praca wykonywana poza siedzibą pracownika.
The work performed outside of the working place is not a new phenomenon. In the past, it was mostly about manual labor, and now actually it is like reflection of what an employee does in an actual workplace. So a milestone in application of remote work was actually caused by the pandemic. So remote work was performed at various workplaces by university employees, accountants, officials. So our presentation is to focus on the Polish legislation. It will be our point of reference. I should start by saying who is a remote worker. There was a definition published by ILO, and a remote worker is a person who performs work, whole of it or part of it, in an alternative place of work different than the assumed regular place of work. In order to perform their duties, this person needs to have the right skills and competences and the equipment, and usually there is a separate part of a flat or a house where the work is performed if the work is performed from his place of living. If a remote employee doesn't have the right skills or qualifications, the work will be of poor quality. Not every worker who is a good worker in their working place, so non-remote, traditional working place, will be able to perform their duties remotely. And they will not always maintain the high quality of their work. We tend to forget about that, because they might not have competences for performing remote work. Because it is also about work organization. So it would be best if remote work is not connected with negative consequences. If remote work is imposed on an employee, the person cannot bear the risk connected with a lack of competences. Then an employer should make all the efforts to train the employee to improve their competences for performing their work remotely in such a work that quality of the work is satisfactory. Employee has an obligation to actively participate in various activities which aim at improving their competences in such a way that they can perform their work remotely in a satisfactory way. So what competences are these? Definitely such a person has to be independent, must be able to organize their working place and time independently, and competences connected with communication, because they need to communicate remotely with others, with other colleagues, so communication in writing, but also so it is about formulating their ideas and comments in writing, or not necessarily in writing, but remotely. It is not always the case. So self-motivation, self-organization, personal skills and ability to adapt. It is absolutely necessary to be able to process of work, even though there are various distractions while working at home, because a person might be distracted because, I don't know, there is a dishwasher that needs to be switched on or something else. So there are plenty of distractors available at home. As for the the place for work for people working at home, well, it is connected with a certain conflict, because for a remote worker, well, it is also a flat or a house, so such a person is entitled to certain privacy. On the other hand, employer knows that employee has certain duties and obligations, and there are some health and safety reasons which also need to be taken into account. A remote worker is the worker who has employer, and the employer has to be aware of barriers for a remote employee. The remote employer cannot demand constant readiness for work without limitations to certain fixed working hours, because obviously it is about work-life balance. Another challenge is to understand a certain interdependency. The fact that an employee is not seen doesn't mean that this person is not working. There were studies before 2010 by American scientists, and they focused on attitudes of employers and managers, and it was very difficult for them to acknowledge and appreciate work of employees if they cannot see that, especially if the result of work is prolonged in time. It is not instant. And some remarks about remote work in the Polish legislation, because certain issues are already regulated by the Polish law. I know that some remarks might be obvious, but such regulations are already in place. Remote work was regulated in various legal systems. In Poland, such laws appeared in 2020, first in a very fragmented form, and then it was amended and broadened. And the current law entered into force towards the end of 2020. So it is about the possibility of remote work, and remote work may be ordered by employer if employee has skills which are necessary to perform such a work. A contrario, we should assume that an employee cannot be ordered to do remote work if they do not have appropriate skills. According to the Polish law, an employer cannot order an employee to do remote work if they do not have technical capacity to perform it, or if they don't have the facility to perform work remotely. So it is not enough to have skills. They need to have the room or facilities, technical capacity. And if an employer orders to do remote work, questions arise or doubts arise whether an employee can deny such an order. And here, regulations of the Polish Labor Code apply. Let me just say that Article 100 foresees that an employee is obliged to follow instructions for the employer if they are not against the legal regulations or employment contracts. So, in order to do remote work, may not be in line with these conditions, but if these conditions are met, such a person is supposed to perform remote work. So, what are the consequences for an employee who says they won't do remote work? And in what circumstances they can do that? They can refer to the following premises. They may not have technical capacities. They may not have a room to do that. They may not have the right computer, the right equipment at home, and the employer does not give such equipment to the person. They may not have a room that would provide confidentiality in data transfer in their flat or house. Then an employee doesn't have an obligation to start remote work, even though such an order, such an instruction was given by the employer. And it is in line with the directive, because the law cannot impose impossible things on employees. There is also a problem of sanctions which may be imposed on employee if their denial of remote work is not justified. If it is justified by specific reasons, important reasons, especially lack of technical capacity, lack of the room for that, then the denial is justified. If such conditions are not met, the denial may be qualified as a heavy violation of basic employee obligations, and in the Polish law it is possible on such grounds to terminate an employment contract. But if it is not justified, there might be other circumstances. Simply an employer no longer trusts the employee. That is why employment contracts may be terminated by means of a termination notice. So there are various challenges for remote workers, and obviously remote work is here to stay. Before the pandemic, it was quite a rare solution, and nowadays it is more and more typical. So we need to ask more questions. What will happen next with remote work? So what are challenges? It is organizing their home space, because remote work is usually performed at home, especially it was happening under the lockdown, so they can perform work remotely. Yet it seems that the obligation like that is not only the obligation of an employee. If the employer makes such an instruction, it is up to the employer to take care of various aspects, like sometimes it is utopian, it is just a dream. For example, I can say that it was not really fulfilled by the employer of university personnel. And then employees have certain rights to work in safe conditions, and sometimes employer doesn't have tools to monitor and control conditions of work which is performed from home and remotely. And as a consequence, there should be some reparative measures and corrective measures. There are other challenges for remote workers, namely work-life balance, because it is also in the interest of the employer that an employee has some rest and relaxation. An employer should support the employee in differentiating between free time and time for work, because there is professional life and private life, and people need balance between those. And then employers can see now that home work environment may be sufficient, but there were some solutions which were supposed to be temporary, and they should not be considered permanent. So after several months of remote work, employers need to reassess the situation of remote workers and have some reflection on the basis of the experiences of previous months. And it is the responsibility of an employer, and a big part of this responsibility was transferred to employees. For example, I'm talking about the right equipment in the workplace or remote workplace, then training sessions for employees taking care of their general well-being, like taking care about the work-life balance. And two last sentences from me. Development of remote work seems a very possible direction of development in the labor law, but there are certain threats and risks. Because, well, this development was accelerated by the pandemic, so this speed, this haste may be dangerous because haste does not evoke deeper reflection, and as a result, we see some temporary solutions which are not perfect. Thank you very much for your attention. Many thanks, and if there are any questions, I'll be ready to answer them. Thank you. That's all from me. Thank you for the presentation. It was very interesting from the point of view of your topic, but you stuck to your time limits, so even there is still some time left, because perhaps we can use it for discussion later on. So, ladies and gentlemen, now we are trying to connect with our foreign participant. We'll see what will happen with our connection, whether we will succeed, because the next speaker is Professor Badrina Rao from Kettering University from the United States. I don't know whether we have connection in place. No, there is no connection with Professor Rao. Maybe we can connect with Professor Rao later on, and maybe he will be speaking later on. 2 years ago, he visited us in Rzeszow, so I hope he would like to deliver his presentation also today. All right, we can hear some voice online.
Hello, I think this is Professor Rao from the United States. I think I have some issues with my Zoom connection. If you can hear me though, I would be happy to talk. Is that okay?
Tak, w takim razie słyszymy, więc prosimy o
I can
prezentację.
hear you, so please go ahead with your presentation.
All right. Thank you, everyone. I'm really sorry about what I am experiencing. This is some kind of a technical glitch. A little while ago, I was just fine, but I'm finding that I cannot put my name or anything. My camera is not working, but my audio is. So let me bring you up to speed about the platform economy jurisprudence in the United States currently. As you perhaps know, we have a major controversy going on in the state of California. And this controversy has been an ongoing affair since 2015. And March of 2015, Uber, Lyft, and other such platform companies were sued, and the accusations, among other things, were that Uber was withholding the gratuities that were due to the employees or the drivers, and was not covering the expenses incurred by the drivers. And in the case of Lyft, the allegation was that it was not paying even minimum wage. Now, these corporations, they moved for summary judgment. This was in 2015, and they rejected the claims that were made. And the basis for this was that the nomenclature or the classification of the people in question was wrong. So they proceeded on the basis of what they called misclassification, and they said that the claims were premised on the understanding that the people involved were workers or employees, and that is just not the case. They were independent contractors. Now, the judge in that case denied the motion for summary judgment and ruled that the drivers were to be deemed as employees and that they were due wages by the companies. Now, this is a major issue for platform companies like Uber, Lyft, and so on, because they will be under this verdict required to spend a great deal of money paying back wages, benefits, and so on, running to the tune of millions, and they are clearly not in any mood to do so. So what happened was three major companies, Uber, Lyft, and DoorDash, they collected about $200 million for a ballot measure known as Proposition 22. And this ballot measure would allow drivers to be classified as independent contractors. And all the companies were willing to do was to give them what they called limited benefits. So the companies Uber, Lyft, DoorDash, and so on, they were saying that the people who drive their cars, who work for them, are not to be deemed employees, but they were willing to make a small concession and were going to pay limited benefits. Now, this was something that the drivers obviously were not happy about, but these corporations came together, put $200 million into a massive campaign for this ballot proposition known as Proposition 22. And because of their money power, they were able to get it approved in November of last year. And it was approved by a 59% vote. Now, once this happened, the workers or the drivers were obviously not happy. Labor groups were not happy. They sued these corporations and argued that Proposition 22, which curbed or limited their rights, was unconstitutional. Now, the California Supreme Court declined to hear the case, and for a while it seemed like the workers were out of luck, but the workers and the Service Employees Union, International Union, they all went to a lower court, and very recently, the judge of the California Superior Court in Alameda County held that Proposition 22 was unconstitutional. So this was a very significant victory for the drivers of Uber and Lyft. Now, the judge made three important points. He held this proposition unconstitutional on three grounds. He said that this proposition carved out an exception for gig workers with regards to workers' compensation benefits. Now, workers' compensation benefits, as you all know, are provided to workers who are injured on the job. Now, the state legislature under California's constitution has the right to set the rules and control workers' compensation, but Proposal 22 or Proposition 22 said, no, that is not allowed. And the judge said that this limits the power of the legislature and hence it is unconstitutional. Now, the second reason why Proposition 22 was found unconstitutional was that it imposed unduly heavy restrictions on making any amendments to this proposition. Thus, it had unusual provisions like, requiring a 7/8 majority or a super majority for making any amendment to the law or for reversing the law. Now, this super majority is hard to accomplish, and therefore the judge found that it was not constitutional. Finally, the judge also found Proposition 22 problematic because it prevents gig workers or platform workers from unionizing, and said that any future law that gave the rights to unionize to workers would be considered an amendment to Proposition 22 and hence would require 7/8 majority or a super majority. Now, the judge said no, unionizing rights are a separate and unrelated legislation. They should not come within the ambit of Proposition 22, and hence he ruled the proposition completely unconstitutional. Now, this might seem like a victory for the drivers of Uber, Lyft, and so on, and for gig workers. For now, the situation is ambiguous. Why? Because gig workers say that following this ruling by the California Superior Court, Proposition 22 is dead, and gig workers are to be considered employees. But the corporations are vowing to appeal this matter in a higher court, and their logic is that pending the outcome of the appeal, they should be allowed to treat drivers as independent contractors. So this is the background for the current controversy. It has been going on for quite some time. What I propose to do is to remove this debate from the nitty-gritty of trial logic. Instead, I want to elevate it to a different plane. At stake here is the security, future, and well-being of millions of workers who, as you will all agree, are marginalized. They have very limited skills, limited organizing power, and are at the mercy of big business. So this brings us face to face with some very foundational questions. How are we going to treat people who are less privileged? What social arrangements are we going to put in place when we encounter people with limited abilities who have no choice but to work at the lower end of the labor spectrum? Now, the law and the courts are clearly not in a position to address these foundational questions. I'll very quickly give you some instances. For instance, the judge in the Uber and Lyft cases also agreed that the legal status of drivers is ambiguous, number one. Number two, the judge agreed that it's hard to find out whether someone is just an independent contractor or an employee, because in the case of platform workers, they fall somewhere in between. So is this a question of fact? Is this a question of fact and law? These issues remain unresolved. Now, we have been approaching these matters, courts have been approaching these matters from a traditional perspective, in that they say, well, in order to determine whether someone is an employee, we have to ask ourselves, does the employer have control over the employee? Okay, and is the employee dependent on the employer? Now, these tests, as they are called, they were forged in a different context when technology was of a different character, and obviously, therefore, it cannot offer solutions to the problems we face. The issue now is we have millions of people across the world driving cars for Uber, Lyft, and other corporations, working for platform companies like DoorDash and so on, and they have very limited bargaining power. They have an asymmetrical situation where their ability to assert their rights is limited by their lack of secure income, their lack of a good permanent job, and so on and so forth. So the question then becomes, how can we address the real concerns of workers in the platform economy by using a framework that was developed in an earlier epoch when the rules of engagement were different? Clearly, the tests that we have in employment law in the United States with respect to determining who is an employee and who is not, the control test, the dependence test, and so on and so forth. Now, there are many more things. There is a 5-point test, and there are 8 indices tests. I don't have the time to walk you through these things. They're all in my paper. But the important thing to keep in mind is these strategies do not provide us any viable basis for providing relief to the companies. Now, I'm sorry, to the employees. Also, the companies have threatened to quit California. They have threatened retaliation in other ways, etc., etc. So the issues here are twofold. Number one, when new and disruptive technologies emerge, we have to ensure that they are provided the proper ecosystem to flourish. If we continue with old strategies for regulating them, then we could be stifling innovation, we could be destroying creativity. And so that is clearly unacceptable, and no one would want that. We want new technology, we want new companies. This is one thing. How can we ensure that this happens? Secondly, at the same time, we have to ensure that people in the platform economy are given a fair treatment and their rights are not compromised. So we have to strike a balance. Now, scholarly debate on this issue has been rich and extensive. People like Professor Brishan Rogers from Temple University have written about this. Several others also have written. And broadly speaking, there have been debates about what is the best way of approaching this question. Now, Professor Rogers, for instance, has argued that we have to adopt an anti-domination policy when you are deciding issues concerning platform workers. Why? Because he says platform workers are victims of two types of domination. One is what he calls the dyadic domination, which is domination from the employer. The second one is structural domination, which is domination that a marginalized platform worker experiences while functioning in a market economy. So these two types of domination create challenges. So the question then is, as I argue in my paper, that one has to go beyond this. As I see it, there's one critical question. I understand I am running out of time, so I'm going to make this last point. Okay. We now have millions of people that we have to work with. The issue is, are we going to respect their inherent and inalienable dignity? Immanuel Kant has reminded us that people must be treated as ends in themselves and not as means to an end. So from a Kantian perspective, if we adopt a dignitarian approach to the rights of platform workers, I think we have to, as a society, come to this consensus. This is not going to be easy, but one has to forge this consensus that there is a threshold beneath which we will not fall, we will not go while dealing with fellow human beings. One last point before I close. You see, there is this market-driven argument being made that platform workers are semi-skilled and so they don't deserve any more. I want to draw your attention to a concept that Warren Buffett has popularized, the concept of ovarian lottery. What does this mean? Many of us have had the good fortune of being born in the right family, right circumstances, and so we flourish. Many others do not have this advantage. In other words, they are not lucky. And we must not penalize people for their unelected circumstances. That, I submit, is the crux of this debate. And the best way to approach it is from the Kantian perspective that privileges dignity. And dignity is important because human beings are moral agents, and that is what entitles them to fairer treatment. Thank you so much for your patient hearing.
Dziękuję bardzo profesorze Rao za zachowanie również dyscypliny czasowej i za ciekawe informacje, które myślę mogą być przydatne również tutaj w
Thank you very much, Professor, for your highly interesting presentation and for sticking to time limits. It's time for the next speaker, Dr. Walasek from the University of Transylvania, Romania. She's going to talk about the evolution of the concept of employee in the Romanian labor law. So the floor is yours.
Thank you, Professor. I hope that everyone is hearing me, and I will try to share my presentation. I hope everyone is seeing my presentation.
Yes, yes, of course.
It's okay?
Yes.
Okay. So, my presentation is about the evolution of the concept of employee in the Romanian labor law. And I want to start with a motto. It is a motto from one of the first labor lawyers here in my hometown in Cluj, in Kolozsvár, in Transylvania. He was named Augustin Peter and lived in the first part of the 20th century. And in his book entitled The Slavery of Work, he said that people's perception of law and the rule of law is so wonderfully conservative. And I was always interested in this motto. And I want to start my presentation from this point of view, of course, in the Romanian context. So I will put the questions in what way has our perception of the main subject of work the worker himself changed in time in Romania, in the Romanian regulation. Who have we considered and do we consider to be employees? What is covered by the diversity of terminology by which we refer to the employee as a legal entity? What does the concept of employee mean to us today? And of course, in my short presentation, therefore, I would like to shed some light on the changes of the legal concept of the workers, highlighting some of the most relevant moments of the development of the Romanian labor law. And my main question is how that we ended at the nowadays with the expression of work in nobles, when we started from the Roman law with the expression of working is disgraceful. It appears as a uniform position in the labor literature in Romania that we can find the roots of regulating employment relationships in the institution of locatium conductium operarum from the Roman law. Of course, in later eras, the occupation of freelancers who were forced to work for living was also important and may have influenced the legal status of the worker. In Christian Rome, to serve in the military, in civil service, or in church became to be considered as a privileged vocation. And of course, agriculture was considered one of the most respected sources of income too. Preference was given to sailors, to blacksmiths, and other craftsmen. As a conclusion, thus, at this early stage in the regulation of work, the thinking about someone working for a living was fundamentally influenced by two aspects. And these two aspects are who did the work, who is the person working, the employee, as we would say nowadays, and what kind of work was involved, of course. The other outstanding aspect, already of great importance, was the element of constraint, the subordination, which in our current language appears in the term of dependent work, as it was heard in other presentations today. This dependent work characteristic is an essential feature of the employment relationship. And in the 19th century already, as the result of legislative processes that took place in this century and before, the history and development of labor relations reflects deeply the economical, political, and ideological imprint of the century and of all times. For this reason, it is also clear that in our thinking about the employee, in defining the legal concept of the employee and in its appearance in the regulation, we also need to find the characteristics that can be assessed as an imprint of the given era. We can see a diversity of the concept of employee in different laws in this 19th century and the beginning of the 20th century too. And we must conclude that the uniform approach of the concept of employee is not typical for this period in the Romanian regulation. What we find particularly interesting about this diversity of perception existing in the beginning of the 20th century and the 19th century is that the worker status, the regulation of the labor law about the worker status today is partly reorienting towards this idea of diversity, of course, albeit in a completely different context. We are talking now about platform workers and remote workers and a lot of other atypical employees, which we are wondering if are employees or not. Nowadays, the principle of equal treatment between these different groups of employees is considered a basic requirement, both in European and, of course, national regulation. And one of the biggest challenges, I might say, of the labor law is the regulation of new labor relation forms, all these called atypical work, in which we are forced to rethink, as we heard before, the concept of worker as well. And beginning with the first years, the first decades of the 20th century, in Romania has appeared the first law. It is called the Nenicescu Act, talking about the employee and the status of the employee. And this act said that a person over the age of 16 could be a worker subject to the condition of good behavior. And of course, we know what meant good behavior in this these first decades of the 20th century, for example, not participating in strike activity or something like that. The first real Employment Contracts Act, it is not a labor code, but a very important law in Romania, entered in force in 1929. And the first piece of legislation that really tried to, this is the first piece of legislation that really tried to provide a uniform framework for all employment issues. Uniformly provides rights and obligations for employees, although it introduces specific provisions for certain occupational groups, primarily with regard to payment, to wages, and other entitlements. No specific legal definition of the employee is included in the law. However, the definition of the employment relationship can help us in this matter, because Article 37 said in this law that an employee under an employment contract undertakes to perform work or service for a specified period of time or to perform a specific job for the other party, designated as the employer, who in turn undertakes to pay the employee. During the parliamentary debate on the draft law and this labor contract law, the diversity of groups of employees was highlighted in the comments and in the discussions, but they are regulated by the same law, and their rights, their legal rights, are guaranteed in the same way, as it was emphasized by the Minister of Labor of that time. In the second half of the 20th century, of course, in Romania, there began the Soviet-type legal regulation to be entered in force, and it was a strong ideological regulation which had an impact on the way of thinking about the employee. In this context, working was considered to be primarily an obligation towards the society and not really a right. It was obligation and not a right. The first Romanian labor code in 1950 had no definition of the legal concept of the worker. However, we can clearly deduce from Article 2, which sets out the scope of the legislation, who was considered to be a worker. The category of employees can be delimited on the one hand by the fact that workers and civil servants are covered by this new labor code as employees, and on the other hand, the above mentioned two groups are to be considered all employees on the basis that the cited article refers to all public offices, all institutions, and all employers, company, entity, cooperative, natural, or legal person that used paid work. The main characteristic of the employee in this period in Romania, I might say, is vulnerability. The worker appears as a central actor in the construction of the beautiful new world, as we all know it was called. The employee is the central figure of the ideological narrative, and in many aspects, freedom to work also meant a kind of slavery of work again. Institution of posting and relocation was widely used in Romania, and employees being transferred from one establishment to another or from one location to another was a daily practice. In the same time, young people leaving educational institutions were placed in pre-designated jobs based on a real or artificially generated labor demand. And wages were based on quantity and quality of work, punishable by wage deduction, even if the failure to meet the labor standards was in no way due to the employee's fault. The second labor code of Romania entered in force in 1972, and this labor code did not attempt to define the concept of the worker either. The concept of the employee was not defined. We can find an appropriate list of the political ideology of the era according to the importance of each group of workers to the development of the socialist economy. The list began with industrial workers who have a special responsibility to the people, as the law said, and continued with those working in construction, agriculture, ended with those working in intellectual professions, education, health, culture, and so on, and in the public service, of course. The concept of the employee was set from the point of view of working capacity, as a conclusion. And about the concept of worker, we only find in the Labor Code of 1972 the age requirements for that work capacity. Work is compulsory in this era for all persons who are able to work. And from this perspective, we can say that in the Romanian regulation, this labor code set the widest possible range of persons as employees. Do we have to examine work ability in a purely medical sense, or is the ability to work related to the ability to act? This is the main question in this era. We do not find any guidance in this regard in the legislation. As I said, we have only the age requirements set in the Labor Code of 1972. But this issue is very interesting because the current Romanian Labor Code from 2003 explicitly prohibits incapacitated persons from working, even if they are physically and medically able to carry out some activity that is naturally appropriate to their individual abilities and regardless of its possible positive effects, which I think it is not a positive aspect of our current Romanian labor regulation. As a conclusion, in this period, the socialist Romanian labor law considered that being an employee was an obligation, and without the concept of employee being defined by law, the ability to work that characterized an employee was basically only on age conditions. And of course, in nowadays, we have the Romanian Labor Code in force. It is Act number 53 from 2003, and the Romanian regulation is fundamentally defined, characterized by the transition to the market economy and the requirements of the European Union. Still, we have no legal definition of the employee. We essentially speak of a natural person based on labor code who carries out his activity on the basis of an employment contract concluded by him or her. We can get to the interpretation of the concept of employee from the definition of the employment contract and again from the point of view of the ability to work. Under Article 10, a contract of employment is a contract under which a natural person, an employee, undertakes to perform work for an under and direction of an employer, of a natural or legal person, in return for remuneration known as wage. From that provision, we obtain a very simple definition of the employee on the basis of his relationship with the employer, in which the main characteristic is the dependent work which he undertakes under the employment contract. So, as a conclusion, in Romanian labor law, for being an employee, you must have an employment contract. Platform workers, for example, are excluded from the labor regulations. Article 13 deals with the condition of ability to work, and as a result, the concept of worker under Romanian labor law is more clearly defined. A natural person acquires full ability to work when he reaches the age of 16, and we have in Constitution the age of 15 set as the minimal age. The employment of persons placed under judicial supervision is prohibited by law, as I said. Basically, two conclusions can be drawn from the above provisions. First of all, according to the Romanian labor law, an employee is a natural person who meets the legal age conditions and carries out his or her activity in a legal relationship based on an employment contract. And finally, some concluding remarks. We can see the development of the concept of employees through the decades on the basis of the changes of the labor regulations in Romania. Nowadays, in addition to the labor code, European labor law also has a very important effect on more precise definition of the concept of employee. The principle of equal treatment between the different categories of workers and the more general definition of the worker in both the regulation and the labor law literature is characterizing this aspect. The new challenge for labor law, in my opinion, and I think not only my opinion, is that in the following will be how to find a broader interpretation of the concept of worker that allows those who do not work under an employment contract, but also work in some atypical employment forms, for example, platform workers, as we heard before, to be protected under labor law. The main question for Romanian labor law in the 21st century is how to find the increasingly blurred boundaries of labor law, the status of a worker in the classical sense, and the form of self-employed yet partially dependent work, and to reshape the concept of the worker eligible for employment protection accordingly. Thank you for your attention, and I hope my time limit was not, oh, it's okay. Thank you.
Dziękujemy pani doktor. Faktycznie.
Thank you very much for your presentation. It was a highly interesting presentation, also from the perspective of the development of the notion of employee in Poland, the notion of worker as well. Thank you for sticking to time limits, and there will be two more speakers now from Jagiellonian University. So Dr. Justyna Czerniak-Swędzioł and Dr. Ewelina Kumar-Jezierska. The topic will be the status of person who performs an invisible work under regulations of labor law and social security.
Do wygłoszenia prezentacji.
Dzień dobry Państwu. Dzień dobry, Szanowni Państwo.
Well, good afternoon, ladies and gentlemen. I hope that you can see us and hear us well. First, I wanted to congratulate the organizers very much on this conference. I have the pleasure to take part in this conference for the second time as a speaker, together with my colleague from the same department. And we wanted to present to you the concept of invisible work. This is something that we study, and we want to present the status of a person who performs this invisible work in the context of social security, and explain the phenomenon. And I think we'll have a presentation.
Czy jest widoczna prezentacja? Tak, ja widzę.
Tak, jest widoczna. Pozwalam sobie tutaj za chwilę niedostępnego pana profesora.
Dobrze. Ja tylko jeszcze chciałam również podziękować za zaproszenie, za możliwość udziału w niniejszej.
Thank you very much for this, for inviting me to this conference. This is the first time that I'm participating in this conference organized by Rzeszow University. In particular, I would like to thank Dr. Agata Ludera-Ruszel for admitting me to this conference. I'm giving the floor to my colleague, and she will start this presentation. Ladies and gentlemen, yesterday and today, speakers presenting their excellent papers, they spoke on the changes in the perception of labor law and the need to redefine the notion of an employee. This topic combines two quite contradictory words, which is work and unpaid work, although this is not a volunteer work. So what is invisible work in this context? So this is a concept or a notion which is symbolic in nature. It hasn't been defined but in the economy, but has been defined in social sciences. This is this natural division of responsibilities and duties between men and women. This work is work which does not follow under the attention of the society, although its outcomes are visible. This invisible work is directly related to the situation of a person, is performed free of charge and doesn't generate any income. But as evidenced by the report prepared by Oxfam in 2009, if it were financed at the level of the minimum wage, it would be 3 times the size of the global tech sector. So this work is unappreciated and not recognized in terms of payment and in terms of acknowledgement, appreciation, and it's often confused with leisure and rest. This is often, it is often referred to as the pink zone because it's not hidden from the state. It is the state that doesn't want to notice that work. So who performs this work and for the benefit of whom? So this work is performed for the benefit of children, of relatives, of the elderly, but this is, it is not my intention to focus on just one area of field of doing this work, and which is largely associated with care, because we'll be talking about this care a lot today. But the phenomenon on invisible work is also can be also identified in the professional area. We've been continuing studies which is in the area of the so-called academic management, and the concept of invisible work in institutions of the higher education is also visible when it comes to care about students, when it comes to student counseling, when it comes to work for the sake and benefit of the academic community. So invisible work, as I said, it may concern 2 different areas. Today we're going to focus on this private area. We'll be talking about the burden of educational, emotional, organizational, nutritional, and care-related tasks. We know very well that they have been even more exposed during the pandemic. The pandemic forced us to look at the issue of invisible work of an employee, of a caretaker, from a different perspective. It is no longer, I don't think it is difficult right now for you to guess that invisible work and this work involving care, this is work of women. And according to statistics, women are the ones that carry these responsibilities on their shoulders. It is them who are responsible for all these child care and other care work. 42% of women cannot be gainfully employed because of caring for others. Sometimes this is a result of a conscious choice, but sometimes this is the result of an enrichment of the family relation. But this invisible work is important, has an impact on the professional situation of that person. We can absolutely prove that women who do these invisible duties at home, who care for their children and the elderly, who work from home, who feel, and women do not entirely agree to speak about it, or are willing to speak about their invisible work. Well, actually, such invisible work actually removes that person from the labor market, and and such work closes door to promotion, reduces the person's accessibility, availability, and her competences become outdated, and that results in a professional isolation. So when it comes to our legal regulations and how our law sees it, well, let me give the floor to my colleague. Thank you. In my part of the presentation, let me mention that the invisible work doesn't only include childcare, which is often commented and often encountered, but there is another issue that gained publicity recently. So that is the issue of aging society and caring for the elderly, for the aging elderly, aging adults who, because of their status of health, who because of their illnesses, require constant care. And caretakers are professionally active adult members of their families. So that invisible work is largely identified with caring for children. However, the study published in 2020 clearly shows that the Polish society is among the fastest aging societies in the EU. Could you perhaps turn your camera on? My camera is on.
Znaczy, u nas wygląda, że ma pani wyłączoną,
Well,
ale...
we see it this way
No
that
dobrze,
you're...
jeżeli jakiś problem, to w takim razie to zostawmy tak jak jest, natomiast...
Ja mam włączoną, wygląda na to, że mam...
No dobrze, no to zostawmy w takim razie.
Tak więc problem opieki nad osobami dorosłymi będzie narastał.
This issue of people staying home and caring for their elderly relatives will be aggravating. Nearly 37% of the respondents were not sure whether they had any persons burdened with caretaking duties in their surroundings. Only 9% of the respondents didn't know whether these persons were not taking care of children. So apparently, knowledge about caring about children is more popular. Well, people talk, employees talk about taking care, caring for children. When caring for adults, that is a smaller source of smaller satisfaction for caretakers, results often in a mental burden of the caretakers for adults. In Poland, caretakers are largely the nearest the relatives, the nearest members of families, and not that often these would be friends or perhaps neighbors, and only to a very small extent these are state, municipal, and other institutions. Perhaps I'll move on. As already mentioned, women are the key members of the caretaking of the caretakers. So, for example, nearly 90% of women who cared for their children with leukemia and other forms of cancers, they had to resign from work fully, and similarly in other cases, caretakers are mostly female and not male. As for legal regulations in the Labor Code in 2018, it was amended, in particular Article 140, paragraph 1, that was to make it easier to reconcile professional activity and caring for persons who required such care. However, the scope of that provision applies largely to parents of young children who are ill or that require extra care and have that proven by a specific certificate. However, in this provision, the legislator ignored caretakers for the elderly family members, and such persons do not have the right to deduct the time of such care from their work time. When it comes to other regulations that somehow appreciate work of the persons who care for adults, there is a law. There is law on family benefits, so there are two main benefits that may be applied for by a caretaker. However, the benefits are quite insubstantial. The care benefit paid out to parents of disabled children is less than 400 euros per month, and another benefit it's about 150 euros. So these two benefits do not really guarantee life and dignity to these persons. But for a caretaker to apply for such benefits, that caretaker must fully give up any work, any professional work generating any income. I understand that we don't have much time. Let me just mention two important pieces of legislation which unfortunately are related with abandoning professional work and earning. So one is contained in the supplementary family benefit, and applies to parents only, and specifically parents who rear at least 4 children. And here note that there are certain premises for awarding that benefit. So here the legislator actually addressed this benefit who are inactive professionally or resigned from work solely for the purpose of having more than 4 children or more. But while women who have 4 children and work professionally, they are not eligible for the benefit. So the key assumption of that legislation was to honor and appreciate rearing a bigger family, and in my opinion that purpose hasn't been fully achieved, because that is at the detriment of the parents who kept their work and while rearing a family of 4 or more, with 4 children or more. And my final point focuses on the EU Directive 2019. And that directive is to be implemented to Polish regulations by to the Polish legal system by August 2022. And the preamble clearly refers to the issue of the aging society, presumes an increased demand for care for the elderly in the future, and the state is called to follow with legislation appropriate so that aging society can be taken cared for. So, for example, the legislator introduced 5 business days of leave in case when our close relative requires such care or support because of a serious medical condition. So finally, note that system solutions which have been already introduced in order to support caretakers of adults are outdated. They were adopted 20 years ago, and since that time, the labor market has changed and technologies progressed, and this way, and with them, remote work is allowed. So here, persons who are burdened with long-term care for the relatives and who are placed in such a situation, who are shunned from the labor market, they have no capacity, they are not eligible for any additional benefits and social benefits later on. So that calls for changes, and that calls for solutions that facilitate performance of both roles of a caretaker and an employee. And finally, the authority, that right that was specified in the directive, it does exist in Polish legislation in Act on Monetary or Pecuniary Benefits, but this is a short-term solution. So there should be some rights assigned or given to those who continue with long-term performance of their responsibilities. Thank you, and I would like to give the floor to Dr. Czerniewska, and I wanted to ask the question, Czerniak-Swędzio, and I wanted to answer the question that we asked here, whether the person who performs invisible work can be classified as an employee or as a worker. So the answer will be negative if we follow the labor code definition, but a person who does invisible work should be considered a worker in constitutional terms. A lack of proper understanding of the concept of unpaid work and its value is not entirely right. Well, obviously, I used the paper by Professor Anna Musiała on unpaid work in the context of volunteer work, to which I referred to at the very beginning. I believe that the definition of a constitutional worker should be analyzed and perceived on a broader basis, and persons who do the invisible work should be appreciated in such way too. As we've already said, the invisible work, caretaker work, should not be limited to one sex, but unfortunately it is limited to one sex, and as a result, in consequence, women who do such tasks, who perform such duties, they disappear from the labor market. So what are the conclusions from our study? There is this need for the state to appreciate invisible work, and perhaps that could lead to partial freeing women from this patriarchal system and engagement of men in the care system, in the system of caring for children and the adults, the opportunity of using more institutional care, but also it is about looking at persons who do the invisible work as an employee. That is to make it possible to the person who has the right conditions for it to combine professional work and performance of the caretaker's duties. And on top of that, what is crucial here, making it possible for the person to receive benefits without the need to start gainful employment. Thank you very much for listening to us, and thank you very much for inviting us to this conference. Thank you very much, and it was a very inspiring presentation, then prompted us towards reflection. And now is the time for our next speaker, Professor Vetpal Singh from Maharishi Dayanand University, India, and he will tell us about key factors of relationship between employer and employee, glimpses from India.
Thank you. respected chairperson, organizers, speakers from various parts of the globe. Good evening. I am Dr. Vedpal Singh, Associate Professor from the Faculty of Law, Maharshi Dhanand University, Rohtak, Haryana. First of all, I would like to express my gratitude to the organizers who have given me an opportunity to express my views on the very important topic, that is key factors of relationship between employer and employee, glimpses from India. Introduction. The relationship between employer and employee in India has been a key in sustaining balance in the industrial relation scenario. A relationship, it is characterized by the way two individuals or group of people view and behave towards each other. An employer and employee relationship then is the way an employer and employees view and treat one another in a work setting. From this moment a person signs his or her employment contract, a relationship starts to develop between that employee and their employer. Thereafter, the momentum of the work starts and gears day by day. Objective of the paper is to understand what type of relationship is required between an employer and employee. Number two, what are the benefits of this behavior between employer and employee? Number three, how to create happiness towards employees by the employer. As a part of the welfare state, it is the duty of the state to ensure that all kinds of people, they remain happy. So for that purpose, what kind of steps need to be taken by the employer to keep his employees happy is the main objective of the paper. Number four, what is the role of the government and trade unions in maintaining good relationship between employer and employee? Need of the cordial relation. As we know, whatever work we perform, in case we are having the environment conducive for the betterment, that is known as cordial relations. So it is very essential to have a cordial relations between employer and employee. The nature of that relationship depends upon various factors. Some of them are: number one, to provide adequate training. Training is the tool which makes us perfect to perform a skilled work. In the relationship between employer and employee, it is the training only which will be able to create its employees towards its work, towards the work they have signed with their employer, depending upon their efficiency, skills, and the type of training imparted to them. Number two, to set clear expectations. Yes, it's of course it's true that once we are the part of the contract between employer and employee, it is expected that the employees, they will be doing better and better for the betterment of the industry, for the profit of the system, for the betterment of the quality of the products and everything. So there are always expectations from its employees that they shall be working in tune with the terms and conditions accepted by the employees and made by the employer. Number three, be flexible. Sometimes a person falls sick. So in that situation, it becomes the duty of the employer to provide sorts of incentives, to provide leaves so that he or she can improve, can have that strength to work on that particular machine. So it's always, it should be flexible. If anything is rigid, then there may be chances that contract can come to an end. So for that purpose, we must always remain flexible because we are human beings. Sometimes there may be some problem at home, and the employee want to leave the factory and to go attend to the family member. So it should not be so strict that you cannot leave the work and you cannot move towards home during the working hours. So there should be flexibility, and that flexibility depends upon that kind of relation which is sustained by the employee towards his employer. Then it is a breach of, it is a kind of maintaining the trust, and trust means to have a faith on its employees on the part of the employer. Be consistent. Yes, of course, it's true that one should be consistent and persistent towards the work assigned by the employer, assigned by you as a part of the agreement. To reach the millennial generations, how to prove yourself that you are a kind of asset to the industry? You have to prove your skills as we follow the principle of better than best. Everything is in a good condition, good shape. Then also we need to work in such a way that there are no loss to any machine, no loss to any person, or you can say that we are able to develop a kind of system which is accepted by both parts, that employer and employee. And for that purpose, one should be more cautious towards the duties. Role of the parliament is Indian labor laws are made to characterize obvious relationship among employees and managers. Indian labor laws, they are made to shield the interests of the workers. Few of them are as follows. Payment of Wages Act 1936. Before independence itself, the Britishers, they have started to regulate the mechanism of employer and employee. So for that purpose, that these employees, they get the handful amount of money so that they can remain happy. There was a kind of legislation which is known as Payment of Wages Act 1936. Second one was the Minimum Wages Act 1948. Because of large population of the country, there were a lot of chances that exploitation of worker would take place. So in order to avoid such type of problems, the independent country, the parliament of the independent country, they enacted Minimum Wages Act 1948. The country got independent in 1947. 15th August 1947 is the independence day of the country. So thereafter, the Parliament of India enacted Minimum Wages Act 1948 to ensure that exploitation of capital force should not take place at any cost. Thereafter, in 1948, so many Factories Act 1948 was created to ensure safety measures and what kind of facilities can be provided to the workmen, because it's not necessary always that you keep on asking the work and work and work. We must ensure that how to create facilities, how to create safety measures, how to create all sorts of things which are necessary for the interest of the employee. And later on, Maternity Benefit Act 1961. It was enacted to ensure that all those ladies who have joined the industry, they must ensure and they must get the benefits of their maternity. It's a fundamental right of every woman to enjoy the Maternity Benefits Act, because we are living in a welfare state. Welfare state means to look into the interest of each and everyone. And moreover, we are talking about the persons who are the part of the system, terms and conditions. But you will be surprised to know, up to 1961, there was no such regulation. In the year of 1961, Maternity Benefits Act was created to ensure that the mother can look after the needs of the newly born child. and its nourishment. Payment of Bonus Act 1965. It was a landmark legislation to ensure that labor laws, they are for the betterment, for the interest of these laborers. These are some of the significant labor laws in India. These laws have several provisions to safeguard the interest of the workers of the organized and unorganized sectors in the country. Role of Indian judiciary. In India, Indian judiciary has been functioning as an independent organ of the government of India. So let us understand what is the role of the Indian judiciary to uplift the conditions of the workmen. Judiciary has time and again tried to interpret the statutes and attempted to come out with its interpretations that maintain harmony and peace in industrial establishments. Judiciary has repeatedly provided indications that employers and employees, they have their respective obligations and they need to have the appreciation of each other's responsibilities, duties, and obligations. Judiciary has reminded all stakeholders of the industrial establishments from time to time that every dispute between the employer and the employee has to take into consideration the third dimension. What is that third dimension? The interest of the society as a whole, particularly the interest of those who are deprived of their basic rights. So judiciary has also adjudicated upon as to whom the onus of establishing relationship of employer and employee lies. The judiciary has passed various judgments. Two of them are as follows. In the case of JK Cotton Spinning and Weaving Mills Company Limited versus Labor Appellate Tribunal, in this case, it was observed by the court of law that goal or object of industrial adjudication is to help the progress and growth of an economy of the country. It's true that we want to have the growth of the country by developing its economic conditions. But being capital force, employees are capital force, their interests are also to be protected. The court was of the view that they are the part of the mainstream of the nation. Although they are working in the industries, doesn't mean that they cease to enjoy the fundamental rights or the rights of the country which are there for each and everyone. So for their betterment, all those safety measures, all those measures which are of their interest, they are to be protected. In the case of B.R. Singh versus Union of India, in this case, a very famous judge, Justice Ahmadi, was of the view that the right to strike cannot be compared to that of fundamental right. It is not a fundamental right. It's a mode of protest. Strike in a given circumstance is a type of demonstration. The right to demonstrate and thus right to strike is a significant weapon in the armory of the workers. The right has been pursued by practically all democratic nations, though not raised to the high platform of a fundamental right. It is perceived as a method of redress for settling the complaints of the workers. However, the right to strike is not absolute under our industrial jurisprudence, and restrictions have been set under it. Because there is a principle of law that absolute power corrupts absolutely. We need to put some kind of restrictions which are necessary for the smooth functioning of any system. In the state of Madras versus Parthasarthi, it was observed by the court that rather the government has the power in the interest of the industrial production to set the machinery of the settlement of disputes in motion without pausing to inquire about what the specific points of the disputes were. So the government is empowered to frame the legislations which are there for the betterment, which can improve the conditions of the workman. And both the parties, that is employer and employee, they need to create a conducive environment where the economic conditions of the country can be improved. It can be improved if both have balanced powers. In the conclusion, I would like to say that since March 2020, imposition of lockdowns have increased unemployment, poverty, inequalities, challenging the solidarity system based on the wages relationship. Their architecture and their sustainability, they are more than ever the focus of the social, economic and political concern, so that future of work is maintained. Now the time has come to look after the needs of the employee, at least during the health crisis. Friends, as we know, entire society has been suffering on account of coronavirus, and because of that, the rate of unemployment has increased. The conditions of workmen cannot be ignored. That on 20th March 2020, all the gates were locked down and the laborers were forced to move their hometowns without any vehicle. They followed by walk to reach to their destinations. So many persons died on their journey to their home. And moreover, you understand the conditions when they were having no job to do. Although forget about all this, there was a scarcity of living the life. So we have undergone such type of trauma in our life since last 2 years. Now the time has come towards a normalization. We need to improve the conditions of our workmen. The government of country is looking after for enacting the labor codes where the amount of leaves, that is holidays, are going to be increased. So I think it's a kind of welcome step on the part of the government for looking into the interest of the workmen. With this, I would like to express my sincere thanks to all those who have joined for the patient hearing of the Prof. Thank you. Thank you.
Dziękuję bardzo, panie profesorze, za bardzo interesującą
Professor, it was a highly interesting presentation. Thank you for sticking to your time limits. Now it's time for the next speaker. These will be representatives of the Labor Inspectorate in Rzeszów, Barbara Kiełt and Aneta Gronowicz.
Dzień dobry. Ja może w imieniu Okręgowej Inspektor Pracy pani Barbary Kiełt.
Hello, in the name of the Regional Labor Inspector, Barbara Kiełk, and myself, I would like to thank the organizers for today's conference. I'm for the second time at this conference. 3 years ago, I was in the audience, and today I have this opportunity to give a presentation because the regional labor inspector could not be here for professional reasons. I would like to give you my presentation, and I would like to tell you about remote work related issues. I come from the state or national body which supervises and controls work conditions, and therefore I would do my best to go swiftly through the presentation and focus on the key issues in very practical, down-to-earth approach.
Trochę statystyki, trochę, że tak powiem, materiałów. Dobrze. Proszę Państwa, trzeba pamiętać o tym,
Right. Bear in mind that remote work was introduced to the Polish legislation because of the last year's pandemic. Similarly, note that this is not a regulation based on labor law, but this is a special provision. Initially, remote work based on Article 3 of particular solutions related to counteracting COVID-19 and other diseases and crises caused by or connected with such situations will introduce the importance and the concept of remote work. So we had many questions and phone calls how to arrange it. We've had many questions and phone calls about obligations and arrangements that should be done by the employer and employees. So because of lack of time, I will focus on what employees and employers need, and that is again based on the pandemic situation. Since March 13 last year, Poland the territory of Poland fell under the condition of a pandemic, and Article 3 of that law introduced that option of working remotely in a location other than ordinary and usual place of work. That provision did not apply for a very long time because it was expanded in June 2020 with some additional concepts which indicate obligations and duties of employee and employer working remotely. As for the entity to whom this provision is addressed, well, that can be any employee, any team, but note that when the type of work is appropriate, well, that cannot be a production group working on production and using specialized technologies, which cannot be used at home or which are prepared by employers. In some instances, for technological reasons, such work is not possible. When it comes to the duration of remote work, so directing an employee to work remotely, there are no specific time frames imposed by the legislation, but it would be a predefined period because the legislation applies throughout the pandemic and 3 months after the pandemic. So in its current shape, we only have these borders or these concepts here. And when recommending remote work, employer may at all times extend or reduce the period of working remotely, or an employee may be dismissed from or recalled to the office. Such remote work doesn't require justification or a rationale. Right now we're in the 4th wave and the number of infected persons is growing. So obviously the employer doesn't need to present the grounds for such decisions because that is justified by life and our operational conditions. And as I was saying, that instruction to work remotely under that legislation says that this is the instruction to work remotely on the basis of the terms of the contract. So it doesn't require termination of employment contract, doesn't require a change of the employment contract, and doesn't affect the amount of the salary. But if an employee refuses without proper grounds, may face consequences based on a labor code or arising from the labor code. Then we have certain HSC rules that apply to remote work, but I think that this issue will be cared for in the labor code and I'll speak about it more when presenting conclusions. Now about the workplace. Well, the remote workplace can be performed remotely at the employee's home or house or place of living, but note that before such instruction to work remotely is given to an employee, the employee must present us with their family and housing condition. It is not that everyone lives in a house or in a flat that would allow us or offer us proper conditions for working remotely. I remember watching a film made by a US-based professor. That film was very popular on the internet. The professor was speaking about the very serious issue, and then all of a sudden his children marched behind him and in full view of the camera. And that is actually nothing extraordinary in it. That only reminds us that we work from home and that we perform remote work. Also note that when it comes to the purely practical aspects of remote work, how would the employer check or control an employee working remotely? Here we have a number of methods. There are methods to confirm or presence or check presence of the employee working remotely, so I can log on to the server, on the internet, etc. And similarly, remote work instructions are sent. That could be sent through a social media communicator, by telephone, by email, in writing, etc. We represent supervisory bodies, and we always recommend a written form because this is the safest form when it comes to evidence and proving evidence later in court. On a daily basis, I see that the provisions introduced because of the pandemic they are applied, and they are applied successfully. Also, because we haven't received any complaints or interventions that come with remote work. So both employees and employers emphasize the ease that accompanies provision of such work. We also strongly suggest or recommend to employees to introduce remote work. And I checked the statistics, and it was in 2020, and that's the data published by the Eurostat. 8.9% of all employees employed in Poland worked remotely. This year, the percentage is even higher, 14.7% in the first quarter and 11% in the fourth quarter. Well, I think that because of the summer and alleviated or slightly lifted restrictions, I think that the number was growing, but in the view of the growing number of infections, the fact that people can and may work remotely would be a big relief. I thank you very much for your time. I thank you very much for your presence. So I have many materials, and I'll be very happy to help and present them to you. But I understand that you've been here all day long, so I was trying to cut my presentation short. And I strongly consider the fact that you may be simply tired of listening, being here for so long. Ladies and gentlemen, we're 10 minutes after the allowed time slot, but considering the fact that we started late, perhaps there are some questions from the floor, there are some questions from our internet audience. I can see that Professor Duraj has a question. Dr. Maniewska.
Proszę bardzo, panie profesorze, zapraszam.
Thank you very much. I have a question to Madam Inspector. In the context of remote work, what was missing in my presentation was, well, I know you had limited time for your presentation, but I'm curious in the following. How do you assess observations of various regulations, and what are typical irregularities in observing the legal regulations in the remote work? How do you monitor employers from this perspective of observing regulations? What is the efficiency of inspection carried out by the Labour Inspectorate? So any remarks perhaps here? And now Dr. Maniewska, can we combine the answers? I don't know. I'd like to refer to the presentation by Justyna Czerniak-Swędzią and Dr. Ewelina Kumor-Jezierska, so two speakers from Kraków. I just wanted to say that a very important supplementation to the studies that you are conducting is an institution of social safeguards. So I'm talking about long-term care. And there is a great system in Germany, and I'm very much interested in that. And there are publications by Professor Lach. I think there is no other way to solve that reasonably than just, well, simply the state intervention is necessary. And the state needs to create a special institution, simply an insurance institution. In Germany, it is a kind of social insurance, not like in Poland, because in Poland it is just, I don't know, a social benefit, a social allowance, which is very low in its amount and absolutely insufficient. And I guess it should evolve, in this direction, like in Germany, because there are ready-made solutions, so to say. We would have to just adopt them. But I would say it is misunderstanding to recognize invisible work, like you did it, referring to the concept of autonomous concept of employee in constitution, because there is autonomous concept of work in a constitution, and there is also autonomous concept of worker in the constitution. It is something else. I fully agree it is also work. I fully agree with that, but I do not agree that it is a worker in the constitutional sense, because who should we turn to if we have claims about healthy and safe working place? It is guaranteed by Article 66, paragraph 1. And there is a question to Madam Inspector. How, on the basis of your practice, because, well, in your practice you have an obligation, or let me rephrase it. Okay, in remote work, people often work with screens. Do employers take it into account that we as employees cannot work all the time with screens? We can't do it 8 hours a day. Employers very often do not understand that people need to move away from the screen, from the computer, now and then. At home, people may start doing some other home chores, and an employer may perceive it as not maintaining the relation with work. There's a question from Professor Włodarczyk on the chat. That's the last question, because our time is limited. So the question from the chat. Thank you. Can you hear me? Yes, yes, we can hear you. Yeah. Good afternoon. Maybe it is not a question, maybe it is a remark to presentations we have heard so far today. First of all, the presentations, especially by Professor Rao, but also by Dr. Florczak, by Dr. Czerniak-Swędzioł and Dr. Kumor-Jezierska, and also the presentation by the Romanian professor and the professor from India, so evoked my reflection. I'm also referring to previous speakers like Professor Menegatti. So, what I wanted to say. Let me go back to the title of the conference, Employee-Employer. We are looking for differentiating features, and from my perspective, it is an economic problem. If we try to answer this question, the answer is somewhere in the economic sphere. Let me refer to some remarks connected with the decision of the European Court of Justice. Court of Justice of the European Union, they are very cautious. Definitions of an employer are based on national practice. The question is, why is that so? Because adopting this or that definition is an economic matter. An attempt to interfere by the Court of Justice of the European Union in the definition of an employee in a given country is a very important economic decision, because it means that either you impose these or those obligations on employers, or you do not impose any obligations. So the Court of Justice needs to refer parties to the practice, which is like domestic national practice, because the court always makes these reservations. Check your national practice, whether they use the word worker or employee, they always do that. I guess there will be a slow process of unification of this concept in the European Union. ILO is working on that on a global scale, but on a European scale, I would say that such a reflection or such reservations are always made. It is an economic matter, it is an economic decision, and the law has to follow that. Professor Rao has mentioned that entrepreneurs or social partners, but mostly the party representing or the side representing the interests of enterprise, will take care for flexible forms of employment to remain in place. We are trying to translate it into legal regulations. And what is our goal? Our goal is of two kinds. I've mentioned that during my lecture. It is to look for the title to provide social protection to the employed. What kind of title, what kind of mandate will it be? Well, and then another issue, a title to impose responsibility on the employing party, employers or the employing party, employing entities to incur costs of the social protection. So these are two goals. We have to bear it in mind. One more remarks, I guess, connected with my reflection, connected with Dr. Eliza Maniewska and her statement yesterday. She mentioned human rights in the context of social rights. Well, that's my perspective. Social rights or the struggle for social rights, well, it started in the 19th century when workers, through trade unions or individual workers, started to fight for their entitlements, for their rights, for their wages, for shorter working hours, for protection of women, children. As for children, maybe there was a different source of the struggle, but anyway, human rights appeared later, the ideology of human rights. And we have to remember that if we talk about social protection, about social rights, we have to be aware that these are very specific issues. It is not a general idea that people of work need such and such social rights because it is connected with human rights. No, people of labor, people of work need something specific, like decent wages. If they get that, they are pleased. They need the right working time, the appropriate work-life balance. And if these specific rights will be implemented, the people of work will say, all right, we are satisfied, our human right to a dignified work is realized. Human rights appeared later. First, there are specific solutions. And one more reflection, again referring to Dr. Maniewska and her statements about using the concept of employment law. I'm thinking about that because when I analyze this concept that Professor Gersdorf mentioned in her book, I'm thinking whether we should move from labor law to employment law. Well, from my perspective at the moment, using the concept of employment law, it was introduced mechanically, I would say. Namely, if it is employment contract, if it is employment relation, it means work. So non-employment contracts will be included perhaps in employment law. Professor, I do apologize. We have to move towards conclusions. So let's wrap it up because our time is actually delayed. We are delayed. Okay, so for me, I can see a certain danger of simplification because employment law is or has different connotations, has different network of notions and concepts. Employment is connected as organization of work, whereas work, in the terms of labor law, is a premise for protection of the employed. Thank you. Sorry for prolonging this session, but I believed it was quite important to mention. So I was just looking forward to this Q&A session. Thank you very much, Professor. I do apologize, we have to stick to some time limits. So perhaps Madam Inspector will be the first speaker to respond. Okay, I will try to give you an answer. First to Professor Duraj. In my presentation, I have mentioned that there were no complaints connected with remote work. Usually employees come up with complaints like that. They can turn to us and ask us for help. There were no complaints like that, but if we start an inspection, because the Chief Inspector of Labor is acting on that. Thank you very much. And now the last question. We are going back to Kraków, to our speakers from Jagiellonian University. Do we have a connection? We are waiting for the connection with Kraków.
Znaczy to już Eliza, to już może w późniejszym terminie, dobrze? Po prostu, bo już jesteśmy tak...
Do it later, Eliza, because we are already delayed. That's fine, you can do it in writing, you can send the question to Kraków, no problem. So, perhaps we have our colleagues from Jagiellonian University online. If you are online, could you give us an answer? If not, all right, so... Yes, we can hear you. Good. So, we are listening to you. We can't see you, but the audio is in place. So, brief answer, please. Perhaps I should do that. As for our topic in the context of some social protection, we know publications by Professor Lach. I would like to refer you to our paper that we wrote together, and I hope very soon it will be published, because it will be published very soon, and we give more details connected with our main topic. As for the attempt to define invisible work, an invisible worker or unpaid worker, as a worker defined in the Constitution, let me just say I do not fully agree with you and with your position. In our further research, we are going to make other attempts to prove that perhaps there is a chance to have a broader definition of a worker. And we want to focus more on the following, that perhaps there is space for people who do very valuable work in the social context. I am fully aware that there are constitutional relations about health and safety, but I think that we are moving in this direction, namely this definition of these standards should be broader. Maybe I don't want to call a person performing work, I don't want to call them a worker in a traditional sense or an employee in a traditional sense, but I will try to prove that there is space for that. I know my answer is quite vague, quite general, because it is not like I have clearly cut arguments, because we are at the stage of examining this topic. We are investigating that, but we'll try to come up with convincing arguments. So perhaps there will be a room for maneuver, there will be such a possibility here. Thank you very much indeed. So I understand that the next meeting will be held in Kraków, and then we'll try to answer that question more precisely. All right, I do apologize, we have to stick to our time limits, so we have a half-an-hour delay. So many thanks for the session, and we'll have half-an-hour break. Please be back at 2:30. Thank you. Thank you very much. For people who are here on site, have a good lunch. For others who are online participants, have a nice lunch at home. Thank you.
You want it. So first, I would like to congratulate the organizers on this comprehensive and holistic view and approach to the concept of employee and employer and worker. So if we look at it as pieces of puzzles, then we have certain regulations, certain concepts related to national labor law, and then we have also provisions of collective labor law. So I think that this panel is needed to analyze and have a grasp of that collective labor law. So in this panel, we'll listen to 4 panelists, but before I give them the floor, my big request is to remember about time constraints. Each has a slot of 15 minutes. I think it's a good slot for a fairly comprehensive presentation of papers. So I don't want to keep you like very disciplined, but I would like to help. So by way of assistance, when you reach 10 minutes of your presentations and you have 5 minutes left, I'll be showing you this sheet of paper with digit 5 written on it, just to remind you about this time discipline. So I think we can start with the first paper. Professor Irene Bajo Garcia from University of Alicante, the Spain Dialogue as an Answer to Technological Challenges. Professor.
Thank you very much, and good afternoon to all. First of all, I would like to thank the organization for the invitation, especially Agara Lucela for her implication and brilliant management and friendship. And I would like to say also that it's a pity that I am not in Rzeszow again. Next time, sure, we'll meet again. Okay, my paper, I'm going to share presentation. Can you see it? Is it okay?
Yes, we see it.
Okay, thank you very much. Okay, my paper talks about dialogue as an answer to technological challenges at work. And in the next few minutes, I will try to highlight, in one hand, that dialogue is particularly useful to address the challenges posed by technology, and on the other hand, the potential of technology for social dialogue and decent work. Obviously, it is not possible to address the issues surrounding dialogue and technology, so I will focus my presentation on 3 of them. Dialogue as a tool to combat the negative effects on labor rights of a transnational and micro-fragmented production system. Dialogue for the regulation and management of service provision through digital platforms, and dialogue for a reasonable use of technology, both by the employer and the employees. In all cases, I will try to provide examples and make proposals. In relation to the first question, it is well known that technology allows production to take place anywhere in the world and to be carried out by an exponential network of collaborators, whether in subsidiaries, small companies, or freelancers, in a fragmentation of work into tasks or micro-tasks. Obviously, the perfect situation would be that in the face of transnational and network production, there will be labor legislation and collective bargaining, but it is also transnational and network. But we know that this is not the case today. About legislation at the international level, hope is pinned on the legally binding instrument to regulate the activities of transnational corporations and other business enterprises, commissioned in 2014 by the United Nations open-ended intergovernmental working group, which includes governments, enterprises, trade unions, and civil society organizations from around the world. If adopted, it would be the first binding treaty guaranteeing access to justice and redress for human rights violations. But realistically, hopes of reaching consensus, especially in relation to its binding nature and protective effectiveness, are fading as the position of some of the negotiators, such as some European countries, is absolutely disappointing. So we have no binding international law, but is there such a thing as binding transnational collective bargaining? In this case, the difficulties are also considerable, among other things, because in transnational companies, strategic decisions are taken by a close core group, which is almost always far removed from the dispersed and diverse countries in which production takes place. These countries are diverse in terms of production, working conditions, risk prevention, recognition of trade union freedom and collective bargaining, etc. This diversity makes it extremely difficult to carry out collective bargaining on working conditions applicable all around the world. And if this is the case within a single company, it is even more complex to extend collective bargaining to other companies, suppliers, or providers, realistically speaking. Does it mean that there is no progress in terms of dialogue? The answer is no. There is dialogue at company and sector level. The most advanced is represented by the joint enterprises and trade union initiative of negotiating and signing international framework agreements, whereby companies assume the compromise to respect minimum labor standards, whatever the level of protection provided by the legislation of the country in which they operate. This has been for more than 4 decades, usually involving global union federations, and has culminated in hundreds of agreements. And similar agreements have been signed for sectors, a paradigmatic example being the accord signed in 2013 by the textile sector after the Rana Plaza tragedy in Bangladesh, currently in difficulties, as you are surely aware. A different question, more optimistic, is whether technology can help to extend and improve the effectiveness of these framework agreements and also international collective bargaining. And the answer is an absolute yes. Technology can help the election of workers' representatives in each of the subsidiaries, the constitution and meetings of transnational inter-center committee, the internal debate of demands, the coordination of strikes and other types of collective action, and so on. And once an agreement has been reached, technology can give firmness to the commitments and guarantee the control of compliance, and it can also help by providing transparency and traceability mechanisms in the value chain. So technology makes it possible to know at any time where, how, by whom, and under what conditions working services are provided, and it should be used for this purpose. More briefly, the second issue is digital platforms. Leaving aside the debate on the nature of the contract between the platform and the service provider, I would like to highlight the business tendency to commit to provide a certain degree of social protection, clearly insufficient social protection to those it calls its collaborators, no matter what is legally compulsory. For example, in 2018, Deliveroo decided to ensure its riders with a minimum level of protection from the moment they connect to the app until 1 hour after their last delivery. Or a better example is, as an example of dialogue, also in 2018, the United Federation of Danish Workers conclude the first collective agreement with a digital platform, despite the platform does not recognizes the labor nature of the contracts. In Spain, fortunately, the High Court has resolved the discrepancy in favor of labor nature of the contract, and that tendency has been absolutely reinforced by the agreement reached in 2021 by the social agents and the government, transformed into law, which in addition recognizes the workers' representatives' right to be informed of the rules contained in the algorithms and artificial intelligence systems used by the companies regarding working conditions. I must highlight that, in my opinion, this is a major victory for trade unions, which have long been calling for greater transparency and participation on issues related to algorithms, the very essence of digital human resources management, and which should be extended to any decision taken by any company that relies on artificial intelligence. The third question is that as technology is almost present in all questions related to human resources management, it is almost compulsory to reach an agreement within each company for the reasonable use of technology, the minimum content of which should address at least two major questions. The first one, the use of technology by the company for recruiting, for setting working conditions, fixing wages and obligations, for mobility, promotion, and even for dismissals among disciplinary decisions. And the second one, questions related to digital disconnection, remote work, training and fight against digital divide, management of the information obtained through technology, and in generally instructions for the use of digital services, and especially about social media, whether or not provided by the company. I have to say that I have not found a consensus document that brings together all these characteristics, of what I have found some partial examples. One is the Spanish consensual law 18/2020, which expressly provides dialogue with workers' representatives as mandatory for the development of an internal policy on digital disconnection. However, it must be said that prior to the law, companies such as Banco Santander or Telefónica, that maybe you know, have already reached collective agreements with workers' representatives with a global scope for all the subsidiaries. More generally, the same law provides that the workers' representatives must play an indispensable role in the elaboration of criteria for the acquisition, conservation, and use of digital devices. In addition, this consensual statement should encourage the signing of similar documents by other companies or professionals involved at value chain, and above all, contain elements that ensure that workers do not perceive technology as a threat, but as an advantage. For example, the company's commitment to negotiate and offer training before introducing any technological innovation, the creation of a digital whistleblower channel, anonymous and secure, allowing private use by employees and their families, providing not work-related applications for leisure use, and most relevant, essential, democratizing the data obtained through technology so that its benefits are bidirectional, thus workers and workers' representatives should have access to this data to be able to claim for improvements at work or to denounce abuses or non-compliance. In conclusion, the potential of technology for inclusion, diversity, transparency, data reliability, monitoring of working conditions, detection and correction of abuses, dialogue and negotiation is almost unlimited. So we must reclaim dialogue for technology and technology for dialogue. That's all from me. Thank you very much for your attention.
Thank you very much. I thank you very much for this inspiring presentation. The next presentation will come from Professor Yufeng Zhu from the National Jiangming University from Taiwan. And the topic of the presentation is collective bargaining of the independent contractor in the digital economy centers on Taiwan's Collective Agreement Act.
Okay, thank you very much. Can you see my presentation? Okay, thank you very much. I'm very glad to have the opportunity to present my ongoing research. And my topic is a collective bargaining of the independent contract in the digital economy. And maybe I will have time to introduce the Taiwanese Collective Agreement Act. Okay, and in this conference, we have already talked a lot about the concept or the definition of employee and in the meaning of contract. And today, I think my point is what is our concept of the workers in the collective labor law, and especially in the digital economy. And if I have time, I will introduce the idea and the model, and also the regulation of the Taiwanese Collective Act. Okay, first of all, I want to explain what I want to argue the point. Yes. So in this conference, we talk about a lot. Do we need a new definition for the employee, and or should we do we need to modify our concept? And this discussion we have since 2 days. And then the problem is when we try to define what is an employee, and we have many different kinds of a definition, and also in the context of different national regulation, we have the same problem. The workers may be misclassified as an independent contract, and then we maybe have the definition, but when in an individual case, they might be misclassified as well. And then in the individual case, it's also very difficult to identify is they an employee or not. So what I want to emphasize is it's not only a problem to have platform workers and the platform operator as this kind of difficulty and a problem we have already discussed since 2 days. So now my first research question is not to repeat the question again, but want to ask another question. Why should we define an employee? What is the importance to define the employee? I think we also talk about the social protection. We want to find who is the object we want to protect, and then we have the national or international regulations, and we provide the social protection for the employee. So that's the reason we need to find the object first. But many speakers in this conference has already mentioned that, for example, in France, in Italy, in Spain, or in Germany, there are already judgment that already confirm some types of the platform workers they are also employee. Yeah, but this is only some cases. And in many other countries, for example, in my country, in Taiwan, there are still that kind of disputes. For example, the platform delivery riders in Taiwan, they face the same situation. But every time when the riders pursue a lawsuit against the platform in Taiwan, they are willing to settle and pay the settlement fee. And then they will never have a case. They will never have a judgment. So we have many cases, but the cases is end up with a settlement. This is a problem. So this is not the effectual way to deal with that kind of case. So we cannot only to wait for the judgment from the court and then to think if we can find a general rule from the judgment is very difficult. So in addition, we also see some other legislations in some countries to say, do we need a third category of the employee, just like the employee-like person? And for example, in Germany, we have there is already that kind of a regulation, or the AB5 test in California. But the problem is, again, the legislation process in different countries are very different. And so if we go back to my original question, why we use a lot of possibilities, maybe the judgment or the legislation, but the definition, we want to find who is the employee, but what is the reason to find it? If we want to justify the government, the state, to provide them the social protection. So maybe we can have another way to think about this problem. We need to find who needs the social protection. Is only the person with in the subordinate contract needs the social protection or not? I think this is the first question. I'm still thinking about it. But here is my assumption. If the legislation provides the minimum working condition and they have the basic guarantee for a working place, then for the employee to have the collective action or to have the collective bargaining, the motivation will not be so strong. Yeah, so go back to my topic today, collective bargaining of the independent contract is just on the contrary. If the legislation provides the typical employment, the employee already like a minimum wage or the working time protection, something like that, or social insurance or occupational that kind of protection, then they don't have the motivation to join a union and then to initial collective bargaining or even to strike. But for the platform economy, for the platform workers, or especially the platform delivery riders, is just on the contrary. So we see in this picture, there are already many platform workers around the world. They have already collective actions, especially in Europe, but some also in the United States, America, and also in Asia. In some then is in Taiwan. So here, I want to say is maybe another way to think about the topic is not the subordination, but the social protection. How can we guarantee the social protection? Another way is not to direct legislation to provide the minimum working condition. But I want to say I'm not against that kind of way. I also think the state had to take some responsibilities and to make some legislation, but we also have that kind of disputes, though. So we have to think about another way. And for the platform workers, they are just the group. They don't have in general, they don't have the social protection from the legislation. Then they are the people who have the motive to join labor union and to initiate collective bargaining, and then even to strike, just like this picture shows here. And then from this point, I want to take the legislation in Taiwan as an example, because when we are thinking about what is our concept of the employee in the collective labor law, it must be something different from the individual labor law. That's the reason why we need to discuss. And in Taiwan, we have a labor union act. It's very, as I know, in European countries, many countries don't have a regulation and for the labor union. But in Taiwan or in many Asian countries, or also in Japan or in Korea, we have the act, and then they regulated what kind of labor union you can organize and which kind of right you have to for the labor unions. And in Taiwan, the Labor Union Act, they regulated, there are different kinds of a labor union, and most of the unions here are company unions. It's different from the industry union in Europe. We have many company unions, but for the platform workers, it makes no sense to join a company union because they may work at the same time for two platforms. Or they may work for one platform today and tomorrow they change to another platform. The flexibility is the character of the digital economy. You can change your job very quickly, and maybe you have the so-called freedom to choose your working time and working place like that. So in Taiwan, the platform workers, the riders, they don't organize a company union, but occupational, or we call the craft union. That means if you have the same professional, just like you are a platform delivery rider, then you are in the same occupation. Then you can organize a union. And then in this union, you can bargain many different of conditions with the platform operators here. And the point is here, according to the regulation in Taiwan, it doesn't matter you are an employee in the meaning of a contract, or you are self-employed, or the so-called independent contract. It doesn't matter which kind you are qualified as the employee or inter-contractor. You can join all of that kind of workers. You can join the craft union, and then you have your own union. Maybe you don't need to join the traditional union and then work with them together. You can have your platform workers union here. And I want to emphasize here, you can see in the regulation in Taiwan, the point is the regulation is a response to the economy independence. When we talk about the subordination, we also we emphasize the personal independence. But for this point, is the economy independence, because here we want to emphasize they have the social protection, and we need to find who need to pay for the cost for a social protection. If we want them to have a higher level of the wages, we want to have the overtime pay, that who needs to pay the cost. And then in this regulation, if you join the trade union, is in my next slide, the logic here, if you join the trade union and the type of corporate union in Taiwan, then the union is defined as the insurance unit. Then the platform workers can also join the social security system at the same time. So if we argue the labor insurance or the social system also applied to the platform workers or not, is different in different countries. But in Taiwan, we have that type because this is the response for the economy independence. And I want to emphasize the difference from the individual labor law and collective labor law, because if we say the state need to have some legislations and to regulate the minimum wage, the working time, that means this is already the working condition regulated in the law. But for the collective labor law, if they have a right to organize a union, they have a right to initiate a collective bargaining, that doesn't mean they will get that kind of protection at the same time. They need to organize a union first, and then they have to initiate a collective bargaining. But the platform operator, they may want to, or they may not want to bargaining with the union by the platform workers. So I would say this is a different kind of protection. So we also need a different kind of concept for the workers in the two systems, labor law two systems here. So from my point of view, is in the collective labor law, the workers only have the right to organize and then to have a collective action and then to ask for the platform operator to have to negotiate to have the bargaining, but they don't know what will happen in the end. Maybe they will try again and again, and then they get nothing. This is also possible. But this is a character of the collective labor law. They need to have their bargaining power. The individual platform worker doesn't have it. That's why I think it is also the justified that the legislation allows them to have their own union and also to have a collective agreement. Okay, so my last point is in this protection, they have a right to do that. But if we say they have the freedom to have a union, they have the freedom to initiate collective bargaining, is far from enough, because it's only a freedom. But we have to say, we need to say they not only need the freedom, but also the right. If this is a right, not only a freedom, then the legislation need to provide some protections. Also, the code, they have to offer some supporting system to support them to the right. So my last point is, in Taiwan, we have another model. I want to introduce, to use my last few minutes. We have a system against the unfair labor practice. Maybe in Europe, we call the union busting. That means the employer or the company, they will use any kinds of a possibility to destroy the union and to prevent the workers to join the union or to join the collective bargaining strike, anything of that. I just read a news today in Germany, the delivery riders, they have a strike, and the platform operator have just terminate or a contract. This is just a news today. So if we say they only have the freedom, it's not enough. They also have the right, and the state need to offer some protections. So the legal system in Taiwan, we have the unfair labor practice, and also in the Collective Agreement Act. That means the employer or the platform operator, if you have the power to control the working condition, even you deny you are the employer, but you control the working condition, then you have the obligation to negotiate, to have the bargaining with the union. You don't need to have, you can say, you don't need to accept all the from the union, but you have the obligation to negotiate with them, and then in a good faith. This is this is a minimum obligation for the employers. So this is I want to, because the time is very limited, I can just address the framework of the whole regulations. So let's come to my conclusion is, we need a different kind of concept. It must be broader than the concept in the individual labor law, because the need or a response to the independence or the protection is not the same. And then take the Taiwanese legislation as example, and the independent contract also have the right, not only the freedom to join the trade union, and then they can in a union to initiate a collective bargaining, and the state also provide a system to support that kind of collective rights. Yeah, so maybe this is another kind of possibility when we argue for a very long time, for years, where is our employee? Maybe another way is we empower the employee to join the union, and then they have their own agreement, and they create their own minimum working condition. Maybe this is a possibility to solve a small part of the whole disputes in the digital economy. Yeah. Okay, that's it. Thank you for your attention. I'm looking forward for your comments and all the questions. Thank you very much.
Thank you, Professor, for your Proszę Państwa, kolejnym referentem jest
Now the next speaker is Professor Kowalczyk from the University of Warsaw, and he will talk about representation by trade unions, by representation of non-employed persons by trade unions, theory and practice. Thank you. Ladies and gentlemen, I was on this side and now I'm on the other side. Well, the previous presentation, I think it's a great introduction to the topic which I would like to present to you. And other speakers covered that topic yesterday. We also had that distinction of the notion between work and employee. So far, collective labor agreement, collective labor law was approached in the context of labor code, which I think is fairly obvious for the Poles. And it turns out that our debate yesterday and today, also in the sense of trade union freedom based on the EU law, show if there is this context of term worker use, Polish translation it turned out to be quite doubtful. Actually, I had the pleasure to work for the International Labor Organization in Geneva, and I remember analyzing at that point in time the documents, and I understood that this is the direction that we should be taking, and that is clearly based on the concept that restriction of the right to association was not sufficient. And in theory, one would think that the decision of the European Court of Justice should have been swiftly introduced to the labor code, but unfortunately it wasn't the case, and only a few years later the Act on Trade Unions was amended, and this amendment was not that clear-cut and obvious. Last week I spoke to some colleagues who are experts in the competition law, and they struggle with cases when there are independent entities with the right to associate, but there is always this threat of breaching the principles of competition. Dr. Maniewska covered the concept nicely, and here we have just clearly cut out decision, and the decision states that every single person who works with their own hands, so without the intervention of third parties, is approached as an subject to the right of coalition. There are also some other laws, like for example the law on the dissolution of a collective agreement, which is quite interesting because some say that the rights of employees they are transferred onto other members of the working group. Now the question is about the meaning of that. Note that we need very clear-cut understanding of the regulations. Article 7 of the trade union law provides that trade unions represent all persons who work for it, irrespective of their association, be it a good decision or not. So anyway, these trade unions, they represent everyone. And in practice, since I've been handling all that, there are expectations that employee benefits are transferred onto me because of that representation.
W sprawach
So, in
indywidualnych
individual
dotyczących
cases
wykonywania pracy
related to
zarobkowej
performance
związki
of work
zawodowe
for a fee,
reprezentują prawa i
trade
interesy
unions
społeczne.
represent
A na wniosek
rights
niezrzeszonego mogą
and
go reprezentować.
obligations of
Tradycyjnie
their
rozumienie prawa
members.
pracy, bo to głównie będzie miało
And that
znaczenie,
is
no
the
jeżeli
traditional
mamy kogoś zwolnić z
context,
pracy,
because if we are to make
wypowiedzenia
someone
umowy
redundant,
bezterminowej, to związek
termination
zawodowy
of
musi mnie reprezentować, jak
undefined
jestem jego członkiem,
contracts
a jak
requires
nie jestem, to może. Chociaż też są
representation.
oczekiwania, że dlaczego mieliby mnie nie
But,
reprezentować. Nie ma takiego obowiązku.
and
Więc tu mamy sytuację dosyć prostą przy pracownikach. Ale co się
so
dzieje,
with
proszę państwa, jak
employees,
nie mamy
that
pracowników?
case is clearly
I tutaj
is fairly clear
przesądza o
and
tym artykuł
unambiguous.
23 z
But then
indeksem
we have
kodeksu
Article
pracy, który mówi, jeżeli
23
przepisy
of the
prawa
Labour
pracy,
Code, providing that if the
czyli tu już w
provisions of
kodeksie
the
pracy mamy
Labour
jednoznaczne
law,
przesądzenie,
so
że
here we have
nieprawdą
that
jest, że osoby
clearly
niebędące
stated that
pracownikami
this is
będą miały
not true
uprawnienia
that
w kodeksie
persons
pracy,
who are not
bo musiały
employees
mieć
will
tego
have
uprawnienia
rights arising
bezpośrednio z
from
konkretnego przepisu
the
kodeksu
Labour
pracy.
Code because
Mówimy
their
teraz o prawie
rights
indywidualnym, bo
would need to
przed zaraz
arise
przejdziemy. Czyli nie ma
from
automatycznego
Labour law.
przesunięcia.
So there
W
is
związku z
no
tym, co to oznacza?
automatic shift here.
Wypowiedzenie,
So that
rozwiązanie
means
umowy
that,
z tym
termination
samozatrudnionym zleceniobiorcą
of a
w żaden
contract with that,
sposób nie mieści się w kategorii uprawnień
self-employed
związku zawodowego do
contractor
konsultowania tego. W
does
praktyce
not
może być sytuacja taka, że jeżeli byśmy chcieli negocjować
fall
rozwiązanie
within
umowy
under the
cywilnoprawnej,
authority
taka
here
konstrukcja dosyć
of the
specyficzna, ale załóżmy,
trade union.
to
If we were to
członek
negotiate
związku
something
zawodowego nie będący
here, a member
pracownikiem
of a
teoretycznie
trade union
może
who is not an employee,
zobowiązać drugą
in
stronę, żeby
theory,
na spotkaniu
may
uczestniczył przedstawiciel
obligate
związku.
the other party that there is a
Jako członek
representative
związku,
of
skoro
trade
związek ma
unions
go
present.
reprezentować, w tym wypadku może taka być sytuacja.
at
Ale to nie
the
jest
meeting.
działanie urzędowe. Czyli
But
to nie jest
this
tak, że
is
związek
not an
zawodowy może to
official
w jakikolwiek
action.
sposób zablokować, bo tak naprawdę nie ma żadnego pozytywnego przepisu, który by...
But actually there is
z jednym
not a
wyjątkiem,
single
o którym za
positive
moment
regulation
Państwa
here,
No i teraz
except
mamy
for one which I will cover in a moment.
rozgraniczenie.
And then we
Uprawnienia
have that
indywidualne, czyli
differentiation
trzeba by było
between
znaleźć w kodeksie pracy, w
individual
jakimkolwiek innym
rights,
przepisie
so you
prawa
would
pracy
have to go
uprawnienie
to
związku
the
do
Labour Code or
reprezentowania.
any
Już
other type of
wykraczając, szybciej powiem,
legislation.
ciekawa
And
konstrukcja,
just
działacz
jumping
związkowy
ahead,
nie
let me
będący
explain
pracownikiem i sposób rozstania
that
się.
this
To jest
that
mistrzostwo
sounds
świata.
really funny to
Odpowiem
have
Państwu
a
tak, już w tej
trade
chwili
union
się pojawiają
activist
pierwszych
who
moich
is
klientów
not
działacze związkowi nie
employed.
będący pracownikami.
So who
No
are
i teraz
these
zobaczymy, jaka
trade
będzie
union activists who are
konsekwencja
not
chęci rozstania się z tym
who are not
samozatrudnionym.
employees? So let us check what
Zgodnie
is
z
the
przepisami tam cała
intention
procedura analogiczna zbliżona do
about
tego, co wynika z
parting
prawa
with
pracy
such
działa. Więc
employees.
odpowiadam,
But
to
we
jest
have
dopiero
the
początek,
entire structure
ale nie ma
here.
żadnego innego
And this is
pozytywnego
only a
przepisu, który by
start, but
zakładał,
there isn't
że
a
w zasadzie
single positive
indywidualnych
regulation
uprawnień
that
związek
would
zawodowy ma mnie
assume
reprezentować.
that
Natomiast
I'm supposed to be represented by trade
powiedzieliśmy
unions
sobie,
on a
że
case-by-case
związki reprezentują
basis.
wszystkie osoby
But we
wykonujące
also
pracę
said
zawodową.
that trade unions, they represent
W
all
związku z tym
persons
kontrolują przestrzeganie przepisów. Tutaj już było wielokrotnie
for a
chociażby
fee, they
przepracowano
control,
do kwestii BHP. Tu akurat
that,
tam kodeks
they
pracy zawsze
control
przewidywał, że
compliance.
BHP-owskie kwestie
And
dotyczą
here,
nie tylko pracowników. Więc akurat w tym zakresie nie ma
actually,
wątpliwości, że
there
związek
was this
zawodowy te
provision
osoby
that
reprezentuje. Natomiast, i to jest w tej chwili, proszę
HSC
Państwa,
regulations
ciekawostka,
that
pojawia się
they only
możliwość
apply to
zawierania
clients. But what is
odrębnych
interesting,
układów
there is an
zbiorowych
option to
pracy
enter into
dla
separate collective
niepracowników.
labor agreements for
Możemy sobie wyobrazić, proszę Państwa,
non-workers.
dwie możliwości. Jedna,
And there
że
are
jest
two
to
options
odrębny
here.
tylko dla tych osób.
One that this
I
is
druga,
a
że w
separate option for
układzie
these persons
zbiorowym
only. And
my
another
dajemy
one is
uprawnienia
that
niepracownikom.
under
Z
the
tym, że,
collective
proszę Państwa,
labor
to nie jest jakaś
agreement, we
filozofia,
give
może
power
tutaj
or the
przejdziemy, ponieważ już w
authority
tej
to
chwili
employees.
można było w
And
układach
this is
zbiorowych
not
pracy wprowadzić uprawnienia dla niepracowników.
difficult because
Ponieważ
one
przebadałem
could
ponad 500
do it.
układów i to mogę odpowiedzieć
Because I
tak,
analyzed
według
about more
starego
than
stanu
500
prawnego takie uprawnienia znalazłem, ale one oczywiście dotyczyły
collective
kwestii,
work
która myślę, że jest
agreements
w tej
I
chwili
found
będzie
in
tematem sporu,
such rights
zakładowy
in
fundusz
some.
świadczeń socjalnych.
And then
Ponieważ
there is
formalnie
this
zakładowy fundusz
in-company
świadczeń socjalnych
social
jest
benefit
źródłem
fund.
dodatkowych uprawnień
In,
dla pracowników.
on a regular basis,
prawa,
that
ale
is a
uwaga,
source of
sama
additional
ustawa zawsze przewidywała,
rights
że mogą
for
być
employees.
inne osoby,
But,
którym przyznano to uprawnienie.
According to
I tak,
the
jeżeli
legislation,
związki zawodowe
there could have been
generalnie
other
nie
persons
reprezentowały niepracowników,
who
to
were given that option.
Osoby, które nie są ich członkami, chciałyby to przekazywać.
So let's say if they represent persons who are not their members, well, they could do a lot here. And nowadays, trade unions requested broader authority of their of their courts or objects. Well, it seems that in that case, it will be divided into more persons than originally planned. And actually here, the first one, supranational Polish trade union emerged. But then if you read its documents, let me put it this way, that will be more a political organization than formal and legal organization. So what about our joint rights? We associate nurses, couriers, translators, taxi drivers, etc., etc. So actually, any shared interest, if we wanted to introduce it, is quite limited. So I don't think that these professions come from the similar sector, because usually you would come up with a sector or a branch of industry, but these professions, they come to different branches. And the trade union officially represents its members and fights to ensure fair, proper and transparent market employment conditions, requests that self-employed are contributing more, and we'll see how this organization is going to develop. We'll see whether they're going to have some exceptional supranational rights or authorities. So we indicate unfair or dishonest corporations, tax offices, etc., who abuse self-employed, and we are fighting against self-employed. Well, we were fighting for self-employed having summer vacations. So to sum up, we check our our options here, so I wouldn't exaggerate here. Well, it's not a trade union in the standard sense of the word, so that would be an organization that lobbies and supports actions and activities. But here we're talking about employment and not about work, because when trade unions automatically represent all employed, so that connection, that relationship is automatically implied. So can the basis for employment be the basis for differentiation? And 2 days ago, I spoke to the management board of one of the banks, and banks used to have many employees that could enter into such contracts, and labor law foreseeing the rights of trade unions calculates them for all the employed, and a trade union must represent at least 5% of employees. So that is the third definition of representation. So answering your question, even large trade unions of those who are employed will not have an impact on the labor law unless they have more than 5% of the staff, but they spring in every single negotiations, because the legislation was enacted in 2019, but emerged not that long ago. We don't have much experience connected with that, but I think it's a matter of time. Thank you.
Profesorze, dziękuję również za perfekcyjność.
Thank you, Professor. You were perfect in terms of time limits as well. And now it's time for the next paper. It will be delivered by Professor Joanna Unterschütz from the Highest School of Business and Administration in Gdynia. The title is Mysterious: Who Works at Home? Professor, the floor is yours.
All right. Can you hear me well? Good. So maybe I'll just share the screen. I don't have many slides, so it's more to show you some concepts, etc. I was my apologies. I'm very bad at those technicalities. All right. So, well, first of all, thank you very much for inviting me here, for interest for my paper. And I'm really sorry I could not take part in the conference in person. Well, again, as Professor Stefański said, life is life. We can't help that. So, who works at home? Basically, the idea was to concentrate. The idea was to think about people who precisely work at home. And as we will see, we can't say that there is one general category of people, of workers who perform work at home, because they will probably fall into several or different definitions that we find in the law. And well, the subject seems to be more and more adequate given the fact that during the epidemics, and well, we can't still say post-epidemic, but still, work at home is starting to be more and more popular and more either welcome or hated by workers and employers. So, of course, this form of work will have also influence into collective issues, collective labor law. But first, I would propose to look through some definitions. Well, because I started with a question that I actually asked myself, who works at home? The first answer that comes into mind, especially after I couldn't say 1.5 years of remote teaching, that is my experience and of many of my colleagues, the first answer would be, well, everybody works at home, don't they? Well, obviously not. And the interesting thing is that I couldn't find the latest Eurostat data concerning people working at home, but it shows that, well, there are not so many people working at home, really. It could be 10% or 11% maximum if we say that these are people who work sometimes at home, and people who usually or normally work at home will be more or less 5.3%. For Poland, the data is more or less the same for many, many years. It was 5%. Only in 2020, the number rose to 11%, and then in the second quarter of 2021 to almost 90%. But it seems that it is, actually falling. So, well, certainly not everybody works at home, but probably it's a visible number of workers. So the next question should be, well, we are talking here about employers, employees, definitions, which is always very important. Then we should ask ourselves, who actually, from a legal perspective, will be person working at home? It could be, well, very often when we look at the documents, that especially English language documents, we will see teleworkers and remote workers, and sometimes this means the same and sometimes this means something else. But still, I put here teleworker, but it could be also remote worker, which would, to simplify it to the maximum, be the person employed probably under employment contract who simply performs their tasks, well, not from the workplace, not at the workplace. Then we can have home workers. This is a specific category which is to a certain extent forgotten, but I will argue that probably we should consider this category for especially some types of work that are being performed at home. it could be a platform worker, or, well, it could be a platform worker, it could be a crowd worker, which is a category which is, again, not a monolith, and we did talk about it a lot during this conference. And finally, it can be simply an entrepreneur, a self-employed person who does not even consider himself, herself as an employee, as a worker. So let's look at the definitions that we find in, I wanted to say European documents, but actually international documents. Well, starting from Europe, we had a report of 2010, as far as I remember, or 2009, of the European Commission, who also consider the role of teleworkers, as they are called. And the report defined this group as you can see here, people who work from home. Well, more and less regularly, and people who use personal computers in the course of their work, or use telecommunication, phone, fax, email, well, whatever is available. But they can be either employees, but also self-employed. So we have a category of people who not only work at home, but also use the computer, use new technology to perform their work. Then we have framework agreement of European social partners when telework, because this term is used, telework is defined as a form of organizing or performing work using information technology. So we have this element in common. In context of employment contract or employment relationship. So definitely here, the framework agreement concentrates on employees who work from home and again use new technologies. Whereas when we look at the ILO Convention number 177, the definition is more ample. It is quite interesting that in the Polish language translation of the convention, there is no term as, well, directly home worker or person working from home. The term used is nakładca, which sometimes is also used in well, not precisely legal language as chałupnik, which means a person who performs work at home. And this work has quite defined character. So the person has to basically produce something. It can be some material goods, but it also can be, well, non-material goods, as, for example, also some type of computer work. But this form of work, as we could hear yesterday, is not widespread anymore, but we have to consider whether this definition would apply to, well, quite a large group of home workers or people working from home. Because as you can see here, it is a person who works either at home or other premises of their choice, which is very important because here we have the premises of their choice other than workplace. So who is to decide about the place of work? The home worker. And of course, the work is done for remuneration and there is some kind of product or service specified by the employer. So this definition does not concentrate only on using new technologies, and it doesn't concentrate on the form of employment, rather on the fact that work is being carried from home. So if we, perhaps I'll do that, if we come back to our first table, we could see that it can be home worker, it can be teleworker, it can be platform worker, but not necessarily an entrepreneur. In this term, I would actually have some doubts, but this term, as you can see, covers all 3 categories, whereas the European category would cover only teleworker working on the basis of employment contract, platform workers. Well, we had a lot of discussion about that, and not really home worker if it is not a contract of employment. Looking at the national definitions that we have, well, we have definition in the Labour Code, which concerns telework. And here we can see that it is quite similar to the European definition, to the European Framework Agreement, because we have here person employed on the basis of employment contract, which stems from the fact that that it is regulated in the Labour Code, not anywhere else. Then we have the use of new technologies as a means to communicate with the employer. Then we have a definition from, as we call it, COVID-19 law, which is the law introducing some specific measures for the time of epidemic. And here also we have not only work being performed remotely, but this work is performed by the order of the employer. So it is not a choice of the worker, it is a choice of the employer to, we could say, send people to the remote work. And of course, we have the specific purpose of remote work in the form of preventing the spread of epidemic. And finally, we also talked about it. We have a definition in a bill to change Labour Code concerning the remote work, because the name changes. But again, we deal with employees, although this form of employment is more consensual, we could say, because there are many elements of the work that have to be negotiated between the worker and the employer. So that's what we have, and already we can see that the group that we can call home workers or teleworkers in the, I would say, more sociologic terms, will cover many forms of employment. There are many issues if we want to qualify a person, or if we want to put a person in a certain group. We have to ask what is the legal basis of employment, who decides that the work has to be carried at home, who decides on the working team or the working time schedules, who decides upon tasks, etc. And finally, who decides where to work, because it can be, well, outside the employer's premises, but perhaps the worker has the choice whether I do it at home, or I do it in my country house, or I just, well, travel abroad and do it on the beach. So what would be the impact, what will be the challenges concerning collective labor law and workers' representation? My colleagues already talked a lot about the implications of status of worker. Of course, well, I am more concentrating on the Polish situation, on the Polish legislation, and here we can see that, well, very oftentimes we will talk about employees anyway, but these implications, as Professor Kowalczyk mentions, are quite important. So first issue might be the status of worker, because depending on the status, the workers might have, as the previous speaker mentioned, different legal status on the basis of collective labor law, and they might have different rights, different privileges, or do not have any privileges almost at all. Then we have another issue concerning the very construction of functioning of trade unions in the Polish collective labor law, which says that the basic unit of trade unions operates at the employer's company, which might mean that, well, maybe sometimes there will be no trade unions. Maybe people who would like to create trade unions are just remote workers, but they might also have some obstacles in, well, communicating, finding common interests, as we could see in the illustration that the previous speaker showed concerning this self-employed trade union. I also looked at the documents. I also looked at the statutes, and I think that is extremely interesting, because for me it is more actually employers' organization than a trade union as far as their scope of activity is concerned. But well, we'll see how it will proceed. Then another challenge is contact between workers. Professor Bajo Garcia mentioned that the role of technology, and she mentioned that this technology can be used to facilitate communication, in fact, which, while I will agree, but also it may be an obstacle that people don't meet directly, because very often, well, as a social creatures, we develop trust, we develop the feeling of common interest by knowing people in person, by seeing how people are. And very often it is mentioned that the lack of direct contact is not an obstacle for the communication itself, but it may be an obstacle to create trade union organization. Then we have the issue of common interests, and well, this is something I already mentioned, because remote workers or, well, home workers might have the same interests as workers in certain group at the company, working, well, directly at the company, or they might have completely different interests. And we have to ask ourselves to what extent those different interests will be taken into account while, for example, negotiating not only collective agreement, but also, well, company regulations, for example. And finally, the issue of elections. This could be, well, both facilitated by the fact that people have access to new technologies, as again, Professor Bajo Garcia mentioned, but it can be in some cases also the obstacle, because people may be discouraged to take part in the elections when they actually do not know the representatives or future representatives in person. Well, to conclude, I would say that in the research concerning new forms of work and atypical work, very often the finding is that people who work not only part-time, not only on the basis of atypical forms of contract, but also people working from home are less prone to create trade unions. So the more people working from home we have, the more perhaps maybe or the less maybe trade union members we will actually have. Then, thing that I mentioned just a moment ago, this is the question of company rules, collective agreements, whether they will be adapted to the needs of this particular group, even if they are actually employees, not perhaps not really well, civil law contract workers. And well, Professor Kowalczyk did discuss the issue at length previously. And to just conclude, I would say that it might be the case that the more remote work we have, regardless of whether it is employees or workers or, well, any other legal basis of work, this might have an impact on the democracy at work, because by the democracy at work, we understand also social dialogue, also concluding collective agreements and other types of agreements. So I couldn't say that there is a threat to democracy at work by the very form of remote work, but it might have some negative impact. And with that, I will conclude. Thank you very much for giving me the floor. And well, the floor is yours.
I thank you for this very inspiring presentation. So I think we have some time for discussion. So I encourage you to ask questions. Professor Włodarczyk. Thank you. Well, actually, I raised my hand so quickly because I have two questions. The first one goes to Professor Yufang Xu. My question is about, well, actually it's a request for more detailed explanation, because you, Professor, pointed out that in the Taiwanese labor force, the fact that one is a member of a trade union is the basis for social insurance. Did I understand it correctly? So does it mean that an employee joins a trade union and then the trade union fights for funds to cover that person's social insurance? Is that how it is done? So it is first about employing an employee, and is that then the employer who is obliged to pay the premium, the social security? So did I understand it correctly? Because that would be a very interesting structure from our point of view. And the second question is about trade unions that were described by Professor Kowalczyk. Trade unions of the self-employed. We also have a similar structure in our law. These are trade unions of farmers who do have their own law, and we believe that the situation of these two categories of entities is quite similar. Thank you.
Czy można, Paweł Nowik? Paweł Nowik. Mam pytania do pani profesor Garcia.
So my question goes to Professor Garcia. Actually, two questions. So indeed, the Spanish solutions when it comes to employee protection with this algorithmic management, are these as far-fetching as those that you described, and what's your and can you relate them to the solutions of the European Parliament and Commission that that opposes them to the digital and automated concepts? But because these Spanish solutions are much more advanced than the European proposal. And then at the end of your presentation, you also mentioned democratization of the data. You mentioned the regulation in Spanish regulations, access of employees to data. So my question is about enforcement of that law in Spain. And then I have a question to Professor Yufang Xu. Initially, at the very beginning of your presentation, you had this very interesting question referring to the structure of power in the algorithmic management, and you asked whether that was a standard relation of subordination. Is that the standard relation of subordination? Or perhaps from your presentation, I could conclude that we should be looking for broader ways or options for social protection for the employees working on platforms. So my question is as follows: whether looking at the algorithmic environment management, should we look at it from the point of view of qualified forms of subordination? What's your impression? What's your perception? And what platform did you mean when you spoke about some types of protection required in Taiwan? We believe that there are quite many of these. And then you also said, madam, that Taiwan has a system of preventing unfair practices at the workplace. So my question is whether that system is based on public or administrative authority, or maybe these are soft measures such as trade union control. So this is the system preventing unfair practices at the workplace. Thank you. Thank you, Professor. Unfortunately, I do not see the audience, but are there any, the floor, but are there any questions from the floor, perhaps?
Bardzo proszę.
Jedno krótkie pytanie do pani profesor Yufang.
I have a short question to Professor Yufang Xu about subject-related limitations or restrictions here, because if I understood well, that you demand that the right of coalition applied to self-employed. So what are your specific restrictions when it comes to membership in trade unions? Any other questions from the floor?
Nie ma pytań.
No more questions from the floor. Excellent. So perhaps without further ado, some observations related to what we've heard. Generally speaking, the leitmotif of this conference is whether law should introduce equal position of employees and workers and other persons who work, who do paid work, or whether the persons who do paid work be given the status of an employee. Because this is a question which is not only related to the collective labor agreement, but it is important for the collective labor agreement when it comes to the limitation of or restrictions to associate in different countries. And then we have this development of technologies, and both in terms of on the side of employees and employers. So I mean specifically different forms of work and work performance. And as for about platforms and working for platforms, I remember when more than 10 years ago, I read about employment on platforms. This would be more rigs and rigs on the offshore rigs than regular platforms. But now I can see that with changes in technology, it change our perception of such important aspects like the independent and subjective or objective nature of an employer. So the first question is to was addressed at Professor Yu Fang-Xu. So may you please, Madam, answer this question. Thank you.
Okay, thank you very much for the many very interesting questions. And the first question is about the insurance system in Taiwan. And the professor, sorry. Okay. Yeah, and the professor, you have understood very well. It's correct. In Taiwan, the insurance, the first is the obligation of the employer. They have to insurance the employee. But the point is, if the workers or employee, they cannot find the employer or they are real independent contract, they still have the need for the social protection into the social insurance system. That's why our legislation provides this possibility. You can join the occupational or craft union, then you find a insured unit, and then the union have to make the insurance for you, and you have to pay the insurance fee. And I think 60 or 50% the workers, and no, 30% for the workers, and 30% have goes to the union, and 30% for the state. So I mean, the point is the social protection, the need is the point of the regulation. And another one is if you are work in a company, and the company has an employee less than 5 persons, then the employer has no obligation to make insurance for the employee. Then you can have the choice to join a union, and then you are also insured. This is for the first question. And the second question is about the power or the power structure. How is the algorithm? How does it work? And it's very interesting, because what I mentioned is not only the platform in Taiwan, also in other countries. And for my observation, there is last year in December, there is a judgment in Germany, and then it's a very interesting judgment. It explains that as a platform worker, you may think you have the right, you have the freedom to decide many things in your workplace, but indeed the algorithm or the platform operator has already designed everything, and you think you are making a decision, but not. You have no choice to refuse any request from the platform. So that's why I am saying it's very difficult to tell if you are in a subordinate contract or you have a real freedom to make your own decision. Then you are real independent contract. And I think the platform operator in different countries, they have a different kind of a system. But in this point, it's maybe it's very similar. You think you have freedom, but it's not true. You are under the control with the thing you cannot see. Yeah, there's the second question. And the third question is about the legal system, about the unfair labor practice, or we say the union busting. And this system is very similar like the system in the United States. But what is different in Taiwan is, in Taiwan, only the behavior from the employer are prohibited in this legal framework. But I know in United States, both the behavior from the trade union and also from the employer. So in Taiwan, because the union, the power is not so strong, we don't think they already have the power to do unfair labor practice and to harm the right from the workers. So the point is only the behavior from the employer. Okay, the last question is about the membership, about our trade union. And I just mentioned in Taiwan, we have a Labor Union Act, and then we have 3 kinds of labor union. One is a company union, the small, very small union. Another one is, I mentioned many times, occupational union. Workers from different companies can join the same union. Or we have the real trade industrial union. Okay, and the important is the membership, the restriction of the membership for the occupational union is for the three types of union is not the same. And very important for our topic is the occupational labor union, because this kind of union, the membership, they don't ask for subordinate this character. Only you have you need to have a job. You are working, and then you have occupation. Then you fulfill the requirement to join the occupational labor union. That's why the platform delivery riders in Taiwan now, most of them, they organize that kind of labor union. Okay, I think I have answered most of the question. If not clear enough, I can later, if we have time, we can talk about more. Thank you very much.
Dziękuję bardzo, pani profesor. Kolejne pytania.
Very much, Professor. And then we had questions addressed to Professor Irene Bajo-Garcia.
Thank you very much for the questions. I've been talking about algorithms, and I must say that I must distinguish between the reality and the desire. I mean, the real point is that nowadays there is a law that says that workers' representatives have the right to be informed about algorithms, but just about the workers dedicated to delivery or distribution of any consumer product or merchandise through companies. I'm reading it because it is literal. Through companies that manage a service by means of algorithmic management of working conditions. I mean, it's a very long name to say that this possibility is only thinking about this kind of services, this kind of workers. What I think it is that it is a victory for the trade unions for two questions. The first one, it is because this is a consensual law. I mean, enterprises organizations agree with this kind of information. So, and of course, this is the law. And there are not enough arguments to keep it just for riders. I mean, it's very easy to argue that this information is also important for making the workers' rights defense at any question, at any enterprise that uses algorithms. So I think in the future, it is not going to be very difficult to assume that that information and that participation of the trade unions deciding about algorithms will extend to the whole production, not only about riders, not only about platforms workers, but any kind of human resources decision that is taken under algorithms or artificial intelligence. And also, I talk about democratization of the data, but this is something that something that it is not at this moment as a legal regulation, but I think that is the one of the main things that the trade unions should fight for, because it is important that we know that data to know who works where, how long, in which conditions. This information must be on the workers' representatives' hands. And but I'm not sure this is going to happen. I think this. I'm a little bit techno-optimist. I try to be, and this connects also with something that our colleague Joanna. I'm sorry, I cannot say your surname. It's very difficult. Sure, if I tell it in Spanish, this is going to sound terrible. But you said that I agree with you that more remote work, less democracy, or less trade union. But what can we do? I mean, we cannot change the future. And so I think that we have to do with, if we are in the position of the trade unions, is try to be not so techno-pessimist, but more techno-optimist, and try to find a way to make the technology a tool for our positions. Because, for example, in Amazon, it's impossible to coordinate strikes in Europe, and it's made by technology. So I don't want to see technology only as something negative, but something that we can use for human labor rights. That's all. Thank you very much.
Bardzo dziękuję pani profesor.
Thank you very much, Professor. And I'm actually so happy that actually we concluded on the same note yesterday as for perception of technology. Our time is up, but I would like our speakers to have a moment to refer to that decision,
No cóż można powiedzieć, ponieważ w
to
pewien
that
sposób
opinion.
zostałem wywołany do
Or what can I say?
przez profesora Włodarczyka.
Professor Włodarczyk asked me to speak. Well, actually, we do have farmers' trade unions, but the specificity from a closer, when approaching them, shows that they're not the same in terms of their subject matter and and other aspects. But the future will show. But this is not as obvious as one may think, and there are some issues that come with that. So I believe that the next conference could be devoted to this topic, just to have an overview of trade unions formed by non-workers. And perhaps we'll have some patterns here. Thank you, Professor. So what you were saying during your presentation about sectors that form parts of form such unions, well, that's I'm quite curious about that, and we'll see. Well, the future will show the future fate of the trade unions and persons who are not employees. And last but not least, I would like to give the floor to Professor Joanna Unterschütz.
If I may just a short remark to actually answer my Spanish colleague. I would love to be optimistic about that, but I think that this positive change that you're talking about will probably come with time. Although we are, or I should say perhaps especially the younger generations are very familiar to using technologies to communicate, to work as well. It is not experience of everybody, so it can be in some cases a little bit discouraging. But with time, as the use of technology will be more and more widespread, as well as when the awareness about the technology, about the algorithm that rule, also the workplace to a certain extent will be more extended. I think that this we will have time, we'll have possibility to look at it more optimistically. So, just to end on a little bit more optimistic note, perhaps.
Bardzo dziękuję pani profesor. Oczywiście tych wątków, które...
Professor, and of course all these concepts that you presented in your contribution, there were quite many recently. I spoke with a journalist trying to find out about the impact of the pandemic and more next waves of the pandemic on social protests, in particular those related to the right to work. And clearly it is not easy to answer this question, so I wasn't even trying to answer this, to ask this question here. So I thank you very much for all your questions, for these fantastic observations and contributions, and I would like to thank the organizers for inviting me as the moderator to this panel, and I open the break. Thank you.
to the next session. I'm on the other side of the screen, but now I'm a moderator. Thank you for inviting me here. And yes, we now have a panel with plenty of speakers, and we have 6 speakers in this panel, and the subject matter will be diverse, I would say. And even though it is the last panel, it will be greatly interesting because we are going to talk about threats and challenges related to the concept of employee. So, from what I see, when I look at the titles of presentations, it is quite possible that there will be more information about how, or perhaps what challenges, what threats lead to some situations, special situations connected with employment, because we are going to talk about transgender employees, private life, social insurance, minimum wages, young employees, and new forms of employment. So I guess it is a good idea for us, apart from the main topic of the presentation that every one of you has planned, that we could also try and answer whether a notion of employee or worker has an impact on some special challenges or threats connected with your topic of presentation, or that's a matter uniquely related to a given legal situation. I don't want to prolong, so now the first speaker, Dr. Katarzyna Jaworska, the University of Warmian-Mazury, and Dr. Ariel Przybiłowicz from the University of Wrocław. So we have 2 speakers now, and they are going to talk about transgender and non-binary employees at work. So the floor is yours. Thank you very much, Professor. Ladies and gentlemen, we are very happy, together with Dr. Przybyłowicz, that we can present our paper here. Unfortunately, we are online speakers, so I guess I will switch off the camera because I guess that the audio will be better then. So, our presentation will be on transgender and non-binary employees at work. In our case, we carried out the studies not because these people are a separate category of persons that we can call employees or non-employees, no, but the discussions so far about the concept of employees do not really pertain to our paper. We would like to pose questions about challenges for employers who employ transgender or non-binary employees at work. The situation around us has been changing very rapidly. Time is racing ahead. The social situation is changing so fast. And we notice so many changes. 100 years ago, in the public discourse, there were questions whether women can vote, whether they are prepared intellectually to be able to vote, to have the right to vote. Today, there are different discussions whether certain groups can be treated equally on the grounds of social rights, on the grounds of the labor law and social insurance, because all these things are interconnected. So I guess what also motivated us is the recent EMGA Europe ranking, which checks the level of equal rights among LGBT+ persons in European countries, and Poland took the last place in the ranking. Unfortunately, what we hear on the mass media leads to the situation that transgender and non-binary persons have a very difficult situation in Poland. And they may face many challenges in their workplace, as well as their employers. So the dichotomy of division into men and women is undermined. It is said that a gender is a certain spectrum of experiences, features, and it is not only conditioned by biology. This opinion is presented in social sciences, and it is reflected in case law. So let us think about the European Court of Justice, Goodwin versus Great Britain. Sorry, it was about European Court of Human Rights. And it was precisely about criteria determining the definition of gender. Despite this verdict, the case or the case law, despite these facts, we can still see dichotomy about two genders in the majority of EU member states. There are only some exceptions, but basically that's the general trend. So, because transgender people and non-binary people were not defined on a normative grounds for the needs of our studies, we assumed that when we talk about a transgender person, we mean a person who corrected her or his gender, so took some steps in order to get closer with external look to the look typical of the gender felt by this person. Transgender person is a person in our studies for whom, of course, application an appropriate body corrected the act of birth into the gender which is felt by this person, which this person identifies with. It doesn't always mean correction of gender. These activities may be independent of each other. As for non-binary people, what do we understand by that? Non-binary persons include all gender identities which do not fall into the dichotomy into man and woman. So we believe that these are persons who do not feel either a man or a woman, or they feel to some extent a woman, to some extent a man. But these are also people who, from the perspective of a gender, are fluid. So sometimes they feel more like a woman and sometimes they feel more like a man. In the European international law, from the perspective of our studies, the most significant thing was regulations on equal treatment, especially equal treatment due to a gender. As for normative laws of international nature, European nature pertaining to these issues, well, these are numerous regulations like International Convention of Human Rights of the European Council, ILO Convention 156, but also the Charter of Fundamental Rights of the European Union. And I'm sure you know that in these documents, a gender identity is not mentioned. Transgender people or non-binary people are not mentioned there, but these documents use phrases like ban on discrimination due to gender or equal treatment of women and men. So it will lead to the situation. Well, we believe these notions have to be treated in a broader sense. These standards were formulated in the 1950s or later decades, but it should make us aware that the social and the political context was very much different. So, for example, let me remind you that in 1971, Swiss women received the right to vote. So, as we see it, these notions and these phrases have to be treated in a broader sense. It is not just the gender of a woman and a man, but also a gender of people who not fall into one of the two categories. In the labor law, of the Polish labor law, transgender non-binary people are not a separate normative category. What is more, legal situation of these persons was not regulated in any way in many countries. And it may lead to many complications. Also complications even at the state of looking for a job or at the stage of recruitment. According to the Article 20 of the Labour Code, there is a catalogue of the data that you may obtain about the employee. Gender or gender identity do not belong to this catalogue. However, if an employer has an obligation to fulfill a certain requirements of administrative nature, then they may demand, on the basis of paragraph 4, a bigger set of data, bigger amounts of data. And if a given person is to perform a certain task with limitations for the work of women, the employer may ask for identifying the gender. And then what the employer can do with the information they will obtain from such an employee, because names in the Polish language are divided into male and female names. At the stage of recruitment, it may lead to problems connected with discrimination, because in the documents presented by the candidate for work, you may deduce that it is a person of one gender, but during an interview, looking at this person, you can see it is the person of the other gender, or we cannot identify which gender it is. So it is quite clear that there are regulations on the prohibition of discrimination, but still we may have a problem. And ladies and gentlemen, even at the stage of recruiting for a job, there are very banal problems like toilets. Usually toilets are divided into two kinds of toilets for two genders, but is it necessary to have separate toilets for people who do not feel a woman or a man? What about comfort of employees who are used to the fact that their colleague from their work are of one gender, and after several years the same person has the other gender? Does it mean that this person should use the same toilet or another toilet, another cloakroom? So these are challenges facing employers, actually. Then another issue that an employer should take care of well-being of their employees. In our opinion, the employer, under their duties and obligations, which is even a rule in the labor law, should respect dignity of employees, has also a duty to shape the rules of good, or basically to respect and create the environment for good relations in the workplace. There might be another obligation of preventing mobbing in the workplace, because there is a big risk that people who are different might be victims of mental violence, psychological violence. So here we should consider that whether an employer employing a non-binary or transgender person has a duty to undertake some specific actions connected to that. In our opinion, this person should educate other employees, educate them on tolerant approach so that the working environment is comfortable for everyone. The majority of our time is spent actually at work, in the workplace. Hence, this need to do your duties and perform your tasks in a comfortable way, also in psychological, mental comfort. In our opinion, education is absolutely necessary, education of employees. If educational elements are not sufficient, if promoting positive approach is not sufficient, in our opinion, an employer may reach for some other tools from the code, starting from a personal responsibility of an employee. And then there is also such an extreme tool like termination of a contract of employment if a person doesn't follow the principles of cordial relations at work, and this person doesn't want to use the proper name of a new colleague or proper pronouns acceptable by this non-binary person. And then the employer may think about termination of the contract with this unruly employee in such a situation. Obviously, it is a very radical solution. On the other hand, also the person who doesn't feel comfortable in their workplace is treated badly due to their gender identity or gender difference, may also use various tools, may also terminate their contract of employment without a term of notice, because there is a special article providing that, and they may demand compensation. As we see it, an employer should take care of well-being of their employees from the perspective of health and safety at work. And there are some health and safety regulations which show that there is this duty of providing the right mental conditions, so to say, to perform your duties. It also shows how Polish regulations are, well, maybe not ambiguous, but there are more and more questions and there are not enough answers. Obviously, our time during the conference is limited, so we can't come up with all the answers as to the toilets and so on and so forth. But there are no clear answers, actually. But definitely we need education on that matter. And it is our suggestion. And the employer definitely faces many challenges. There are more challenges. And Dr. Przybyłowicz will take over.
Przepraszam bardzo, że się wetnę w Państwa prezentację, ale...
For cutting in, but you are running out of your time. So there was a very limited time slot. I will try to be very brief.
Tutaj taką funkcję stróża czasu, to pozwalam sobie na tego rodzaju wtręty. Oddaję już głos.
Dziękuję bardzo. Dzień dobry Państwu, bardzo mi miło, że możemy...
Very much. I am very glad I can participate in the conference. It's a pity I couldn't come in person, not this time, unfortunately. So I just wanted to add several specific issues connected with that. One of the aspects of the labor law which might be difficult, especially for transgender people, is certificate of work. It pertains especially to people who formally go through a gender correction procedure, and for many years they've been functioning under one gender, and then they move to the other gender in line with the gender that they feel identified with. And then in a new place, they want to present the certificate of work, for example, because they need, I don't know, a holiday, and they are obliged to submit the documents, and in the documents there is the old name, when they functioned as a person of the other gender, assigned at birth. And there are no obligations on the employers that in situations like that they should issue a new certificate of work or a just certificate of work upon the request of the employee. If there is a lot of goodwill of an employer, even if it is an employee who stopped working in this place many years ago, well, if there is goodwill, it may happen, but there is no obligation, there are no proper regulations, the matter may be taken to court. So we don't even know whether such a case would be taken up by the court, because the labor code gives some short deadline for the obligation of issuing the certificate of work. So it may be a problem for a person after gender correction procedure, because this person is actually forced to admit to a new employer that he or she is a transgender person. So this problem should definitely be solved, and not force the person who is transgender, for example, to do something that might be humiliating to them, to open up to the new employer and talk about very personal matters, namely being transgender. And then there is another issue for non-binary persons. As Dr. Jaworska was saying, they are neither a woman nor a man. And in the Polish law, you can say that there is no formal problem because there are women or men, but this problem may come from abroad. And we don't need to look far, because behind our western border in Germany since 2019, due to the verdict of the federal court, constitutional court, there are new regulations introducing 3 genders, men, women, and jokingly it is coined diverse. It is pun on words, diverse into English, so it is sometimes the name used for the 3rd gender in Germany. So these are people who formally say they belong to the 3rd gender. And another possibility is that documents do not include any information about the gender of the person whatsoever. Due to the freedom of movement in the European Union, we have to assume that a person with such an issue, such a situation, who formally have the third gender, they might simply come to Poland and they start to work in Poland. And then how should we treat them, especially in the places where the labor law differentiates between the situation of women and men? And here there is an employee who is neither a woman nor a man. So there are some problems here, some challenges, and at the moment it might seem theoretical. Maybe there is no practical case like that in Poland yet. But if we haven't had it yet, this problem will come up and we'll have to face it, and definitely courts will have to face it first of all, I guess. And let me move on to, very briefly, to social insurance. Gender is not a piece of information that the person needs to mention during the process of recruitment, but the employer will always have information about the gender because the employer is also the payer. As the payer, they have to send the data to the social insurance company, like information data to enter this person into the register. And if there is a form, you have to fill in some information and send to ZUS, which is the social insurance company, and there is a question about the gender there, woman, man. And the form has two options, woman, man. So if these are non-binary people, a problem occurs. How this person is supposed to declare their gender for social insurance matters. There is no other option, there is no third gender, there is no other option. And formally, it might be a person who is neither a woman nor a man. There are people like that. And let us take a step further. The social insurance law for certain benefits differentiates between the situation of a man and a woman. The easiest, the simplest example is the right to pension, old age pension, because in Poland there are different ages for women and men, like 60, 65. For transgender people, it seems to us that if a given person is after the formal path and on the basis of the documents this person is a woman or a man, we apply the regulations pertaining to the given gender after the correction. And there shouldn't be any problems there. But what about the situation when a woman has on old age pension entitlement when she was 60, and when she was 62 she went through the procedure of gender correction and became a man? What then? What then? Is this person still entitled, or should old age pension be withheld? Because then this person has become a man. Because if they are 62, a man would have to wait till 65. There was no court decision about that. I don't think there is anything like that. But it might be a problem. And again, I think it should be regulated so that there is a clear legal situation for people who decide to undergo this correction procedure. Perhaps not thinking about all the implications when they start the procedure, but then it may turn out that they are left without this allowance or this entitlement and they have to take the matter to court. Doctor, you have to wrap it up, I'm afraid. Just one more minute, all right? One more minute. Non-binary persons who formally have a different gender, there are neither a woman nor a man. What about the entitlement to social insurance in the situations when there are different conditions for men and women? If someone is not a woman, but they are not a man either, if they apply for old age pension, what is the pension or retirement age? What is the minimum period for premiums, 20 or 25 years? If there is no gender assignment, or if it is this third gender called the diver. So these are theoretical problems, but they will become practical problems at a certain point, and they have to be analyzed, they have to be regulated by the law, and definitely it is a pity that the law, which is supposed to regulate that in 2015, was vetoed by President Duda. and these problems are still not solved. And summary, we've mentioned several issues connected with the topic of our presentation. Obviously, it is a highly comprehensive topic, and we've mentioned just certain bullet points. And this topic would require a more in-depth analysis, more comprehensive analysis, taking into account legal and comparative approach, because it is very interesting to see how these problems are solved in other countries. On the basis of what we can see so far, the labor law, social insurance law, doesn't focus on transgender, non-binary persons. What is regulated is just gender correction procedure and consequences. So when we think about dignity of people, including transgender people, non-binary people, these issues have to be clearly regulated so that these persons have to be aware what is their legal status, what is their legal situation, so that they don't have to fight for their rights in very complicated and often humiliating procedures in front of the court. I guess we have to emphasize this topic. These issues have to be simply regulated. Thank you very much for your attention. Thank you for your presentation. I am a bit sad that I have to rush you, and I asked you to wrap it up because it was a highly interesting presentation and there were 2 speakers, but unfortunately we have to give the floor to other speakers. There are plenty of speakers in this session, so I'm very much looking forward to post-conference publication from you if you are going to do that. Now the floor goes to Barbara Godlewska-Bujok, and she's going to talk about the private life of an employee and employment relationship as a dynamic relationship. Thank you very much indeed.
Dziękuję pani profesor. Na początek chciałabym podziękować.
Hello and good afternoon. Thank you very much for inviting me to the conference and for accepting my presentation. And I think that what is written in the program is not entirely true. I do not represent the University of Wrocław. I do represent the University of Warsaw. I love Warsaw. Warsaw is great. People in Warsaw are great. In Wrocław are great. I like Wrocław as such. But I'm based in Warsaw. My family life is based in Warsaw. So that's how it is. And let me just refer to the previous presentation. Well, I think it's a great starting point for my presentation. And this is something that I do appreciate in, I think, all aspects of my life of a researcher. When Dr. Jaworska said, work changes, the world is being transformed, and that's the only certainty that we have. And in my opinion, that largely determines our approach to labor law and our perception of work, or our expected perception of work. And some time ago, remote work was the hot topic, and we believed that that was a humbug, that no one actually heard about that some perceived that as a benefit, and then all of a sudden it just arrived, it just came to life and have become less of an award or a prize, but more of a burden. I believe you've heard from, must have heard from so many people that they wanted to go back to the office, they wanted to go back to regular work, and it happened this way because professional life entered our private life. So let me start with the private life. So in the literature, we do not have one uniform position on our definition of a private life. Typically, family life is a part of a private life of an employee, although some believe, and that view was expressed by Panaszek, that well, some people may have private life without family life, so it is not a certainty. So I think that the right not to have family is also a part of private life or personal life. So I think that family life is a part of a private life of an employee. And now speaking about the context of employee-employer, because we'll be talking about employment relations, we'll be talking about type of work that we do, and that could be employer, that could be the principal, that could be the mandator, but still we have that independent relationship with certain context and end, and when it comes to the end, that end may have a may look differently depending on the context. So it's worthwhile to note that even when one's personal life, that some consider public, is happening, well, it's difficult to look at it only from the point of view of public life, because it is going to be like that to some extent, but not entirely. So we have the threshold set out by the social and economic policy of the state. Note that very often these regulations go beyond the scope of the public sphere, of the professional aspects here. They go into the context of an employer and employee. We have some standards here which to some extent have an impact on the family and shape and develop the family life. So private life, that is information about the health status, asset status, family, family or lack of it, pets, activity of family members. But bear in mind that privacy is a structure whose scope is going to be changed depending on whether an employee has a relationship with the employer, whether the employee enters the public zone, or whether that part is negotiable. So social life as a part of, and in the context of private life, is a very broad concept. It would be difficult to define the borders of that here. And actually we may claim that the family life, these are relationships between members of family members and siblings, and then the family life can be considered in the context of mutual dependencies and the degree of that dependence in a daily life. And here Professor Kowalczyk also mentioned that he spoke with his colleagues about competition. We've learned we've learned a bit more about relations. We've learned that that context sets out the type of relation, and we have this community or social group-like relation. So as Mecenas Hołowska was saying, we heard about, well, she spoke about loyalty, the principles of loyalty. We no longer have it in our labor code. But here we had that concept of joint, of a community, of being, of having that relationship. And here we have that context of transactional relations. So we no longer have this mutual relations, which is based on a relationship or subordination, and we are more, and becomes more of a transactional relation. We may disagree, and we may claim that work is not a commodity, etc., as in the Philadelphia Declaration. But that is happening overnight. That is happening faster than we ever wish to. And then we have that, well, we have family members, the relations, family secrets, family celebrations, family life. And then family life is very often perceived in the context of good, protected under the Constitution, in particular Article 47. So that is, family life is part of this private life. So actually one could demand effective protection of values according to regulations, in particular Article 47. So that would be interesting and worth consideration. And perhaps to sum up this part, I don't want to initiate a debate about definitions, but I'm trying to say that we cannot precisely determine a catalog of persons who create and form the family relations. So this catalog is unspecified. So now about the labor code and how that works. So we've said, we talked about it, Dr. Jaworska and Dr. Przywiłowicz talked about it, because they pointed out to that feature which may suggest a different situation of a worker or an employee in a different time perspective. What I'm trying to say is that nothing's certain, and if we look at the job relation dynamics, we can see that that dynamics is going to change with the change of time work. With the change of working hours, change of views and concepts on life in connection with someone, a person being a parent of own or adopted child. And then age of an employee changes. And here actually, when looking at the provisions regarding discrimination, the employee will be changing their positions slightly. So that is going to change slightly because the protection will be different here again. And here again, we're talking about anti-discrimination regulations or but you know very well that it doesn't happen this way. So work has both a sex and body. And body doesn't change. The body goes through a variety of transformations. So it's not about physical work, but it's about mental work, about intellectual work, and it's about independent style of work. So the work relation, it doesn't remain the same. So we have this threshold beyond which private life starts. And we need to define what are the standards, what is the borderline here that sets out the border for private life. So parental rights. So we have the entire section that prescribes what is and what isn't allowed. Then we have vacations. But then if we have this critical look at the provisions of related to obligations of an employer, like obligations to participate in training, etc. Note that in all cases we have that reference to all these notions from private and personal life. So that refers to so many elements of private and personal life directly and indirectly. So that sets out the borderline here. Then the final part of my presentation is that because a human being changes, perhaps that is not easily acceptable. So note that all the parental rights and the other rights or anti-discriminatory regulations, they largely apply to body and or concerned body. So we cannot look at it from the aesthetic perspective. So we're looking at things from a very static point of view, without that dynamics.
I też z tego, że po prostu wszystko płynie, tak już sam.
And that comes also from the fact that panta rei, everything flows. So things change all the time, and we cannot look at it from a static point of view. So employment relation, also with the references to the labor code, etc., cannot be considered complete. There is always this risk that the assumed goals of that relationship cannot be achieved. So we never know what can happen So considering our judicial education, we can understand employment relation as the basis for this dynamic relation. We're talking about uncertain consequences of because services change, qualification changes, etc. So we have that incomplete nature, uncertainty, etc. I think that that is about conclusion of a contract on a work relation, and we cannot predict how this work relation is going to look like. This work relation is more a set or a collection of variables, and its content will be changing. So as I said, our sex may change, our health may change. We may become parents, we can have or adopt a child, and we get older. From the date of our birth we get older, and with that we can also recognize that negotiational imbalance of parties. And in my opinion, that is decisive for agreeing conditions of work.
Znaczy może nie zależy, ta nierównowwaga strony jest zbudowana też na dużej asymetrii informacyjnej, tak, pracodawcy, pracownika. No ale też jest zbudowana na...
It's also constructed or built on the imbalance of resources and services, or reduction of resources and services. Please, so it seems to me that in the context of that dynamics, we need to look at that. It's difficult to set out that precise border of between private and family life, and employers may not be willing to separate these two spheres.
Thank you very much. I do apologize, but I think that I didn't shorten your presentation. I found it difficult to cut in because it was very interesting, but unfortunately we have very strict time limits. So now over to our next speaker. It is Professor Biljana Todorova, and she is our online speaker, connecting with us from the Republic of North Macedonia. Professor, are you here? Can you see us? Can you hear us, Professor?
Yes, hi, I'm here just to start the video too. Hi to everyone. Sorry, I can hear you.
Everything is fine. So Professor Todorova is going to talk about extending social security on non-standard employment.
Can you see my presentation? Sorry, I can't hear you. I hope that you can hear me.
No, we can't see your presentation. Yes, we can hear you, but we can't see your presentation yet.
Okay, I just want to do PowerPoint slides. So thank you for the word. I'm going to talk about the topic extending social security on non-standard employment. Just to go to the next slide. The evaluation of non-standard forms of work in North Macedonia can be analyzed through the development of North Macedonian's labor legislation. In this regard, the labor legislation of North Macedonia is marked by two periods. The period from the adoption of the first law on labor relation of 1993 until the adoption of the second law on labor relation of 2005. and the period from the adoption of the second law on labor relation of 2005 until today. The adoption of the law on labor relation of 2005, which is still in force despite numerous amendments, came about because of the realization of two basic goals: the harmonization of the North Macedonian's labor legislation with the EU Acquis Communitaire, and the continuation and depending of a trend to lose an employment relationship, particularly in relation to flexibility in firing and hiring. I'm going to talk about the significant growth of non-standard forms of employment in the Republic of North Macedonia, and what are the social security challenges of non-standard employment. The aim of my paper is to review the entitlement of those in non-standard employment, in particular those working part-time, those on temporary contracts, and the self-employed, to social benefits of different kinds in the Republic of North Macedonia. The analysis focuses on entitlement to four types of benefits: unemployed benefits, sickness benefits, maternity benefits, and pensions. The achievement of the second goal that I mentioned before, of increasing flexibilization, initially meant drastic reduction of employees' rights in the field of legal protection against dismissal. In parallel with the firing flexibility, the labor legislation has also started a process of gradual flexibilization of existing non-standard forms of work, starting from the ILO typology for classification of non-standard forms of employment. The following forms can be found in the current labor legislation of North Macedonia. In the group of temporary employment, fixed-term employment contracts, and seasonal work. In the group of part-time and on-call work, part-time employment contracts, additional work, multiply part-time employment contracts, and in the group of multi-party employment relationship, temporary agency employment contracts. In addition to the aforementioned non-standard forms of work, Macedonian labor legislation regulates the following forms: home working employment contracts, employment contracts for domestic workers, and employment contracts for managerial persons, managerial contracts. However, the existing list of non-standard forms of work in North Macedonia has room for extension and further regulation. Above all, there is a need to regulate casual work, as this can contribute to reducing informal employment in the country and will facilitate access to social security for this category of workers. As I said, with the adoption of the new law on labor relation in the Republic of North Macedonia, there has been increase in forms of employment that provide more flexibility to employers. This has been associated with the growth of part-time working in particular, but also with increasing job insecurity for workers, which has given added importance to the safety net that a comprehensive and well-functioning social protection system can provide. The forms of employment that have expanded over this period, however, do not necessarily give entitlement to social benefits in the same way as more standard forms. The widespread increase in non-standard employment gives added importance to the question of how far the workers concerned are protected by the social security system if they are unable to work. Workers on a temporary contract and those in a part-time jobs are more likely to have career interruptions, lower lifetime earnings, and a shorter employment records than standard workers, and therefore to be entitled to a lower, for example, pensions. In our country, these workers are also those who work in dangerous working conditions, rarely receive social benefits, barely have the right to unionization, and have limited job control and regulatory protection. Most of the workers in non-standard employment are precarious because they are often dependent on one or few clients and have no entitlement to minimum wage, overtime and holiday pay, and they don't have social insurance or SSA or other type of social security. Given the data available, however, it is not possible to identify with any precision the numbers who are unable to meet the requirements for eligibility at the present time. However, it is possible to identify those at risk of not qualifying for benefits because of their job or employment type, because, for example, they have a short fixed-term contract or are working very short hours, which may mean that are unable to meet the conditions for eligibility. This may not be the case in reality for some of those concerned, or even many of them, but the risk tends to be much greater than for those in standard employment, who, for the most part, are more likely to have an employment record, giving them entitlement to benefits. The aim, therefore, is to estimate the relative number of people in employment who are particularly vulnerable to not being covered by the social security system, or more precisely, have more limited or less favorable access to benefits than those in standard contracts of employment. Workers with non-standard employment contracts, temporary, seasonal, part-time, etc., are more precarious compared to those with permanent working arrangement. I already said that. Nevertheless, part-time workers or seasonal workers or domestic workers are less paid and have no access to collective bargaining. Hence, they are more precarious compared to full-time employees. Also, they are more likely to end up with a lower pension than standard one because of relatively long contribution requirements, minimum of 15 years. Also, income support of unemployed people, it is unemployment insurance, which is contributory and usually financed through earnings-related social contribution, levied on employers and employees. Qualification depends on the payment of a sufficient number of years of contributions. According to the North Macedonian law on employment and insurance in case of unemployment, benefits are flat rate. For workers in non-standard employment, this benefit is hard to claim because of its long period of contribution. Also, young people, age fewer than 20, are most exposed to the risk of not being entitled to unemployment benefits because they usually work in short-term temporary jobs and usually do not have the required length of service. The lawmakers, therefore, the lawmakers need to find a specific solution for this category of workers so that they also can have access to these social benefits. I will also refer to domestic workers. If a worker performs the job at the employer's house, domestic work, it is less likely that he or she has a written contract, access to social protection, healthcare, and collective bargaining. Most of them are informal workers, meaning they lack social protection and the right to unemployment benefits that further deteriorated their livelihoods. There is one other group that almost certainly is not covered with social insurance. These are family workers who do not receive a wage or salary as such, but are employed in small family businesses. These are unpaid family, that is unpaid family work. It is kind of labor that supports production for sales. It's not remunerated, but the compensation may be felt through the family income, fringe benefits, and let's say payment in kind. Unpaid family workers are usually members of producers' cooperatives or contributing family members. More than 43,000 workers in North Macedonia have been unpaid family workers in 2009. They are usually agricultural workers who perform their job at a farm or on an agricultural. Regarding the employment type of unpaid family workers, 92.5% are informal, suggesting that they have had no employment contract or that work in unregistered businesses. Hence, they did not have access to the available social insurance. Therefore, these workers are also in need of protection equivalent to the given to that given to the other workers. Given this situation, our country should extend the social benefits to workers in non-status employment, either by making them eligible or by enabling a short entry period, less than 6 months, or minimum, for example, 6 months, but in less 12 or 18 months, so the benefits can be received. Yet again, this measure generally is applied to workers in formal employment only. To protect informal workers, the country should extend social protection coverage. The informal workers in North Macedonia, like the law in many EU countries, should also become eligible for the guaranteed minimum assistance and the one-time cash transfer. However, there are no available data on the number of those workers along the deadline introducing
Dorova, I'm afraid your presentation has to finish now. The moderator is asking once again Professor Todorova to finish because there will be no time for other speakers.
Okay, I will go right to the conclusions.
There is no time for conclusions because moderator has asked repeatedly to finish this presentation because there are 3 more speakers who have to take the floor and they have to finish by 6 o'clock. So I do apologize. There is no time for conclusions. I do apologize for that. I have to be very strict. You have to finish now. Sorry.
Bardzo przepraszam Państwa, no niestety mamy panel, w którym mamy...
I sincerely apologize. We have 6 members, participants of this panel, 6 speakers, and we do not afford so much time for everyone as they need, as much time for everyone as they need. So the next speaker is Paweł Antoszak, and he will talk about the salaries of employees in sections of the national economy in the Subcarpathian regions. I would be very grateful if you could afford 12 minutes for that.
Postaramy się zdążyć.
Dziękuję.
To be brief.
Czekam za swoją prezentację, mogę ten. I tak, ja reprezentuję Uniwersytet Kazimierza Wielkiego w Bydgoszczy.
I come from Bydgoszcz, from Kazimierz the Great University. And I'll be talking about salaries of employees in sections of the national economy in the Subcarpathian region. So my presentation is starts with presentation of the Constitution on salaries, on wages. I'm a doctor. I have PhD economic sciences, so I'm not a lawyer per se. I believe that and trust and Constitution is holy, and there is Article 33 that states that men and women, they enjoy equal rights of employment, social security, occupying jobs, and to receive medals, etc. In the Labor Code, Article 18, 3C, paragraph 1, it is provided that employees have the right to equal pay for equal identical work or for work of identical value. And then paragraph 2 says that the salary mentioned in Article 1 covers all the components of salary, irrespective of their name and type, as well as other benefits and performances. And number 3, works of equal value are works whose performance requires comparable vocational and professional skills, qualifications, as well as comparable responsibility and effort. And actually, I will not be reading all these paragraphs from the Labor Code, which are related to labor, to speed things up, but also Article 78 states that identical qualifications are required and to provide the same type of work. In Article 80 states that wage should be paid for work performed, and for non-performed work an employee reserves the right to pay. And then in Article 81 of the Labor Code, it is stated that salaries and wages should be paid even if an employee reported for work and through the fault of an employer did not perform the work, that worker is entitled to pay for work. In Article 82, paragraph 1, for faulty performance through the fault of employer products or services, no wage should be paid. If through the faulty performance of work through the fault of an employee, the quality of a product was suffered, then the employee has no right to pay. And then we have information about the quality and effectiveness of work.
I teraz tutaj, Szanowni Państwo, właśnie na tym chciałbym się może trochę skupić.
And here I would like to focus on the presentation of average monthly salary in the Subcarpathian region. These are up-to-date salary details from the statistical information. So it's about, but in 2010 the salary was 2007 and it went up to 4,100. And then if we look at the financial and insurance activity as well as information communication, we have salaries which are twice as high as they used to be. So let me show it here. So that's the information in total, so that's the blue line. And then we have information and communication. So it's 6,700, and I've selected the top amounts and the salaries which or wages which are much below the average. So the disproportions are, well, public administration and national defense, which is much above the average pay in Poland, as well as insurance activity. So actually, this is what this trend prevails in all regions. So financial activity, information, communication, these are sections, types of business that require education and skills, but look below, trade, car repair, etc. And then we have administration and supporting activity. And then we have accommodation and catering. Well, education is important, but then we have the scope of responsibility. So a responsibility of a person who manages finances is different than the responsibility of a person who is a regular service provider. So it's about education. It's about the scope of responsibility. Recently, a colleague of mine said that education is not important at all. So I asked him, would you like to be treated by an uneducated doctor, perhaps?
Także to akurat jest zakres odpowiedzialności, jaki jest i wykształcenia. Najpierw wykształcenie. Wspaniale powiedział na inauguracji nasz dyrektor, że każdy czas ma
education, and our director had this great speech saying that there is time in life for everything. There is time for excellent, for extra work, there is time for education, there is time for other activities in life. But when one works for one's PhD and one is 25 or so, that is a very dangerous period from the point of view of human resource management. Many women start families when they're about 25, 26, and it's difficult to have their PhDs. Well, I'll try not to dwell on that too much. Well, I see that in Poland this trend has changed and families are started later in Poland. Okay. Deviations from the average monthly salary. These are statistical methods. And we've calculated that.
Ja już tak pani profesor mówiła, że mam się zdążyć w czasie i teraz sam się spieszę.
So I've calculated that,
nie będę
and I'll try to be
cytował tych całych wartości, tylko pokażę po prostu
I won't be quoting all the information, but I will just show you on a graph. So everything which is below zero, well, you can see it right here, and there are some discrepancies. So the discrepancy would be nearly 2.5. As I was saying about information and communication, and here when we have, well, for trade, accommodation, it's 1,400 less than that. So we have these discrepancies, and we can see the differences when compared to the mean salary. So the growth rate of the mean monthly salary in this subcarpathian region. In recent years, this growth ranges between 103 and 107. And when I was working on my study in late 1990s, early 2000, so this growth was similarly fast. So salaries are growing by 2-4% per year. So this growth is not substantial. So we have 112, 110, 108. So that growth is growing slower every year. So I think that is affected by the inflation, by the economic growth, etc. So let me move on to the summary. So salaries are and their amounts are largely justified and grounded in the autonomous functioning of the market. Salaries are dependent on the situation in the economy and the level of competition of enterprises. Undoubtedly, one of the key factors deciding about salaries was the level of employment and the size of a company, and the general trend was in the subcarpathian region that it has concentrated non-agricultural business, and this is a seat or the seat of many bodies of the state administration, and the level of salaries here is quite high, and here salaries were different depending on the sector. It was the professional knowledge, expertise, education, and the scope of duties that counted, and pays in different sections in the region were markedly different. I thank you so much for your attention.
Panie doktorze, bardzo serdecznie.
Doctor, thank you so much for this incredible time discipline. It is highly appreciated, and this way we may have a bit of time for our last speakers, and these are Marta Groszkiewicz, from PhD candidate from the University of Warsaw, and she will tell us about the status of young worker. Marta Groszkiewicz, I regret to tell you that you have 12 minutes only.
Good evening. I am Marta Goroszkiewicz, just a small mistake with my surname. It happens so often, perhaps it is not a very typical name. So let me just say something more about young workers. And I will tell you a bit more about craft. Well, 12 minutes is not much, but I was trying to adjust my presentation. I had to adjust my presentation. Perhaps I will start from conclusions, actually, because the legal status of a young worker is not a huge legal challenge, because as for bigger surprises, so to say, well, there are no bigger surprises. Actually, everything is included in the labor code, but obviously there are some complications, but I deal with craft from managerial point of view. I'm a graduate of PhD studies in the Faculty of Management, and I have to say that I had a year of studies, conversations, insights in the environments, which is quite impressive, the environment of craftsmen who are there, who exist, who still are alive, very active, like people repairing shoes. And sometimes when I talk about craft, people ask, oh, are there any craftsmen? Yes, of course there are. They live very well, and craft has to be a model for two areas of contemporary world which are getting more and more important, like SMEs management, because crafts unknowingly came up with various strategies of people management, and sometimes they are not even aware of that. It is sometimes regulated in the law, but sometimes it is not, but it works perfectly. It's been working for 800 years, 850 years in Poland. So I would like to show to you all these impressive achievements and this intersection of the Magdeburg law. For a moment you could see my dog, so a glimpse of my personal life. So Magdeburg law, the 13th century, the origins of the German-based law in Poland connected with crafts. So all these issues that we have in Poland And then we have to some issues in Poland with adjustment of various professions to the market, vocational education, and actually craftspeople, handicraft, have patterns for that, have solutions for that, and they have had it for the last 800 years at least. So I'm not going to present all the slides I have prepared, but I just wanted to emphasize that when we take into account the current management of your personnel, HR management, which has the following challenges. Because, well, I was taking notes while listening to previous speakers. I was listening to Dr. Godlewska-Bujok, private personnel and professional. For craftsmen, well, these lines are blurred. If there is an apprentice, he or she begins to become part of the family of the master. I talked to many craftspeople. They emphasize that a person of 15, a person of 16, maybe an apprentice from pathological family, and a craftsman, experienced craftsman, is always becoming the educator, sometimes becomes a parental figure. So craftsmen are the only employers who need to have additional skills like pedagogical skills. And it is also regulated in the law. It has a lot of impact on people management. If you look at the dictionary of management, I was discovering various things step by step. I had many conversations with craftspeople. I read legal regulations. I participated in meetings of guilds, in conferences of craftspeople. I looked at various efforts of the director of vocational schools. There are schools also established by crafts guilds. These are schools especially addressed for a specific sector of craftsmen. So diversity management, it is now very fashionable. Diversity management. Craftsmanship always knew how to do that because they always had apprentices, pupils. So they had to manage diversity. It is now continued. It is different to manage adults, and it is different to manage young people or minors or people of 15 or 16 years of age. Security issues are very important, even more important than in the case of adults. Mentoring, intermentoring, intergenerational mentoring. Again, 800 years of traditions in crafts. Because apprentice master, well, it is a special relation. It is a life mentoring, real, true. It is not artificial, worked out within organization. No, it's been in place for centuries. Now there is a very interesting trend, like inter-mentoring. Masters say that without apprentices they cannot function because they do not know state-of-the-art technologies, and young pupils know them very well. So there is like mentoring, but going in the other direction. So it is especially important in remote work. And then CSR. CSR, which is corporate social responsibility. It is precisely what craft has been doing for hundreds of years. It helps the state to educate qualified personnel for the economy, for the domestic economy, for regional economy, for local economy. So we have challenges connected with these particular issues. Well, there is Copenhagen Declaration, and there is this governmental pillar which is focused on vocational education, inclusion of regions, more local Poland, more regional Poland into various activities. It is a real CSR. Again, it is not artificially created within a company. For craftspeople, it is nothing to boast of. It is simply part of their DNA. It is organic CSR. And then strategies of management. Well, it is different to have medium period of education of a pupil in a workshop. Well, when I ask craftspeople why do they employ pupils. Why do they want to do that? Why do they want to educate young people and bring up young people? They don't have to do that. 8,000 Polish zlotys that they received after 3 years of education and after passing the exam by the pupil, well, it is not any compensation if it is the total of 8,000 Polish zlotys and they have to spend 3 years of their free time very often. So it is not enough to motivate them. They need to have additional motivation. When I ask, why do you do that? They say, we want to develop my company. I want to develop my company. I want to model a pupil to adjust this person to the requirements so they can shape them like plasticine. They can shape the young person. Everything happens within the labor law. Everything happens within the educational law. So a craftsperson needs to be a lawyer to some extent, needs to be more versatile than an employer managing adults. Then, when we talk about benchmarking, craftsmen, do they go into benchmarking? Well, perhaps I should move on to the conclusions, to the end of my presentation, because you can see a medal for educating apprentices in a given sector of crafts. So this medal is given to special craftsmen. It is awarded by the Guild of the Polish Crafts. It is all Polish organization which brings together craftsmen. Employers, craftsmen boast of that. In all the workshops that I visited, I could see such medals, and if I could see them, they boast about that. They compete because they want to have more and more, because the highest award is the platinum medal. Centers of shared services. It would seem it was invented by corporations in the 20th century, 21st century, but the Guild of Polish Crafts is organizing something very similar. It brings together crafts chambers and crafts associations, and it provides a kind of support. It is a kind of a center of shared services for individual craftsmen employing young workers. You can see their tasks, their duties. It is about educating, passing on information. It is about cooperation with local governments, organizing additional training sessions, theoretical education. So all these things are interconnected so that the young apprentice can be shaped, can be educated, can be led up to the exam. After passing the exam, they will become a person which has certain competences, and they will become a journeyman. I do apologize, but I will have to ask you to finish because our time is really limited. All right, I see your point. I could talk about it for hours. Yes, so we are talking about young workers, and this young person of 16 or 17 is actually a worker. They have some rights, they have some fixed working hours or limited working hours. Let me just say that we have to remember about craftsmen. It has been part of our tradition, and it is a very much alive tradition. We don't need to support it, especially it's simply there. We don't really learn from history, in my view, but one of creators of management wrote that historical development, historical phenomena are very important for managers of the 20th century. We tend to think that management in the 21st century is something new. No, we have to remind people of craftsmen, of various solutions. As Dr. Godlewska has said, that the only certain thing in the labor law is a change. Paradoxically, in the labor law there is crafts, which hasn't changed for hundreds of years, and yet it fully meets all the requirements of the 21st century and fulfills its role in a perfect way and tries to fill in the gap with adjusting educational requirements to the requirements of the labor market. Thank you, that's all from me. Thank you very much indeed. It was a very interesting presentation. I have to admit that craftsman issues are very close to my heart because I'm very much interested in that personally. It is amazing because more and more often I can see that adults decide to fulfill their dreams from childhood and they do something atypical. If it wasn't for crafts, we wouldn't have such a possibility for many pupils, for many young children, young people from pathological families. It is the only way for them to develop their professional skills and have a regular, decent job in adult life. All right, so now it's time for PhD candidate Michał Skóra from the University of Rzeszów, and he will deliver his presentation. It will be the last presentation in our panel. It will be about new forms of employment, reflections on employment of people with disabilities. I have to say, from organizational point of view, that organizers have to finish the conference at 6 o'clock sharp, so I would be very grateful if you are very disciplined in terms of the time of your presentation. Okay, I will try to do my best.
Professor, I'm speaking as the last speaker. I think we're all tired with these two very intensive days and our panels. As you said, Professor, my presentation will focus on new forms of employment, reflection on employment of people with disabilities. I should start with certain reflection when speaking about the need to change the definition of a disabled person, to have the shift from and in the light of the UN Convention on Needs of the Disabled. And I wanted to talk about the strategy that one should adopt for the disabled. Our government has adopted it this year, and one of the key objectives of the strategy is to ensure that the disabled can exercise their right to work. And that right stems from the Constitution, that stems from the content of the UN Convention and other pieces of legislation. And that convention refers to employment of persons with disabilities on the open labor market. And the governmental strategy on which I spoke implies introduction of certain new instruments which have the task to support professional activation of the disabled. And that would involve development of the national program for the employment and recruitment of the disabled. So here the disabled should be employed as employees on the basis of a work contract, and it is interesting that the program will contain certain solutions supporting employment of persons with disabilities that would work at the seat of the employer. And then persons working on the strategy, they acted with the spirit of the times and included the aspect of remote work. And particular pressure will be put on preparing employers. So that would involve preparation of the employer and the team, so they will receive the disabled person. And I believe that that is an innovation. Experience shows that employers tend to fear employing persons with disabilities. So I think that strategy will be a good stimulator. It's going to contain certain standards based on the UN Convention. So it's about sign language translator. It's about translator and guide of persons with hearing and visual impairment. I think it is not a bad idea to emphasize flexibility of employment in the context of people with disabilities. The strategy foresees that a new institution should be introduced, which is a temporary or interim employment institution. So that is about sharing one full-time job by several employees. That comes as an innovation, and that is particularly important in case of employees with disabilities who suffer from certain mental conditions. And then concluding, as the result of testing and analyzing business and economic activity of population, the research showed that that indicator for the disabled was at about 29%. And the strategy adopted government is spread over the period of 9 years, and it is to increase the professional activation up to about 40%, which is a major change. And my last comment goes to the change in the proportions. So far, persons with disabilities, they were employed on the protected market, in protected or especially designated workplaces. But here, according to the information from the Fund on the Rehabilitation of the Disabled since 2019, we observe a clear increase of employment of the disabled when compared to the size or volume of employment on the protected market, which is an important and significant trend. Thank you. I thank you, Mr. Skóra, again for this incredible time discipline. It's 5:53. Do we have any questions? Do we have any comments? Do we have any urgent question from you to the participants of the panel? So do you need to answer this question without waiting for conference materials, etc.?
Z sali słyszę, że nie bardzo.
Read from the floor that there are no questions. I don't see. There is one question.
Dziękuję. Ja mam pytanie do organizatora.
I have this question to the organizer, Michał Skóra.
A mianowicie, czy w tej nowej strategii
how about this new strategy?
przewidziane
Does the new strategy contain any provisions for differentiation of instruments?
dobrodziejstw, na przykład pracy zdalnej?
So, for example, remote work. Depending on the type of disability, whether it's a disability since childhood or disability that dating back to mature age.
Pozwalające na taki proces inkluzywności do społeczeństwa, dlatego że zupełnie inny wymiar ma praca dla osoby
It's a very different
i wtedy taka
to
praca
work.
zdalna to jest, uwierzcie mi Państwo, zabójstwo.
To work remotely
ponieważ ona po prostu musi wyjść ze swojego
cannot
środowiska, musi wyjść z domu
really
i zupełnie
feel
inne
like it,
znaczenie ma
and
praca dla
when
takiej
they
osoby,
have been
inaczej to
disabled all
wygląda
their life.
w przypadku osób, które mają już zbudowane
And it is very different in case of persons who have already built some relations.
Świadczyć, bo stały się niepełnosprawne później. To jest, proszę Państwa, niezwykle istotne.
So that is quite
projektujący
crucial.
tego nie zauważa, to jest ogromny mankament.
And that should be also observed, well noticed and appreciated by employers.
Do którego naprawdę wyjątkowo holistycznie.
A disabled employee and an employee with incapacities is an employee that deserves very special treatment. Well, I'm sorry to say that it doesn't work like that. Will remote work or telework, as we say, this is an element, an instrument which is to activate people professionally on the open labor market. And let me stop at that. Ladies and gentlemen, yesterday, on the basis of abstracts and topics of your presentation, that we will be having multifaceted presentations. I will thank you very much for your time and engagement and presence and contributions. Conferences, they make sense when they're the arena of meetings, scientific observations and thoughts, and you are all among organizers of the conference. It was a great pleasure to have you with us here today in Rzeszów, and I thank you.